very sort of epic countdown, mostly just for the YouTube padding, because otherwise you hit start and the video starts like midway through a sentence. So hello everyone in the chat. Welcome to Runkle of the Bailey, and welcome as well Andrea Burkhart, who is at she's got a channel at, do you have the URL handy? It's Andrea Burkhart, right?
Yeah, Burkhart Law.
Yes. So I'm just like, why am I blanking on stupid things? It's been a day. It's been a week, actually.
It has.
And I was like, I could really use like just a quiet week. And then we get sort of the double impact of A, my government's gone crazy, but B, we get these filings, and these filings are something else.
They're a lot. They're very extra.
Yeah, I'm just kind of like, I've read a lot of briefs because I do appellate work, but I'm also just interested in appellate law, right? So I am the giant nerd who goes and reads the Supreme Court decision, but then also reads the briefs to see what's how are they going on? And I mean, I was lucky enough to go to the Supreme Court. I will tell you that in prep for that, I read so many briefs, so many, because I was just like, I don't know what I'm doing, right? So I was kind of thinking I better figure out what that looks like before I actually submit one, which might have been a good step for these people.
just a thought. Maybe look at an amicus brief, like in any amicus brief might be helpful.
Call some, I mean, my experience with the legal community is when you call people, they, like typically most lawyers are willing to help, right? Mm-hmm. I've had lawyers have called out of nowhere and been like, hey, you argued this case. Can you tell me a bit of the backstory? And they're like, oh yeah, let's, talk about the procedural history. And, I'm sure that some of them could have said like, hey, this is stuff that belongs in an amicus brief, and this is stuff that is just crazy yammering that you should maybe leave out.
Well, I think, yes, if your premise is that this was actually an exercise in legal work, then yes, that would have been a thing to do. But as I think we'll see as we get into the briefs, there are plenty of reasons to question that premise. And
that was kind of my thought. And I said this during the trial, that there's basically two trials going on. One is, the case of Depp v. Heard, in Virginia court, which is, being held in a court of law and follows the ordinary rules. And the other is just the public relations battle that is around that. And this seems like it's a filing in the public relations battle rather than something, I have some thoughts on how I'd respond to this if I was the court.
Yeah. Well, I was going to say, Ian, it does not happen almost ever that amicus briefs are rejected by the court, that they don't grant leave to file them. This is the rare situation where I think it's possible. And I'm sure we'll get into why. But it would not surprise me to see that happen.
And I mean, I think it's kind of interesting because where I am, you have to apply for leave before you file your brief. Mm-hmm. Virginia rules seem to be different, that you file the motion for leave with the brief so that they get to look at it. And at that point, mm-hmm. they already have the brief. But, where I am, the court will quite frequently refuse an amicus filing because they'll say, listen, you're just too associated with one of the parties. Mm-hmm. And, the Supreme Court just refuse, when they grant or refuse an amicus brief, they do so without reasons. Mm-hmm. That's their tradition, is to just say, in keeping with our tradition, leave is refused, no reasons. Mm-hmm. But it's weird that we get the whole brief before we know if the court's going to take it. But I guess let's dive in. We've got a whole brief here, and there's so much to talk about.
Oh, and we're going to spend a long time just on page 3.
Oh, so which one do you want to look at first? We've got So we've got this one with the giant long list of the style of cause. I know that they've been sort of numbered as 1 and 2, but I don't know which one is which.
Yeah.
So we've got, and then we've got this other one that I found was kind of interesting because they say that the people who are the signatories of it are in Appendix A. Whoops. And I actually need to hit the allow button to bring this up on the screen. There we go. So we've got the one that's got Urban and Sarabia is one of them, and the other one is this one here filed by this. But this other one I thought was weird because it says it's in Appendix A. I couldn't find Appendix A anywhere online.
Yeah, the appendices are not attached to it. That didn't get released. You know, one of the things we should point out too, because I have seen some comments or questions about this, the fact that these briefs are not file stamped, and that is correct. These are not, as far as I know, formal official court documents. They weren't obtained from the court. They were, I got them off of Twitter from somebody who got them from somebody. So it is entirely possible that, these are some elaborate hoax. Of course, you can never rule out a hoax with the people that we're talking about here. But having said that, these do very much look like what we would expect, the amicus briefs to look like. So I don't really think that's the case. But that is an important disclaimer, I think, that, we didn't get this from the court. So there's no guarantee that this is the final draft, that this is what actually made it to the court. So just bear that in mind.
Yeah, we don't know if this is actually what the court got. I mean, it very likely the most reasonable conclusion is that this was leaked by one of the parties or by the filers themselves. That said,
and we certainly saw on social media that plenty of people were just ready to tee off, on the brief as soon as it was out in the public domain. So there is definitely a hint of coordination to that.
Well, and just for people who haven't ever dealt with sort of news media, one thing that happens, a lot of the articles that you read were actually written by PR firms. So the various, sort of journalism organizations will just take an article from a PR firm and then run it. When we see these articles that were ready to go as soon as these briefs landed, I kind of wonder if some of them might have been PR firm authored. And I mean, I think personally that journalists, like that any reputable media organization should list when they do that. Of course, they'll never list when things are ghostwritten because at that point, if you're just like, oh, this was ghostwritten by Amber Heard's PR team, nobody would take that seriously. So yeah, it is weird that they would leak the brief, but not the list of people supporting it. And yeah, I mean, we just don't have the leaked, we don't have a filed copy, and that, but I mean, the hoax aspect seems like, because if these weren't authored by I looked up the lawyers on this, and they appear to be like actual lawyers, really expensive actual lawyers. And quite frankly, if somebody put out a fake brief on something as politically contentious as this, and it wasn't me, but they put my name on it, I would be going absolutely nuclear.
Oh, yeah.
I'd be looking at defamation. I'd be looking at appropriation of personality. I'd be filing law society complaints if it was a lawyer involved. I'd be just... So I don't think anyone's dumb enough to do that. I hope.
Yeah. No, it does seem very unlikely. I think the plausible explanation is just exactly what you've suggested, that, they just had this all teed off. This is never intended to be a legitimate legal exercise. It's entirely for the court of a public opinion, which is, quite frankly, one of the things that, should the Court of Appeals get a whiff of that, is not going to really sit well with them as supporting them accepting and entertaining these arguments.
Oh, for sure. Now, which one did you want to start with? Because we've got this one with the mystery people, and we've got this one with the list. Which one's your sort of preference? Because I'm
So
good with
this one with
whichever.
the list is the one that I have looked into much more detail at this point. I'm actually going to be releasing my own video tomorrow morning where that's just specifically focusing on this brief. So I haven't gone into quite the detail on the other one, but I am certainly happy to talk about either.
So yeah, let's start with this one. And guys, check out that video because Andrea's content is always stellar.
Guys, I didn't hold back. I said what I thought.
And that's just wonderful. There was somebody on Twitter who was giving us grief about like, oh, they're going to snark about this. Do they not realize that lawyers snark all the time?
Snarking
Like,
is like a coping mechanism. I mean,
you pretty much have to, especially because so much, bad stuff here. But
yes.
all right, I'm going to skip over the table of contents because it's a table of contents and, it's going to have all sorts of, but we do start seeing just from some of the entries here already, like my BS detector is starting to go, yeah, these are not arguments you would make in a legal filing,
Yeah.
where you actually want to win. Like
the main thing to take away from the table of contents is just that's the first thing that the court sees. That is their first impression that they're getting. This is your opportunity to lay out for them, this is what the case is about and why you should be interested in reading further. And there is nothing in the way that this table of contents, these headers, these descriptions of the argument are set up that suggests to the court that there is actually a viable legal argument here. The first issue is clearly just dealing with sufficiency of the evidence, which it's such a bizarre thing for Amicus to be sticking their nose into anyway, because they have the people that they represent have no common interest in the outcome of this particular case and in the evidence and how it was considered and stuff, which is the primary reason why I think there is a non-zero chance that this thing just gets rejected altogether, because it's essentially an effort to evade the page limits that Amber Heard has for her own briefing. So that'll be interesting to see once we get her brief and we can compare what does she focus on, and did she just basically delegate, offload some of these issues that her own, maybe better attorneys didn't want to deal with. But of course, Amber has to have the last word and say what she's going to say. And so she just found these groups that would be willing to dump those gripes into their own brief. And that's the type of thing that's not what amicus briefing is for.
If I was the court, I think that one of the things I would be inclined to do would be to say, listen, okay, this is a motion to allow you to file this. It's opposed by the Depp team. And we're going to have oral arguments on this. And I want you guys to come in and give an undertaking to the court that you had no coordination, not just financial anything, that you didn't talk to the other team. Because if you talk to them, if you arranged, coordination, this is gone. And, if you give us your undertaking that you didn't talk to them, and we find out you did, it's gone along with your practice of law. Like, it's because I think there's real possibilities that this was coordinated for a number of reasons. But
well, it does seem coordinated. I will say, at least in my experience with amicus briefing, that in and of itself is not necessarily unusual or problematic. It's very common, especially I would think in a case like Virginia, where they have to file the brief at the same time as the opening brief. So they don't have the opportunity to see what the party has argued and then, fill in the gaps or decide what they want to pull out and emphasize to focus on their own unique interests. So because they have to kind of do all of this at the same time, it makes sense to me that they are going to need to know, well, hey, what are you going to be focusing on? You've raised these 16 assignments of error. Are you going to be arguing all of them? That type of thing I think would be fine. But that's, again, a little bit different from, planning and coordinating. Well, we'll tackle, these 10 issues and you guys take these 2, or whatever. That is exactly not what amicus briefing is for. It's supposed to be about, the big picture legal issues that are at stake in the case, not just the details of how the verdict was reached that has nothing to do with domestic violence in general, reporting domestic violence in general. It is literally a private dispute. That's what the parties' briefs are for, and that's what they have page limits to constrain.
And the other thing that is important is like amicus briefs are almost always about policy, right? And it's perfectly okay to talk policy in an amicus brief, right? But you have to talk the policy of a general legal rule.
Yeah.
In the sense of like, if we decide that the test for what makes out theft is, this, if we decide that the wording means this thing versus this other thing, these will be the impacts on like the, I don't know, whatever group. Maybe you've got a bunch of YouTube people who go and take video where they're like trying stuff on in a store and then they take a picture of themselves with it and they don't buy the thing. And they're saying, well, this definition would count that as theft and we think that's unfair. Cool. Like that's a larger issue. But what you can't say is, and this is like never something you can do, is like Joe Boggs needs to be convicted because otherwise people will think that they can get away with murder.
Yeah.
Like it can't be this specific. So yeah, we're going to like, that's an important distinction and we'll see how they do on this. Now, some of the stuff that's in here I thought was a little odd to include. And then I read the rules and some of it's required to be included. So some of that I was like, okay, cool. And somebody's asking, is Law and Lumber joining? I sent him a link. I don't know if he's free. So, he's welcome, but we're just sort of going ahead here because so this whole bit about leading nonprofit organizations, professors and advocates and so forth, this is required. They actually have to say who the people are and why they care. That seems to be in the rules, so fair ball, I guess, right?
Oh, you're going to highlight my favorite sentence right here.
Then we get right here.
Don't you love calling the jury ignorant? Don't you think that's going to go over just phenomenally well in Virginia, where the good people of Fairfax County took 6 weeks of their life to endure this process because that is the civic system that we have that is so important to resolving disputes. So let's just go ahead and, insult them.
I mean, lots of the people in the chat watched this trial religiously, but you know what? You did that because you were interested in it. And there was a whole bunch of days I like seeing from, watching, I was on various channels and so forth. And there were days when I could just see the viewer count plummet because like when they're like, hey, let's go through all of the deposition video. There were so many people in the chat who were going, you know what? Dibs out. I would rather, watch paint dry and then drink a cup of it than sit through this. Jury's got to sit through this. I remember the one day they argued, some sort of issue with the court for about an hour. And all that is you're just, you're sitting there and they're blasting this noise machine. So you can't hear anything except white noise. They should really change that to pink noise because pink noise is way more pleasant to listen to. White noise is actually kind of painful to listen to for long periods. Like that sucks. Nobody wants to be there. So yeah. And I see we got Rob in the chat saying, Andrea, Ian and I are truly soulmates with that response. We can mind
preach.
Yeah. And the thing is we have juries partially because the juries might have different opinions and different feelings. That's why juries are fundamentally this notion that some court proceedings should be decided by sort of the ordinary people and not the opinions of the elites, not the feelings of the elites.
Yeah, I talk about the jury as being the conscience of the community. Uh, they're not there to decide what the law is, but at the same time, they're a randomly selected group of people. So, there's not an expectation that, for example, like amici curiae, that they have some sort of common interest. They're just people who come from all different kinds of walks of life with all kinds of different perspectives. And so the process of litigating a case is really a process of negotiation for them to be able to, bring all of these different perspectives together and compromise on what the right outcome is in their opinion. And so that's the function that it serves in a society, is by being able to bring together those different perspectives and being able to reach that point of compromise.
And the other thing is, if you say that the jury is ignorant of these things, what you're fundamentally saying is Amber's lawyers sucked.
They fucked up their case. Oh, sorry.
Yeah,
Can I say the F word?
yeah. Oh, I mean, I'm not going to worry too much. We got to keep it to like a dull roar, because eventually, otherwise YouTube will get upset. But I mean,
I'll watch it. Sorry about that.
Oh, no worries. I mean, they allow a certain number. They used to be really picky about it, but I mean, you're basically saying Amber's lawyers sucked because it's their job to educate the jury on these points, right?
Yeah. Well, the jury heard from, 3 different experts, if you count crazy Dr. Spiegel, 4 if you count the guy that rebutted crazy Dr. Spiegel. Plus, then you've got, the actual therapists and, treatment providers and stuff who were there, who testified at the deposition. Like, the jury heard a massive amount of information about this stuff. So this premise that they're somehow misinformed is just so readily rebutted by the record of what actually happened at trial.
Yeah, and I mean, but fundamentally, the jury are the ones who get to decide some of this stuff. They get to decide what, Amber's statements about abuse meant, like what that was intended to communicate. And
100%.
So, saying that the jury is ignorant, like this statement itself, if you stop and think about it, is basically like putting in writing, Amber should lose. Like, it's just that they don't realize that.
Yeah.
So,
yeah. I mean, if that is what you have to rely on, then yes, your argument is deeply and fundamentally flawed.
And then they continue on with amici or amici. I don't know how Latin is a bad language. We should get rid of it.
The one thing I know about Latin, that because Latin, I guess, is extremely complicated. I never studied it, but the C is always hard. It's like the one easy rule for Latin. C is always hard, so it's amici.
So it's also wish to advise the court of the troubling, chilling effects this highly publicized verdict will have on victims of abuse seeking to protect themselves, report abuse, and raise awareness. This is a statement that I would never put in an amicus brief. Because when you're an amicus, that distinction that I was making earlier is you're arguing this is how the law should be interpreted. But this is a statement of verdict bad.
Yeah.
We don't like the result, and they don't typically allow amicus to, like, amicus ultimately typically shouldn't have an opinion on the result. If I'm running an appeal and saying, and it's about like the king and Joe Boggs, because the king is sort of the government where I am, an amicus would say, listen, you should interpret the rule in this way.
Yes.
But I would never expect to see an amicus saying specifically that Joe Boggs should be convicted.
No, and that's the distinction that's really important with the amicus briefing, because when they are talking about that broad legal principle, when it's time for them to turn to the question of policy and what would actually happen under these different interpretations that the court is being invited to adopt, that's how you lead into that type of argument, and that's what makes it important. That's what makes it something for the court to consider. The court is interested in hearing things like that, because they aren't necessarily in a position to be able to know and predict all of the downstream effects of their decisions. And so that's where amici can be very helpful to sort that type of thing out. But if you don't have a legal basis for suggesting there should be a policy change, then you're just griping. And that's not helpful to the court.
Yeah, it's, you know, if all you're saying is we're unhappy that the case was decided one way or another and that's it, then, you know, they shouldn't listen to the brief. The other thing, based on my local rules, I thought was a little weird, was this bit. Amici requested the consent from all parties to file this amicus curiae brief. Appellant Ms. Hurd has consented. Appellee Mr. John C. Depp opposed. And the reason why I'm calling or making, because you're already going, this is not weird. This is required by the rules of court. Where I am, this would probably be an improper statement, because at that point you're basically saying we are picking a team, but the procedure where I am is different. The amicus would basically say we would like to file a thing, and then you get to oppose or not at that after that. So somebody's saying, would you please explain what an amicus brief is for? Who does one and why? I feel like we jumped into the middle. Okay, let's back up to the beginning. So let's say that we have a criminal trial, and that's between the government and Joe Boggs. Those are the parties, right? Now, we decide legal principles based on these court cases, and those court cases might affect people who are not Joe Boggs, and so let's say he is convicted of some sort of crime because and because of a particular search. And so this is the search issue. Well, you might have people outside of that who want to express an opinion. So you might, for instance, have a group saying, listen, they decided that, that it was considered okay by the court that they, investigated him because he looked scruffy. We represent homeless people, and they get overly targeted, so the court should be aware of this and consider whether that was a reasonable part of the decision. So it's any of these people who might want to express to the court, we have an interest in the legal rules that get used here.
And in your example that you've given too, the very common counterpoint to that is that law enforcement organizations will participate as amicus. They'll want to come in and be able to say, if you don't let us do these searches, then it's going to cause all kinds of problems with law enforcement, or officers are going to be unsafe, or whatever. So it's very, very common for that type of thing to happen.
In the case I took up to the Supreme Court, I was, it's from Alberta, so it's the Alberta Solicitor General on behalf of the government. But Ontario's Solicitor General wanted to file a brief saying, listen, we do criminal law here too, so this will affect Ontario. It's lots of people may have interests. So in civil law, you'll get different government groups saying, like, listen, this is how we do trade. If you interpret loan rules like this, maybe our business, like our bank, goes under, that kind of thing.
Yeah.
But yeah, so that's why they say, hey, one side is consented, one side is opposed, and they're required to actually check and see if they're willing, like which sides are willing to consent. I thought that was kind of neat.
Yeah.
So, and yeah, somebody had the example of the Onion brief in parody. Yeah, the Onion isn't a party to it.
Yes.
But they do parody. I haven't covered the Onion brief, but I should, because it's so funny.
You should. It is just a thing of beauty.
It's the brief we all wish we could file.
Yes.
Like, oh man, I just wish I could get the opportunity to do that. So, yeah, and somebody else was asking, does the court have to accept this, or can they refuse? This is actually part of a motion for the court to accept this. Mm-hmm. You have to go to the court and say, will you please accept this? The court usually will accept them, because usually they're like, more information is good. However, sometimes they don't.
It needs to be helpful information. It needs to be information that the court is going to get some benefit from from reviewing and not.
I mean, fundamentally, you can go back to the Latin meaning here. Amicus curiae, friend of the court. You know, I'm not a party here. I just want to come and help the court. And if the court thinks that you're not coming to be helping the court, they can say, get out of here. You're not my friend. Bounce.
Mm-hmm.
So, yeah.
Yeah, with friends like this.
Oh, yeah. So they've moved to file this brief in the accompanying motion. So source the authority to file. Yeah, we were filing it on that rule. That's not a terribly interesting part, but that's just, this is why we're filing it. It's also interesting that we don't actually have the motion. Like, they leaked the brief, but not the motion. And I would like to see the motion too.
I would too.
Because a lot of the stuff in the brief seems like it's stuff that should be in the motion, but yeah. All right. So though Johnny Depp's defamation claims are facially limited to 3 statements made by Amber Heard in a Washington Post op-ed, the record in this case makes plain that Mr. Depp used his lawsuit to retaliate against Ms. Heard for obtaining a temporary restraining order against him 6 years prior in an effort to escape Mr. Depp's increasingly insufferable abuse. So,
I love this introductory clause. Okay, this sentence is just a gem, because what it's saying is, let's put aside what this actual case and appeal is about and talk about some other shit.
Yeah, it's like, you got to actually argue about the context of the case, not about the other stuff. I mean, it's one.
Yeah.
So, and they're going to do this all over the place. They're going to be asking the court to basically say, listen, you need to consider every issue in the world, which is not what the court is here for. So at trial, Mr. Depp painted the traumatic events that led to Ms. Heard's protective order as an elaborate hoax perpetrated by Ms. Heard against Mr. Depp, the true victim. Mr. Depp's ploy was successful. It was not successful because Mr. Depp carried his burden to demonstrate by clear and convincing evidence that the alleged defamatory statements regarding abuse were made with actual malice, a subjective standard. That requires proof Ms. Heard recklessly disregarded the truth. Rather, as a post-trial interview with one juror revealed, the jury found in favor of Mr. Depp because while the jury concluded they were both abusive to each other, Heard's team failed to prove Depp's abuse was physical. Okay. There's a lot in here. Maybe I should have broken that up a little bit here.
There is so much here.
I mean, the first thing is this is an attack on the factual findings of the jury.
Yes.
And you can do that. That is,
yes.
But not typically as an amicus. Typically,
yes.
Because, and the reason why amici almost, or basically never argue facts, is because typically if the facts are against your issue, that's a good thing for the amicus. And what I mean by that is, you know, if we have the example of, let's say that there's a rule about police can search any red car at will. And the amicus is a manufacturer of red car paint. And they are obviously concerned about this rule about red car searches because we make red paint and that'll affect our business. Well, if the court ultimately said, listen, we find this rule isn't engaged here because this was a blue car. And so the red car issue, usually amicus is like, great, they're not upholding the rule about red cars. This is not a case that bothers us. Cool. The only people who should have an issue with the facts are the parties. And so if you're not, you know, Amber Heard or John C. Depp, this is not a submission that you should be making.
Yeah, 100%. This is not a common interest. This is a specific interest that is unique to the parties in the case. It's often the situation where, you know, I do criminal defense, I do appellate work. And so I will often win on principle and lose on facts, where the court will conclude, yes, we're going to go ahead and accept your interpretation of how the law should be. But when we apply that to your particular client's case, we're going to find various reasons why that rule doesn't necessarily entitle him to any type of relief. So
Yeah.
if I get amicus support, that's really helpful for at least getting over that initial hurdle of convincing the court to adopt the rule. But I am on my own when it comes to convincing the court to please give my client the benefit of this rule, and here's why.
We see this all the time with regards to sentencing appeals. This is where you get this a ton, where the court will say something like, listen, we agree that this mandatory minimum sentence is unconstitutional. It could affect this other group of people. In the case of the Queen and Nur, basically they said, listen, you can't have a mandatory minimum sentence for possession of a handgun with ammunition, because this could be anyone from a gang member to like somebody who just let their license lapse. Mm-hmm. However, they specifically said, but you, sir, look to be a gang member, so the sentence in your case is totally appropriate. So you're the example that is the example for why the mandatory minimum sentence makes sense in a lot of cases. Yeah. But we're going to strike down the minimum for other situations. And somebody says, let's not conflate criminal with civil proceedings. A lot of the rules are similar, yes. Right? A lot of these general principles are very similar. I like Rob Lawn Lumber's comment here. This should have been properly styled as an amicus torcular, friend of the press brief. Where did my legal argument go? Where could she be? So, yeah. And we've got some super chats piling up. I'll get to them sort of after we look at a bit of this. What did you think of this bit here?
Okay, so this bit right here, this is when this brief hits the shredder in the Court of Appeals. They are done now reading this brief. There are so many problems with this sentence that can be distilled down to the fact that it is a bright line, rock solid rule that anybody who has ever tried a case knows that you may not use statements of the jurors to impeach the jury verdict. You can't come in and question the jurors about, well, how did you reach your decision? And then decide you don't like their reasoning and use that to go back and undermine the verdict. The idea is we have these jury trials because we want judgments to be final. And so we understand, like we talked about at the beginning, that jury deliberations is a process of compromise and a process of negotiation. So that's just kind of understood to be part of the process. And as long as that does not cross the line into misconduct, that is exactly what the jury is supposed to be doing. So I went and looked up the rules for Virginia on this, and I'm sure Rob knows a lot about this too. But Virginia's rule is actually quite a bit stricter than it is over here in Washington, where I practice, where they consider these statements to be flatly inadmissible. You're not even supposed to be offering this thing, okay, in evidence. And yet this is the foundation of their entire argument. Their entire argument is because the jury didn't consider physical abuse, and because there are these other forms of abuse that are not just physical, that therefore Amber could have reasonably believed that she was abused and would not have had actual malice. So if you take this piece out of that argument, the entire thing collapses. And this thing can't support anything as a matter of law in Virginia. I think there's a legitimate question if this is a Rule 11 violation here to even include this in this brief. Like anybody who does basic research at all should have caught that this is not a lawful predicate for a challenge to a jury verdict. So I think the best case scenario for them, frankly, is that this is the moment when it hits the shredder.
I think I was reading this and I was thinking there is a potential for like actual, like the court being angry. But I mean, I don't think they're actually going to get sanctioned. What I think they're going to get is maybe yelled at or a dismissive rejection. That would be, I mean, I don't think anyone's going to get hit with Rule 11 on this. I think it's arguable. Like, I don't think it would be improper to say, hey, we want to bring the argument. I just don't think the court will do it.
Sure.
But there's all sorts of other elements to this, even in areas where it is like, even in areas where you could bring in juror comments. Would you do it through a news article that talks about an anonymous juror?
Yeah.
Like,
Yeah, it's a good question. I mean, because it's, we don't know for certain that this juror is who they purported to be on GMA. It's
yeah,
kind of,
we
it's
have
not like this is
hearsay that cites.
testimony. And that's an important thing too. Like, okay, so in situations where I can go in and use juror statements, because say we're talking about misconduct, somebody has come and told me that, hey, somebody in the jury room was doing outside research. I actually had this happen in
Yeah.
a case. It was one of my very earliest jury trials that I ever did. And so we found out somebody had gone home, done a whole bunch of internet research, came back and brought that into the jury room. Well, that's misconduct. That's against their instructions that they are to only consider the law and the evidence that the court provides. So I'm able to use those statements by those jurors that reported that in order to establish that there was misconduct. We need to declare a mistrial. But you don't just you need like an affidavit, you need a declaration, you need testimony, you need to bring them into court and ask them. Like, there needs to be some formality to the process of obtaining the statement, and not just this multi-level hearsay thing where we think it's this guy and he's saying this and he's talking about what other people are saying and thinking, and GMA is telling us that this is an actual juror. Like, it's just very weak.
This is basically coming down to, we have a rumor and innuendo that says this, and we are relying on it as part of our argument. And
not just part of our argument, the foundation. The entire argument is built. This is the footing, okay? And it is sinking fast into the quicksand.
Yeah, so, I mean, yeah, the jury's singular focus on allegations of physical abuse, which, again, you don't know what they were thinking, is contrary to the evidence presented at trial and demonstrates a fundamental misunderstanding of the law.
Which is so funny that they say that after just massively misunderstanding the law one sentence previously.
Yeah, it's... The conduct by Mr. Depp laid bare at trial in text messages, audio recordings, video, and his own testimony. Again, you have to reject the jury's findings to get to this. Demonstrated that in addition to physical abuse, Ms. Heard was the victim of emotional, verbal, psychological, and other well-documented forms of abuse. Again, this isn't like we have an issue. This is, we feel bad for Amber. And that is not an issue for a... this is not an issue for an amicus, right? It's...
Yeah.
So,
yeah, and one of the things too, maybe these people aren't used to briefing these types of issues, or maybe, I don't know. I don't know how to make sense out of some of these decisions, but let's just take them at face value that there is some interest that the people that they represent have in the resolution of the facts in this particular case. As you pointed out, it is perfectly legitimate legally to challenge the sufficiency of the evidence supporting the verdict. The difficulty with that, though, is that it is very clear under that type of review that what the court does, they look at all of the evidence in the light most favorable to the party who won the trial. Yeah. And basically what that means is that anytime there's a conflict in the evidence, anytime there's questions of credibility, anytime there's some sort of disputed issue that has to be resolved, they are going to assume the jury resolved that in Johnny Depp's favor. So it does you no good at all in a brief like this to go in and point out the things that you think were in Amber's favor. It doesn't matter. They're entirely irrelevant. You have to show that there is some deficit that, even if you looked at the entire case and all of the evidence and looked at all of it in Johnny's favor, that there is some inability to meet one of the essential elements. And so this just reads to me as amateurish. Like, this is law student like level brief that you haven't figured out. This is not how you attack a sufficiency of the argument issue. Or sufficiency of the evidence issue.
I read this here as this is quotes for newspaper articles.
Yes.
This is what they're looking for here.
Mhm.
When we talk about like the the jury, the question is basically, could the jury have reached this even if we disagree with every conclusion that they made to get there? Is
Mhm.
it possible that they did that without making stuff up? Is so, let's say there's a shooting at a party and you've got 10 people who are at this party who say Joe shot Frank. And then there's one guy and he admits that he was drunk and, but he says, and he's got mental illness and he's got a record for perjury. This is like your worst possible witness. But he says that Frank was actually shot by, the dog stepping on, a gun that was left out. And you're like, well, that could happen. It's possible that the dog could have accidentally set off the gun. And sure, there's all these 10 sober people who say that that's not what happened. But the jury could have believed Frank and they could have disbelieved everyone else. And the appellate court is not going to go back and say, well, we're going to redo what the jury said.
Yeah.
Now,
and I'll get that situation kind of frequently. It comes up a lot when you get witnesses that are terrible witnesses. They're contradictory. They say different things all the time. And, so you would think, oh, we just entirely disregard what they have to say because none of it can be reliable. And, who knows what the jury actually does do with it. But when it comes to this type of review, it doesn't. The verdict is going to be supported by anything that they said because the jury is entitled to rely on it if they want to.
Yep. The jury is entitled to make bad decisions in some ways. Like that's so, I mean, they're not entitled to like ignore the law or anything, but they are entitled to say, we believe the alcoholic liar. Like we think he's the only trustworthy person who is in that room. Mm-hmm. So, that's their call, and the appellate court is not going to reject it. They do get around to something that I think is actually, this is where I actually think that they sort of stumble briefly into an argument that an amicus could make.
I'm going to argue with you immediately. I already know where you're going, so let's hear it.
So these additional types of conduct all fall within widely accepted definitions of abuse in the Commonwealth of Virginia and in the scholarship of domestic violence more generally. The trial court rejected Ms. Heard's request to provide the jury with an instruction on what amounts to abuse, and as a result, the jury improperly disregarded non-physical conduct when considering whether abuse happened, and it continues on. So, I know you're going to disagree with me, and I kind of disagree with me, and I'm going to explain my thinking here. I think that this is not like measured against the standard of the rest of this brief, which is basically like, legally speaking, a lot of this is like crazy person ranting. Mm-hmm. But I think there's an argument to be said about the jury should be instructed about what abuse constitutes. And then here's my big but. In pretty much every context except defamation. And like, if this was a criminal trial and if the offense was abusing somebody generally, like if that was how the language was, then I think that this would be an excellent point, to say that the jury should have had some instruction as to what that means.
Yes, if there is a crime that requires you to find abuse as an element in order to convict somebody, then abuse should be defined for the jury.
But defamation is the implication of the statement as it was made false.
Exactly.
So
exactly. And you can go back to the letter ruling that Judge White gave in March of 2020 when when she did her first initial challenge to the statements, basically saying, they can't support a defamation claim. And he points out that under Virginia law, the way that this works is that the jury gets to look at the entire circumstances and the context and evaluate, what did she mean? What was she implying? They don't have to stick with a dictionary. Okay. They get to look at what was going on and how is that affected by For example, that decision to talk about what happened 2 years ago as a signpost to what her entire article is about. And then consider all of that context to understand what it is that she meant when she used the term abuse. It doesn't matter what the dictionary says it means. It's what matters is what Amber Heard meant, and that is 100% in the jury's court to be able to decide.
Yeah. So, I mean, when I say that I think they're stumbling towards something, I think that they've just picked the wrong case for it.
Yeah.
Like, it's a good idea to say, hey, the court should maybe know what abuse looks like and so forth, but not in a defamation trial. Like, but yeah, it's so that's sort of my thoughts on that one.
The other thing that I found interesting in this section as well is that first sentence: the trial court rejected Ms. Heard's request to provide the jury with an instruction on what amounts to abuse. That's not an assignment of error. So the court is not going to look on that as an error. The court is going to assume the instructions were just fine. So it's such a bizarre little gripe to bury in here, because that's not the court is not going to concede that there was a problem here. Nobody is challenging that except this amicus.
Yeah, and the amicus can't create a new assignment of error. Like,
no.
This is the other thing you get questions about sometimes is like, people say, can an amicus appeal? And they can't. They can only join another appeal. You can't like, hey, the court convicted Bob. I want to appeal on Bob's behalf because I don't like the ruling. They can't invent grounds of appeal, which is what they're trying to do here. So basically they say that in conducting its independent review of the record, this honorable court will find ample, uncontroverted evidence of various forms of abuse suffered by Ms. Heard at the hands of Mr. Depp. How relevant is that if the court finds this evidence?
It's not. They're trying to burden shift. They're trying to do the reverse of what I pointed out is how the court is going to analyze this issue. The court is going to look at the verdict form. They're going to look at these are the specific findings that the jurors made. And then they're going to go back and look over the record and evaluate, is there anything in here that would support that decision? For example, is there anything in here that could lead a jury to believe, even if we think it's unreasonable, that Amber Heard was a big fat liar? And I would humbly suggest there's going to be plenty to draw on in order to support that type of review. So whether there is any evidence at all that supports Amber Heard's position and her argument that she took at trial is entirely irrelevant to the question of the sufficiency of the evidence.
And I think that the only way this may be an issue is if this was a criminal trial. To say, listen, we can show that it wasn't beyond like the standard of beyond a reasonable doubt. But the standard in the civil trial, preponderance of the evidence, like balance of probabilities, the jury's entitled to that ample uncontroverted evidence. The court can have whatever opinion of it, but they also recognize that in law, the jury's entitled to disregard it.
Yes, 100%.
So what's the appealable error here?
It's a great question.
Do we think
they have not really made that clear yet?
Yeah, at some point they should actually say that here's an error the court made that you can consider and that you should reverse.
Yeah, a legal error.
Yeah, it's just factual. As such, Ms. Heard's statements that she became a public figure representing domestic abuse could not be false, let alone made with actual malice. Again, the jury is the one that gets to make that decision. So then they say the court should therefore conclude that the trial court erred. And oh, sorry, go ahead.
They cut out the 2 years ago. Isn't that clever?
Yeah,
because that's sort of a little important piece of context in that particular statement that really emphasizes why exactly that statement was false.
They also there's a number of places where they do that sort of very selective quoting. If you look at the article with the supposed juror, who again is completely anonymous, the thing that the juror goes on to say is, but we found that she meant physical and sexual abuse, and we found that didn't happen, which is why we ruled the way we did. which, if you include that in the brief, defeats everything, even if it was admissible by some miracle of appellate confusion. Like,
yeah.
so, and then here's where we
More
get
of
into
the parade of horribles,
which again is something that an amicus should not be doing. Such a finding will not only rectify the injustice served in this case, but also send a message to those who may seek to improperly use defamation lawsuits or other legal proceedings as a means to retaliate against victims of abuse. Wow. This is just, this is just, I think, really interesting.
Well, it's a solution looking for a problem is part of how I see it. I mean, has there been anything to establish that there have been, a problem with defamation suits being filed? Like, I feel like this is kind of an important step that you need to take to establish for the court that this is actually a problem that you should be concerned about. And they've just sort of skipped over that to, the sky is falling.
I mean, I've done tons of domestic violence cases. I haven't seen a defamation lawsuit in any of them. So that, I mean, I think it happens sometimes, but
yeah, I'll tell you where it happens. I had a Title IX case where I strongly recommended the kid, consider pursuing a defamation case. That's why there is a growth of defamation in the wake of Me Too and in the Title IX revisions and stuff, is because people are making more of these statements outside of the formal processes. They are using them in the press. They are using them in academia. They are not using them as part of the litigation process where they would be protected by the litigation privilege. So if you can report whatever you want to the police, and as long as it is truthful, you're not going to be able to be sued for that. So
in most situations, even if it's not truthful, there's usually privilege that covers it. Like, even perjury may be covered under litigation privilege, at least in some jurisdictions. I'm always having to hedge because the US has such a wide variety of rules that I don't know about everywhere, but such that, it's like, well, we can pursue perjury, but we can't pursue a lawsuit over it. Like that kind of
thing. It's a really good point. And that's the only reason I was kind of thinking about that. Like, but they could be charged with making false statements to the police. Yes, but they still, I think you're 100% right. They still could not be charged with defamation.
So there are such huge protections there, but also this notion of we need to have a particular verdict to send a message.
Yeah.
Is, it's not just wrong. It's like flagrantly, obviously wrong.
It's like Tom Robinson wrong stuff. This is getting down to where this is not about legal principle. This is just purely about power, because we think things need to be differently. And so therefore, throw out the rules if the rules don't serve the outcome that we're trying to achieve.
Yeah. And this is not how cases are decided, right? You never decide a case in one thing about what it would mean for society. It's just the specific case is decided on its specific facts, and to some extent, damn the rest of society, right? It's,
and again, it's one thing if you want to talk about this in the context of, we're asking you to adopt a legal rule that, adopting it would send this message. So it's important. There's a broad application, not this verdict, freaks people out. I mean, that's not a justification for depriving somebody of life, liberty, and happiness.
Yeah. People say, okay, well, it's a civil trial, but I mean, if this was the rule, it would also be the rule in criminal trials, you'd think. And, imagine the notion of we need to jail this person because otherwise, well, they might be innocent of an SA. If we don't jail them for it, then other people who've actually committed SA might think they could get away with it. It's like, no, we don't do that. Like, that's a messed up society.
No, we tilt this, we tilt the error, you know, the other way. We err on the side of people get to be free.
And then they've got, indeed, an abuser's misuse of legal processes to further control and coerce their partners, referred to as legal abuse, is itself a widely recognized form of domestic violence. This one, you have to assume the conclusion before it's of any relevance whatsoever, right? You have to assume that the jury was wrong. And
Yes.
because otherwise, this isn't legal abuse. This is Johnny Depp filed a claim which was a legitimate claim and got a remedy from the courts. That's what courts are for.
and you have to wonder with how this argument is put together, is there any circumstance where a man would be able to go to court and clear his name and it wouldn't have these other effects? Like what is it exactly about this particular case that, you know, that he won, and therefore it's legal abuse? Like it just, there's a big missing piece here that I can't quite make sense of. How do you fit this viewpoint into having the right to due process, a right to, you know, exercise your civil rights in a courtroom and obtain a remedy? Is there any situation where they would support a man going to court to sue a woman for falsely accusing him of sexual assault? You have to wonder.
I
don't
had a
volunteer
case where,
that they do. I mean,
yeah, and I mean, I don't think that they would. I had a case where the opposing lawyer asked me, "Aren't you worried about being declared vexatious, like a vexate?" And I said, "They don't declare you vexatious when you're winning, right?" And I ultimately won that case. So,
that's amazing.
but I mean, but Christina Pickles here makes a good point about the legal abuse and that cutting both ways. Because guess who started legal proceedings? And in this one, that was Amber. She went and got, you know, so wouldn't that be like the TRO? Wouldn't that be the legal abuse in this context based on the jury's verdict?
Yeah.
So,
yeah.
The verdict in this case is part of a growing and troubling trend of individuals accused of abuse and harassment using lawsuits as a tool to silence victims. No citation.
None.
This one needed a citation. This is where you actually need a citation to things like, we did a study. Like,
yes,
you know,
yes, trend. If you're going to claim a trend, you need to prove a trend.
This is where I would have wanted like a citation to see this dozen research papers. Not just, I am making an assertion. And then they go on, and then they're going to have a citation here to New York Appellate Division, recognizing in Segal and Carrera. Do you guys say again, or, you know, do you say and or v or versus, or what is the U.S. practice there?
It varies. I say v. Segal v Carrega.
Yeah, in Canada we say and, like the king and so and so. It always sounds a little weird. It sounds like they're a little more buddy than typically people are, but that's kind of the tradition. Noting sexual assaults remain vastly underreported, primarily due to victims' fears of retaliation. It does not escape us that defamation suits like the instant one may constitute a form of retaliation against those with the courage to speak out. This does not back up what they cite it for. It doesn't say it's a growing thing. It just says this is one case. Yeah. Similarly, in a report to the General Assembly, Rob has a good point on this. And there's a Canadian rule that I tell people, which is the rule in Canada is, and it's not a formal rule, it's just kind of an informal thing. If you cite to the Magna Carta, you are going to lose the case. I have never seen that proved wrong. It is just like, and I feel like in the US, citing to the UN kind of suggests you're desperate.
Yeah, so, I mean, you're your audience that is going to be receptive to that citation is very, very limited. It is obviously not binding authority. It is persuasive only to the extent that the court thinks it is, and there's quite a few courts that are not going to be particularly persuaded by whatever the UN thinks.
And somebody says, has anyone looked them up to see if they're legit lawyers? They're legit lawyers.
Yes, they are.
So yeah, it's
actually licensed and everything.
Yeah. And I see somebody's saying, why am I covering American cases? I do like 1 out of every dozen. So yeah, it's going to happen. Sometimes the US is interesting. So they note that this is a troubling, chilling effect on survivors of abuse seeking to access justice, to protect themselves, and prosecute abuse. And I'm saving all the super chats, but I am going to go back a little bit to pull one up from Rob here. And, so we'll get to sort of super chats when we've got a sort of a break here. But this one I think is a very relevant one to this. And Rob says, hey, Amiki, literally go bleep yourselves with that one. Stop conflating defamation with reporting to authorities. You, Amiki, are the bleeping problem.
Yeah.
I think that this is, in literally hundreds of DV cases that I've looked at, not one of them turned into a defamation trial.
Mm-hmm.
Not one. Mm-hmm. This is not a problem most people face. Mm-hmm. And in fact, like we talked a little bit before about the protections of litigation privilege and so forth. There's such incredible protections. Like you can say all sorts of things on the stand that might be massively defamatory.
Yes.
I watched a lawyer screw up a trial. And what I mean by screw up is that they asked for evidence that was obviously inadmissible. They said, why do you think this? Like, why were you not letting this person in your house? And the guy said, well, it was some stuff I heard. So he's made it clear that this is based on hearsay and that he's reluctant to say it. And the lawyer says, what did you hear? And he said, I heard he'd essayed a woman. And so that's why he wasn't allowed to my parties, because I don't want that guy around my, around people and, alcohol. I heard he essayed a woman like 3 weeks ago. And I was like, you screwed up, right?
Yeah. Yeah. That's the classic, don't ask the question you don't know the answer to.
Yeah. It would have just been like, you just leave that one alone. But
yeah. Yeah. You should have asked that in your interview.
If you wrote this like in a newspaper, like an op-ed, and you said, I heard that this guy essayed a woman, defamation is potentially an issue, right?
Yes.
Yes. Like it's a classic potentially defamatory claim. But there's no way to proceed against that guy for that statement in case. So, yeah. So I note here, somebody's asking, would I be interested in coming on Clyde Do Something to discuss these new gun laws? Shoot me a message on Twitter. So, all right. So they're going on about the troubling effect. Again, this is the kind of stuff that says that this should be lining the trash bin at the courts. Because they're basically saying you have to fine for Amber or else it will do bad things to other people, which is not a relevant.
Yeah. They're coming as close as they can possibly come to saying you must rule for the women or women will suffer, without just coming out and saying it. But that's just the silent message in all of this. There's not really any other way to read it.
This to me seems like exactly what you just said that they're tiptoeing up to. I think they step right over it. They say, this reversal of the case will serve to reinforce that the rule of law supports and does not hinder the ability of survivors of all forms of abuse to speak up, seek help, and encourage others like them to be brave enough to do the same. Depp's got to lose or bad things happen. Doesn't matter whether Depp is wrong or right. He's got to lose or bad things happen.
Yeah. let's forget about the part where, Depp could be justified in bringing a defamation claim, as the jury found.
So we're now on page 6, and we're finally getting to an assignment of error. That's fantastic. And it's purely based on erred in denying the motions to strike and set aside the jury's verdict with regard to Mr. Depp's failure to prove actual malice by clear and convincing evidence. Let's see if they talk about that. All right. They incorporate Ms. Heard's statement of facts. I like how they note that they say that it's accurate.
Yeah, of course.
That's, yeah.
Did they check all the citations?
Yeah, I don't know. I mean, I doubt it, but I also, I mean, I would have written my own statement of facts. I just would have. You want to look like you're unbiased, right? You want to look like you're a neutral observer, and just saying we incorporate. It's not that they can't do it, but I think it's a bad look.
Yeah, it is a bad look. It is a bad look.
All right. So they say that they can overturn it if it's plainly wrong or without evidence to support it. Now, let's talk about the plainly wrong standard. What does that mean?
Well, it's what we just talked about, how if you look at all of the evidence in the light most favorable to the party that won, and in light of all of that, you still cannot prove one of the basic elements of the charge, then the claim has to fall. And so an example I'll give of this one, in an appeal I won a few years back, was based on Washington's attempting to elude statute. So, you run from the police in your car, basically. And it's just a statute that we have that has a lot of extremely technical requirements that have to be met. And one of them is to prove that the officer at the time was in uniform. It's there in the statute. Officer has to be in the uniform. So this case goes to trial. It's not a complicated case. They get the officer on the stand, and the prosecutor simply forgets to ask about, was he in uniform or not? So it never comes into the record one way or the other. There is nothing in that situation that the juror can hang their hat on to say, even if we look at all this evidence in the light most favorable to the state, there's nothing here that shows that we could, draw on to say that he was actually in uniform at the time this happened. So that element can't be satisfied. That is a very, very different situation than, a 6-week trial where there was lots of conflicting evidence on both sides, and the juror's job was essentially to resolve that. If there was a deficit in the verdict, they would be able to go to the verdict form and point out, this is the one that fails, and here is the universe of evidence on that particular topic, and you will see that it doesn't meet that standard. Yeah. And so the problem here is that actual malice, you just have to find that Amber lied. So there is plenty of evidence in the record to be able to find that Amber lied. It's just it's not a plainly wrong standard, which is why I think, moving on to the next sentence, you should always be judicious in your use of claiming that things are clear to a court of appeals, because usually when you're saying something is clearly established, what that means is that it's not at all, but you're flailing and you're desperate and you have no other way to try to convince the court that they should adopt your position other than to use really strong language that you just are sure that you're right on this.
The only time I really like using things like clearly met is when I can then follow it up with, here is the direct citation that shows it. So let's say
the standard in this case is clearly met by X. Here's the evidence. It's clearly met because. Give us something here, not just I'm asserting that it's clearly met, therefore it's clearly met. That's not persuasive at all.
So let's, take your example of the uniform requirement, right? Mm-hmm. Let's say the judge had thrown this out before it gets to the jury on the basis of no uniform. They've closed their case. There's no uniform. Jury doesn't even get to make the call. I am dismissing this. And let's say that we lived in a jury, if this in Canada, that would be something that you can appeal. I don't know if that's something that you can appeal in the States or not, because you guys have much more restrictive appeals in criminal things. But here in Canada, if that was being appealed and if I was the Crown appealing that, I would say something like it's clearly met because on paragraph 82 of the transcript, the
Yes.
officer says I was in uniform on this day with my
Mhm.
badge and my gun and my bulletproof vest, and a police dog and a parade that, pointed out that I was a police officer. Like, that's what I go, like, it's clearly met.
Yes.
Y-
Yes, exactly.
Yeah, it's something you want to follow up with a, yeah.
It's just one of those things that is a clear tell. Before I practiced law, I was a clerk in the Court of Appeals in my state, and so what you do there is you read the briefs, you do the research, you write the legal analysis, you make recommendations to the judges about how you think the case should be decided and stuff based on your research. So you're just kind of an assistant to the judge in sorting out a lot of these issues. And so this type of sentence is a tell. It's the type of thing that as soon as you see it, oh, this argument's trash.
And the best briefs, like the one, I don't mean the best in terms of the best written, because sometimes the best written are the ones where you manage to spin straw into gold. But the ones that you're happiest being able to write are the ones where you have to do very little argument.
Yeah.
You're just like, here is the
Show.
legal test. Here's a ton of evidence.
Mm-hmm.
You make the call, judge. Isn't it super obvious? Here is the
Yes.
next legal test. Here is all the things.
Yeah, if you find yourself in a situation where you need to be like ramping up your emotions and using exhorting type of language, then chances are that's because there are not things in the record that you can point to that are on your side that clearly establish your entitlement to the relief that you're asking for. Because if that existed, that's all you have to point out. And there is nothing as coolly persuasive as showing the facts that support your position.
Yeah, if your point is that a particular animal is a dog, the more you have to argue it, the less likely people are to really be. Because, with my dogs, I just bring them in and point and go, dog,
Mm-hmm.
we done, right? But if I've got to argue it, people are like, then it suggests that we've got something a little more questionable. And I've got a great question here. Please advise the lovely folks in chat how many times you've ever seen the denial of a motion to strike a jury verdict overturned on appeal. I'm not aware of one in Canada.
Yeah, I offhand, I would say maybe once. Maybe.
Actually, that's not true. I have seen some in criminal law, but it's always based on like the very obvious legal element that was missed. Like the very, officer didn't testify they were in a uniform. Motion to strike should have been granted.
Yeah, and that's the type of situation where the only reason that I got that issue on appeal is just because the trial lawyer didn't think to raise the issue, and that comes up, sometimes. Had they raised it, yeah, it should have won on a motion to strike. I don't know if it would. It's politics are kind of a thing in court sometimes. But
I've filed those appeals where like the person argues. I've filed like. Often trial counsel don't want to run their own appeals because they're like, if I screwed up, I don't want to be so I end up getting appeals from other people. And I had a few in a row where they were all like these sort of motion to strike. We call them non-suits, where it was basically the prosecutor had failed to call a critical piece of evidence. And so I'm like, the appeal is the motion, the non-suit should have been granted because they failed to call this particular point. And the Crown prosecutor, on one of them, wrote me an email and said, we never lose these. And I said, I will withdraw my appeal if you can point to this in the transcript. Like, just shoot me the line in the transcript that says this. And a week later, I got back from the Crown saying, we are consenting to the appeal. You are right. They looked through, they couldn't find it.
Yeah.
So yeah. Where here as a public figure, or as here a public figure brings the defamation case, the requisite intent is actual malice, a subjective inquiry which requires the plaintiff to prove that the defendant in fact entertains serious doubts as to the truth of her publication. Who makes that call, that subjective inquiry?
Yeah, good question. Is that a jury thing?
I feel like that's a jury, and I
I feel
feel like
like maybe the jury considers whether there was a hoax involved in ginning up the statements, and maybe that's the type of thing they look for to evaluate a person's state of mind.
yeah,
Just
it's.
hypothetically.
And I see somebody saying the Crown. Wow, that's the Canadian, like the Crown prosecutor is. We just call them the Crown. Um, and all of our criminal cases are. They used to be the Queen and so. They're now the King and so. It is messed up.
Did you have to go back and change all of your caption forms on all of your open cases?
Every open case had to be amended if it was in King's Bench.
Wow.
Or whatever else. They basically gave people like a 1 week grace period to for if you're filing something that it had to be changed, and then that 1 week grace period turned into 3 days because they just stopped accepting things even though it was supposedly in the grace period. So there was a whole lot of people who were like, what? Yeah, lots. And the other fun thing is a lot of these things are issued on like protected PDFs, the forms, so that you can't edit them easily. And it's like, guys, we're required to file it on this form. You won't accept it in this form unless it has King, and we can't edit the form. So yeah, it's still creating a little bit of headache, but they've largely sorted it out.
That's good. That's good. I thought maybe there would be like a grandfathering or something, but no.
No, it's they basically said anything that's already filed is good. You don't have to, because otherwise you'd have so many cases that you would have to like.
Yeah, that's what I wondered. That's what I wondered. Are they going to have to shift all of the Queen's old cases over to the King now?
It just changed midway through. So you've actually got lots of, especially civil cases that deal with like, that can be years long. There's plenty of cases where there's filings that are like the first filings are Court of Queen's Bench, and now the later filings refer to Court of King's Bench. And
makes sense.
We actually had laws that sort of people were like, oh my God, what's going to happen? People knew that monarchs died, like that this was a possibility. So we actually have laws that basically say things like everything is automatically updated. So the Court of Queen's Bench became the Court of King's Bench the instant she took her last breath, by operation of law.
Yeah, interesting.
So, yeah, I don't see how this is ever going to succeed. The attacking the evidence.
Yeah. Yeah.
And they note that because the question of whether the evidence in the record is a defamation case is sufficient to support a finding of actual malice is a question of law. The reason why it's a question of law and not a question of fact is because of all the stuff that we were talking about and that you were mentioning, is that it's basically just, is there some evidence? And because it's like a some evidence standard that it's a yes or no, that's why.
Yeah.
So they note the court does so by examining the facts pertinent to the jury award and exercising independent judgment to determine whether the record establishes actual malice with convincing clarity.
Yeah. So like that $5 million punitive verdict, that will be considered as part of the evaluation.
Yeah. Oh, this is, and they've got a big, note here about the standards. That's not really in dispute by anybody. Jury verdict was plainly wrong to ignore uncontroverted evidence of widely recognized forms of abuse. Now, this just makes me angry. Like the uncontroverted evidence bit makes me angry. Because, I mean, uncontroverted is relative. It's relevant to a credibility assessment, right?
Yes.
Joe says a thing happened. Nobody disagrees with Joe. Joe might be right. But you don't have to accept Joe's statements just because nobody else said a different thing, right?
Yeah. Yeah.
What
I think they're trying to get at here that they just didn't say is they're trying to say even Johnny's own evidence established things that would constitute abuse that was not physical in nature, given this, broader definition we're trying to get the court to adopt. And I think that's a legitimate type of argument to point out that, like, look, even if you give this guy, full credit for everything he said, there's still a fundamental problem here. That's very different than suggesting that what he said is uncontroverted. There was pretty much nothing uncontroverted in this particular case.
I mean, everybody was. I mean, this is a weird trial because everybody's credibility is at issue.
Yeah.
And even things that normally wouldn't be at issue, like just things like, is a picture actually a real picture? Word issue in this trial. Like, can we trust the recordings is a real issue at this trial. So
was this text message sent or was it received?
Yeah, normally these things are things that I'm just like, if my client is on video and, doing the crime and it's clear that it's their face and the crime, normally it's like, okay, you're done, just so long as it's admissible. Mm-hmm. But like, it's very rare that there's issues of like, is this actually a recording or is this a deep fake? But
well, to me, kind of the bottom line in all of this is it just so misses the point, because take the example of like reactive abuse, for example, is an alternative form of abuse. It qualifies as abuse. Dr. Hughes testified about reactive abuse and what that consists of. And so the point they're trying to make here is that even if maybe you called it reactive abuse, there would be things in the record that you could point to where Johnny called her names, or, Johnny was mean, Johnny, withdrew emotional. I mean, just whatever, that these things are abusive. But they are reactive abuse. And the question is, when Amber Heard wrote her damn op-ed, was she trying to claim the mantle of the queen of the provoker of reactive abuse? No, I kind of think she wasn't. So it's a complete red herring. This isn't what she meant.
Yeah, I was just about to say, like, do you ever think a jury is going to say, well, reactive abuse is going to count?
Yeah.
Like, this guy punched a woman every day, and I'm not talking about Depp, I'm talking about a hypothetical dude. But one day she, she flipped him the bird afterwards. We're going to call that abuse. Like, no jury's ever gonna. And the jury gets to make that call in evaluating defamation.
Yeah. Is that what she meant? Really? Is that what she meant in that op-ed, that after she had punched Johnny Depp and cut off his finger and, beat him multiple times and said all these awful things to him in the recording and, all the various things that she did, that's really what she meant in the op-ed, was that he fought back?
Yeah. And then, yet the trial court refused to provide the jury with an instruction on the full scope of what qualifies as abuse, because it would have actually been probably an error for them to do so, because now you're telling the jury what the statement
what the defendant meant. Yeah, it would be a comment on the evidence, or like essentially you're almost directing a verdict to some extent on, what the meaning of the op-ed was.
And I mean, that's really what they wanted. They wanted a directed verdict on what the result was.
Yeah, they did.
The jury was left instead to reason by negative inference based on the instructions it received on the elements of falsity and actual malice, and the instructions they got on you decide what the statement meant. Like they got instructions about that too.
And on the evidence that they heard, both the general evidence about abuse dynamics that they got from the experts in the case and the specific evidence of the abuse dynamics in this particular relationship that they got. So yeah, they can reason from that information, draw conclusions about what they think about it.
And then they note, as a result, the jury's verdict completely ignored uncontroverted evidence that Ms. Heard endured numerous forms of well-recognized non-physical abuse, including emotional, psychological, and verbal abuse. The jury's verdict was therefore plainly wrong and must be set aside. I mean, this is frustrating. When we look at that interview that they're again relying on, which is like, where is your affidavit? Like, and obviously it's not admissible where they are, but if it was, they'd need an affidavit, not just we read a news article. because, news articles can be false. We get defamation suits over news articles all the time.
Don't we, Rolling Stone?
Yeah. But, the jury gets to decide what it meant. And in fact, their own article contradicts this. Their own article includes the jury saying, we actually thought he was like verbally abusive to her, but we thought that wasn't what she was trying to communicate to everyone else.
Mm-hmm.
And therefore we found defamation. Like, this is contradicted by your own evidence, which isn't even evidence, but it's almost impossible to talk about how wrong this is without running into trouble. Because there's so many layers of wrong, and they all kind of run into each other. It's like,
it is. It's like a phyllo of wrong.
It's like if every layer of wrong was split up by a layer of honey, this would be a delicious dessert. Instead, every layer of wrong is spread apart by a layer of more bullshit. And yeah. Now, I saw some commentary online with people saying that they are admitting that she wasn't the victim of physical and essay. Well, first of all, an amicus can't admit shit. Like, they can't make admissions. They don't have standing to admit anything. But they can focus their arguments, and I think that them focusing their arguments on the emotional, psychological, and verbal abuse indicates that they feel that the other arguments are kind of weaker, like that the other sort of statements on factual elements. And that's not a great place to be when a lot of these same people are making public statements about, like, we think she was, physically assaulted. We think she was, SA. But here in their actual writing, they're focusing very heavily on he might have said some nasty things back to her.
Yeah, he called her Officer Squarehead. That's clearly what she was talking about in the op-ed.
Ms. Heard testified, and Mr. Depp admitted to numerous instances of vicious name-calling, manipulative attempts to control her career, accusations that she had been unfaithful, and threatening behavior. I don't know about the manipulative attempts to control her career. I think he basically was saying, hey, listen, you got to understand, if you do this stuff in Hollywood, you're going to find yourself in a place you don't want to be.
Yeah. And when his advice is maybe you shouldn't do London Fields, how manipulative was that? I suppose if somebody is bound and determined to jump off a bridge, it's pretty manipulative to, pull them back from the edge. But if she was bound and determined to tank her career, then yes, I guess it was very manipulative of Johnny to try to look out for her.
I mean, by this standard, I manipulate my clients all the time. Like, hey, you have a no contact order against you saying you can't contact your ex. Don't phone your ex. You will go to jail. I'm such a bad manipulator.
Could you try not lying to the police? Maybe just zip it altogether. Could you try that?
Yeah, if you tell the client, shut your dang mouth, sure, it's an attempt to control them because it's a good idea. Accusations that she'd been unfaithful and threatening. Do you really want to open up the unfaithful?
Yeah.
I feel like, because the question about whether an accusation of someone being unfaithful is abusive really connects to the factual underpinnings of that.
Exactly.
Like, if I go up to my wife and I say, hey, you've been unfaithful all the time, she hasn't. That would be abusive. But this is not a door I would open. This is a door I would
if she sleeps with every dude that she passes at the grocery store, then it's not abusive to point out that that's what she does.
Yeah.
And it's also not abusive to take issue with that if you're supposed to be in a committed monogamous relationship.
Yeah. If you're in a monogamous relationship and you walk in and, your husband is currently all the way in the neighbor, it's okay to say, hey, you know what? I feel like you're being unfaithful right now, and that pisses me off. Like, that's not abuse.
No, that is not abuse.
So,
and frankly, if I call you a bitch, it's reactive.
I feel like most people would have much nastier comments about that, right? So, and then they've got a bunch of, quotations. Um, some of them are contradicted, but yeah,
Yeah.
a lot of these are just, Amber's statements, which of course,
Yeah,
there's a
Amber said, Amber
reason.
said, Amber said, Amber said, Amber said. It worked in the UK. Apparently, some of them think that that's the kind of posture that will work here too. It didn't convince the jury. It's not
Yeah.
going to convince this court.
The appellate court isn't going to want to reverse the jury on facts.
No.
So, yeah. In audio recording, Mr. Depp called Ms. Heard a effing C. I'm sort of reluctant to drop the terms. In another recording, you stupid fuck. Okay. Yeah. People sometimes say nasty things to each other in relationships. That's not really like, it's pretty clear what they were. Yeah.
There we go. Officer Squarehead. Just stop it here. Okay. Reversed. No, we got to enter judgment for her. I mean, that's
Officer Squarehead.
I mean, it's done. We're done.
Other times, Mr. Depp would claim that Miss Heard was bitching and fucking barking. Well, I mean, I feel like Depp uses a lot of UK slang in some of his comments, and barking in UK slang is crazy.
Yes.
And yeah, I mean, this isn't language I would like for someone to use, but it's also certainly not what was intended by the op-ed.
Yeah. And, you also have to bear in mind that the language takes place in a context. It's one thing to use this language with your grandmother. It's another thing to use this language with somebody who, exceeds you in their ability to curse like a sailor. So,
yep.
That is kind of important.
Well, and here's the thing, right? I would not call my wife, a fucking C or whatever. But I might change my mind on that if she punched me in the face and cut my finger off.
Sure.
Like, I say that I would never call her those things because the range of behavior that she engages in does not include cutting my fingers off and, so forth. I might reevaluate my feelings in those circumstances. So, yeah, it's just nuts. Like, oh my God, he said bad things to the person who is like shitting in his bed, literally. Yeah. Normally I would use that as a figurative statement, right? Like, oh, so-and-so shit the bed, to say she literally shit the bed. Like, the facts of this, like what seems to be the actual, like what the jury seemed to have found, is so wild. It's just nuts.
It doesn't fall within the ordinary universe of normal relationships that I think most of us would expect that we would, if we were evaluating these types of statements in our own context, we are presumably, hopefully blessed to not have to be sorting that out in that kind of situation.
He accused her of having an this. I would not want to open that door, because now all of those like video bits of like her with random people suddenly become a live issue. Like, I had people saying, what about these videos? I'm like, I don't care if she's got, this, unless it becomes relevant to whether it's an abusive thing. Don't make that relevant. This is, yeah. So he goes on. I mean, they go on with like,
just the listing of the text that they have cherry picked, to support their position.
Yeah, and I mean, whatever, but that's how court cases go sometimes. And yeah, I'm just like, this is not what they need to get to. And then, as depicted in photographs, well, okay. First of all, we have issues with the photographs. I mean, once a photograph is at issue, it is like it raises all sorts of problems. Mr. Depp severed his finger during a drunken fight with Miss Heard. it's very difficult to conclude that that's what the jury found as a finding
Oh,
of fact.
yeah.
And this is one of the problems in terms of jury verdicts and appeals, because when you're talking about findings of fact, the findings of fact have to be, those are done by the jury.
Mm-hmm.
Those are in the jury's skull. And unless you're going to get a power drill and pull them out, so you can't say this. Like, you have to point to actual testimony, not just conclusory statements that the jury may have not found. So this makes me upset.
Well, it's just, it's the common refrain that we keep coming back to, that this is clearly not written for the court's benefit. It is written for the benefit of the press and the people on Twitter who are going to try to blow it up and make it act like, Amber has some chance of winning here.
Oh, yeah. And I mean, this just becomes, we haven't seen Amber's appeal brief yet. Mm-hmm. And I suspect that was very intentional. I suspect they filed it at the absolute last second. Mm-hmm. I would have been sitting there and I would have been like, I would have told the clerk, I'm like, file this, could you do me a favor? Have we built up any, relationship here? Yeah. Mm-hmm. Can you stamp this with filed as the last thing you do today, please? Mm-hmm. Like, just last thing you do. And yeah, it would have been. And assuming that you've got a good relationship with that clerk and they're willing to do that favor for you, it would have been stamp, filed, close window. Here, here's your filed copy. We're done. Yeah. Just to make sure no one else gets it before the weekend.
Which is interesting. Just from a strategic standpoint, what is the thinking behind that? Is it that they want to hold something back so that they can try to dominate the news cycle this week and next week? Is it that their own brief is so weak, that it's not going to be helpful? I had anticipated from the very beginning, when she announced her new legal team, and then we got those dueling press releases, remember? That there were already early signs of some disagreement and perhaps, differences in strategic approaches that were maybe going to be problematic down the road. And so one possibility is that she actually maybe has a brief that is kind of good because her attorneys didn't listen to all the shit she wanted to dump into it. But because of that, she doesn't get any satisfaction, out of that brief being filed and being in public. It doesn't say the things that she wants it to say. It's no good to her from a PR perspective.
My notion is a little bit different, but kind of the same, which is, I think the impression I got from Bredehoff was that she was getting too pushed around by her client. And
she had no client management at all.
Yeah. And I suspect that she's hired some pretty heavy hitters who I suspect have basically said, listen, you can have all sorts of opinions, but we write the brief. Mm-hmm. And, and so their brief, I think, is going to be focused on legal points, mm-hmm. and is not going to be able to do some of the crap that they do here, right?
Yeah.
Some of this stuff I would not do and so I suspect that they want this to be the news cycle because they can put all of the inflammatory BS into here.
Yes.
And then they have to actually file a real brief because they're hoping that they might win.
Yeah.
It's a long shot, but you don't want to bugger that away filing stuff like this. Whereas the Amicus, if this gets tossed, they're just like, okay, cool.
It doesn't matter. It served its purpose.
Yeah. This is basically spent at this point. I think that there's actually one more play that they have left on this. And I'll talk about that sort of when we sort of get through all of this. But yeah, you would accuse her of being unfaithful and having affairs with co-stars like James Frank. We have this on video.
In the elevator.
Why would you bring this up?
Yeah, perhaps that's a reasonable inference to draw, hypothetically.
And the thing is that if the appellate court, and the appellate court isn't going to be weighing this in, but if the appellate court is at all familiar with this case, they're going to be looking at that and going, I know I can't consider it, but I'm rolling my eyes real hard at this, at the James Franco bit. I would not have dropped Franco's name. What the heck? So they have here about destroying property as a tactic of abuse. Again, it's up to the jury to decide if destroying property is what they meant.
Yeah.
So not an exhibition of common couple violence experience in some relationships. What do they cite to on that? Oh, they cite to articles about this.
Yeah.
But you can't cite to an article on that. You need evidence on the record. Yeah, so they talk about also consistent with numerous factors scholars have identified to assess the risk of grave danger and death in serious relationships. So they go through all of those. The thing about these predictive things is that you cannot use them backwards.
Mm-hmm.
They don't work that way. So they specifically caution against this. So yeah.
Well, and again, all of this really comes down to the jury had all this. They got all of this from Dr. Hughes. So none of this is new.
Yeah.
And the court is going to have all of this as well because they will have Dr. Hughes's testimony in the transcript. So the jury was already well advised of everything that they are saying. They simply rejected it.
And even putting aside whether Ms. Heard believed she was abused, which is all the law requires in this case, do they not realize how much they're really pointing to the giant problem they have here? Like, the jury didn't even believe that she believes the statements that she's making.
Yes. The jury specifically found she knew they were false and she told big fat lies.
So, great. This is terrible. Virginia law, as well as national and international authorities and scholars, recognize Mr. Depp's conduct as abuse, which would be fantastic if it wasn't a defamation case.
Yes, and not a whole bunch of domestic cases that they've cited from back before the pre-no fault days, where you would have to establish grounds for a divorce or you would basically not be entitled to any type of spousal support. So cruelty was the ground that women would, use in this type of situation to be able to leave and, still have some entitlement to some support for that. Has absolutely nothing at all to do with defamation. It's just extremely bizarre. I don't even know that this is really a dispute anyway. Yeah, okay, Virginia courts recognize it. The jury didn't see it here. What's the point?
Yeah. And yeah, I think your point about the divorce aspects is really critical because I don't know as much. This is where it would be great. He mentioned that he's got a migraine. It would be really great to have him on because he does Virginia divorce stuff. But
yes, Rob, where are you?
Here in Canada, we had this lengthy time where you needed sufficient stuff for a divorce. Mm-hmm. And so they would find cruelty based on anything. This person wouldn't put the toilet seat down, done, divorce. Because they recognize that these people who hate each other shouldn't be required to stay in a marriage. It's just that the law hadn't caught up. And
what's interesting about these particular cases that she's relied on too is that I went through and I looked at all of them. And with one exception, they all involved physical violence as establishing cruelty. So it has nothing to do with their point about they're basically pointing out some dicta in some of these opinions that doesn't have anything to do with the case. The very first one that she cites here, this Hoback one that's incorporated into Hotchkiss, is a situation where they found cruelty was not established because she hadn't established, she certainly hadn't established physical abuse, but her complaint was basically that they argued about household things like where the furniture should be and who was going to do what chore and stuff like that. And he was apparently
sounds like a relationship.
Yeah, and he was not all that interested in her sexually. I was like, well, welcome to marriage. Sorry. and so they specifically, point out that these are not valid grounds to establish cruelty. So but they did find that she did not desert the husband, that he was mean enough that it justified her leaving. But just a very bizarre bunch of cases to be relying on here.
Oh, and it's funny, the Canadian rule actually resulted sometimes in people doing like intentional adultery, because otherwise you had to have like this period of separation for 3 years where people are like, I want to be divorced now. So you'd get like, guy goes to the bar to find a woman and then like, basically tells his wife, I'm going to be in the middle of things at like midnight. Please come home then, so that they could get a divorce faster. This is, I mean, yeah.
I think that was fair. I mean, I think that was fairly common for, amicable types of situations. I kind of vaguely recall that that's sort of what happened with Wallace Simpson and her husband, because she didn't actually want to be divorced, but Edward wanted to be with her, and her husband ended up going and having an affair with somebody else, and so yeah, he ended up filing based on that. So it seems like there are situations where people just kind of work it out that they're going to be able to skip through the formalities by just go ahead and gin up some dirty laundry.
And some people in the chat noted that apparently I skipped over one of the lines I wanted to cover, where they mix up the fingertip missing and the
Australia and Hicksville. Yeah,
it's like
Australia and Hicksville. They just lumped those together. It's just part of the ever evolving story that we've gotten from Amber Heard. It's never a consistent retelling. So why would that not hold with the briefing?
But I mean, if you're an amicus coming in trying to say, hey, look at these facts, it doesn't support everything, you want to at least be clear that you understand the facts. Like,
that is a very good point. If your entire argument is based on the facts, you should probably be accurate with them.
You want to be super precise and beyond reproach, because, if the other side can do things like pointing out several places where you screwed it up, you're no longer helpful. So yeah, they're going to continue on about, angry words, coarse and abusive language, humiliating insults, and annoyances in all the forms may as effectively endanger life or health as personal violence and afford grounds of relief to an injured spouse. Annoyances in all the forms that Nellis can suggest. Yeah, that seems like a very difficult thing,
What's interesting about this too is that this is a situation where, again, because this is not good context. It doesn't carry over well to defamation and abuse and what we're talking about there. This is a situation in this case where the actions did not constitute cruelty. It just meant that when the wife left, it didn't constitute desertion. So she was not at fault for the end of the marriage. That's what they mean when they're saying afford grounds of relief to an injured spouse. It's okay to leave if your husband is intolerably mean to you. It doesn't mean that, that he's therefore a bad guy.
And literally no one disputes that they were able to leave each other here. So yeah. Yeah, wife testified that she suffered both verbal and emotional abuse from husband during the marriage. Based on this evidence, we cannot say that the trial court abused its discretion in awarding wife spousal support. Abused its discretion is interesting language there, isn't it?
It sure is. Yes, it sure is.
Like, that's court language for, we think the trial court was wrong, but not so wrong that we're going to go back and fix it.
Yeah.
So this is like the appellate court saying we kind of disagree, but all of this is irrelevant, because what that statement means is it's a defamatory statement. It's the meaning of it. It's not like, does she trivially fit into a technical definition of abuse? It's, does the actions that actually happened fit into what she was communicating to the public?
Exactly.
So, and, to give an example for the chat who might be going, well, I don't know. Let's say, like, Rob and I last night on Lawn Lumber, we're talking about cheese pizza as an acronym for, so if you describe somebody as really liking cheese pizza, and everyone knows you mean bad pictures,
Mm-hmm.
then you're not going to be able to go away and say, well, look, here's all these pictures of this guy eating pizzas and they have
Yeah.
cheese on them. So it's a technically accurate comment. The
Look,
jury's
guys, I'm
going
going to put a recipe into evidence here.
yeah. Like the jury gets to decide if you meant actual pizza or if you meant bad pictures. And if they
Yeah.
decided that you meant bad pictures and you were lying, then they get to make that, determination on defamation. So all of this is completely irrelevant.
Mm-hmm.
And it just keeps going.
Just on and
And
on and on and on and on. And this is exactly what the court is going to do with this if they even give it this much treatment. Okay, if they haven't shredded it on page 3, like we already said, they're probably going to do.
yeah, embarrass or make fun of you in front of your friends or family. Like nobody understood that to mean what what they were talking about here. So yeah, they just keep going.
Yeah.
Yeah, it's yeah, and like this comment about, whoring herself out is the language that was being used there. I mean, unfortunately, women do have some tough choices to make in acting,
Mm-hmm.
which is sometimes it can be easier to get roles if they're willing to show more, more skin. But then that can really create a self-terminating career impact, right? Where you,
Yeah.
oh man, they keep going here.
Yes, they
Um,
do. Just on and on and on.
where it's like, okay, you've done too much, sort of nude work. We're not going to consider you for more serious roles, right? Um, I mean, if I was in a relationship with somebody who was a serious, I might be going, do you really think this is good for the career? Like, don't do it. London Fields, bad idea.
Yeah, it's going to be probably a little bit limiting.
So,
Which is fine if that's what you want to do with your career. It may very well open up doors in that way. But if that is not your career objective, then you need to evaluate the path that that you start down.
well, and I mean, if you're married to, a Twitch streamer and they're like, hey, I can make tons of money doing hot tub streams. It's like, okay,
Yeah,
cool.
yeah,
But is like, what will this affect your career as, right? Like, what if
exactly.
Twitch bans you for the hot tub stream is a reasonable conversation for people in a partnership to have. So yeah. I see people noting taking a commercial used to be considered whoring yourself out if you were a film actor. There
Yeah,
are
I can see that.
still, well, there's still tons of commercials that are recorded for like the Japanese market with restrictions on them in the contract that it will never be played in America.
Christina, deep dark secret. We attorneys also talk about attorneys who whore themselves out.
Yep. Well, and I mean, we talk about witnesses, like expert witnesses.
Mhm.
Um, you know, I've there, when you see expert witnesses, every time they ask, hey, how much are you getting paid? What's the suggestion?
Mhm.
Right. And
Mhm.
so I have rejected expert witnesses who cost too much, not because the client couldn't pay them, but because if I'm paying like 30 grand a day for the expert witness, um, I'm going to get savaged by the court. They're just going to think it's a bribe, and that's not good. The verdict discourages domestic abuse survivors from seeking protective orders. No, it doesn't. This is just, I feel like this is lying to the court
Yeah,
in a way that's like, you ever like dealt with toddlers? And, I don't have kids, but,
I
and I
don't
don't know if,
either.
but like you've got like a toddler and they'll break a vase, or like the toddler eats a cake, say, and the toddler is covered in cake. And they're like, it was the dog. And you're
No,
like,
I
but
didn't. Yeah.
you've got cake all over your mouth, all over your hands. And like, you know, this is that kind of lie. Like, because the court knows that the protective order is covered by this privilege.
Yeah.
Um, so
And that
Yeah.
any reasonable attorney advising their client would be telling them, yes, you need to be truthful. You're making a statement under oath to get a protective order. So you can certainly be exposed, like we've been talking about, to perjury, false statements, things like that, if you aren't honest. But you
Yep.
absolutely are not at risk at a retaliatory claim for defamation. You are protected by the litigation privilege.
And I mean, there can be issues about saying stuff outside of court, but outside of court has always been risky, right? Even this video, right? If I go and say something like, just random person from chat here, and I'm picking Lindsay because they're always in my chat and Lindsay's lovely. But if I said something terrible about Lindsay, and suggested it was a fact, and I'm not even going to come up with hypotheticals because
Okay,
Lindsay's a
that's
lovely person.
hilarious comment.
Yeah. Counsel, we talk about our colleagues swearing themselves out to remind them to issue receipts to correctly report taxable income. Nice. We just, like doing this video is risky. When I have clients who need a restraining order or something, I'll say, like, you can say whatever is truthful in court. Outside of court, you just keep your mouth shut.
Yeah.
And if the media for some reason came up to say, hey, can you talk about this? You say, no, bye.
Yeah, and that's one of the sort of undercurrents in this case, that it's interesting to sort of see nobody really address it head on, and that is the litigation of these disputes in the press. That's why we had these issues in the first place, because Amber Heard had to open her big fat mouth, basically anytime she had anything to say. And so then that puts Johnny in a position of having to protect himself and respond. So Adam is talking to the press, and this is exactly why that's not how things should be going. If you don't do that and you just use the legal system that is set up to adjudicate those disputes, you will be fine.
They essentially had a thing where it was, let's walk away from this and both of us will keep our mouths shut. And you know what? This got ugly. We're just going to move on. And you know what? When they originally had when that statement originally came out about like Depp and Heard, I was like, all right, it looks like there was some contentious stuff in this relationship, but they're walking away from each other and they're being mature. Cool. And if that was it, we wouldn't be like looking at any of this. But like the reason why my clients, why my, domestic assault files don't end up having these defamation cases is that in none of them have the complainants hired a PR team. Like, you don't want to end up in this. Don't hire a PR team. Don't start writing newspaper articles. Don't just live your life. And, and you know what? You'd be having no problems writing a PR team and writing newspaper articles and whatever else you wanted if you were even close to honest.
Yeah.
Because, I mean, juries are far more likely to be inclined to believe the person alleging abuse, typically.
Yes.
And
juries don't like, in general, to think that people are lying. It's very, very hard to convince a jury that people are lying. Jurors are normal people. They tend to give people the benefit of the doubt. They take them at face value. They assume their intentions are good. And being able to overcome that is very difficult.
Yeah. So, and Mr. Depp responding when asked why he was here today, talks about the, the restraining order. Well,
yeah.
I mean, yeah, that's part of the story, right?
2 years ago, that's how we understand what she was talking about in the op-ed.
Like, if I have, let's say I've got a difficulty with a coworker, right? And, so I end up suing that coworker. They might say, why are you here today? And I go, well, 10 years ago, I took a job at, Widgets Incorporated. It's not that taking a job at Widgets Incorporated is the key bit of this. It's just the start of the story, right?
Yes.
So, Like the court knows all of this about the protective order. So all of this is just not going to go anywhere.
Yeah, no.
This is all like this big, extensive. There's so much of this where you just look at it and you're like, I don't want to go through this line by line because it's just gibberish.
There's just nothing there. Yes, it's just fluff. It's just fluff. We know that protective orders are fine. That's not the issue. The issue is whether somebody needs to fear a defamation suit if they file a protective order. And the answer to that is unequivocally no.
Yeah, it's not even like it's not even like an open question. It's just an absolute no. And in fact, the only thing that's going to deter people is people like this making these public statements, that it will deter you because nobody else had that notion that they were going to get sued for defamation by filing until they start putting these fake notions into the world. Verdict emboldens retaliatory defamation lawsuits, further chilling victims from seeking relief. Well, right now,
seeking relief, seeking what relief? Not being able to yammer to the press about their fantasy abuse. That's going to be chilled. This is a problem.
The jury found that she lied and defamed him. In fact, we should
it kind of makes it the anti-retaliatory case.
We should be emboldening people. Like, this is basically saying people with a legitimate claim will come to the court for relief.
Yes.
On their legitimate claim. Like, this upholds the rule of law and confidence that the law will redress actual malice. Good. Like,
yeah.
This whole section is basically summed up by saying, excellent.
They would have such a stronger argument, really, for this, in my view, if Johnny had lost the case. Because if he had filed the suit and you'd gone through all of this expense and the personal invasion and the difficulty and stress and everything, and then the public exposure in the trial, and then he had lost it, that would be a situation where somebody would be like, look, the process is the punishment. And so, yes, there should maybe be. That's why there are anti-slap, rules that are so much more protective than Virginia's in a lot of different places. Now, granted, some of them go overboard, in my opinion, but that's the whole point, is to allow them to get thrown out early so that process doesn't become the punishment, because that would chill people from saying basically anything at all if you're going to potentially be subject to a frivolous defamation suit. That you still have to go through the trouble to defend it and win it. But that's not something that people, want to do, look forward to doing.
These would be excellent submissions on punitive damages. Like, if the court had said, listen, we find that punitive damages are appropriate, or we want submissions as to whether they're appropriate, or, we are asking how much, then you can say, you need to hit this hard, right? Because, but they're not at punitive damages against Depp. They're in the opposite universe of punitive damages against Depp. So,
yeah, for sure.
You can't call this retaliatory when he's winning. This
whole argument too, that more people are filing defamation suits in the Me Too era, to me, that is such an own goal. Okay, like, you have gone so far to the extreme in terms of encouraging, abuse hoaxers to not use the legal processes to just smear people in the press, in their social media, et cetera, use the cancel culture, use the college Title IX process, all of that type of thing has been encouraged for a decade now. And we would expect more defamation cases, because you would expect that if false accusations do take place, then if you just get more accusations in general, you're also going to get more false ones.
Well, and the other thing is, if they were only getting false ones and everyone was losing these defamation cases, that would restrict the people would stop that as a thing.
Sure.
But when they're winning, it's because they're winning on the merits, right?
Yeah.
It's like,
yes, they are not winning because of patriarchy.
Like, if I say, listen, we're getting more convictions for break and enter in our society. Therefore, we need to acquit more people for breaking and entering.
Mhm.
Really, it's that we should have fewer people breaking into things, right? Like,
Yeah.
they seem to assume that the people bringing this, like, a lot of the problem with this brief is basically it starts off with, if we begin with the assumption that we are correct and this is a massive injustice, then the
Yeah.
following becomes true. And it's like,
Yeah.
but you have to do the homework to get there first.
Yeah. That assumption is carrying a lot of water here.
Yeah. And over 100 defamation lawsuits have been brought against individuals. Okay.
It's meaningless. Like I said, if there have been 100 times more claims made, then you might expect that. Of course, there would be more defamation lawsuits.
I expect that there was an increase in claims over trampling injuries
Mhm.
at, you know,
The Travis Brown thing or Travis Scott
yeah,
thing. Yeah.
it's probably not something that happens a whole lot, and then suddenly there's just like a whole lot of them.
Yeah.
But that doesn't mean
It
that
does.
they're
It
like,
happens. They're like social contagions. It happens.
yep. Well, and the other thing is sometimes you get like this increase in things because a whole bunch of things happened. But yeah, since
Sometimes there was a conference that somebody put on about like a specific type of lawsuit that a bunch of lawyers went to, and they start filing a lot of that type of lawsuit. I mean,
well, another one that you see is somebody like, it's not even a conference. Sometimes it's like one lawyer pushes an issue and says like, if you go back in time, like you'll see now there's all these like, have you been anywhere near asbestos at any point in your life? Well, then you
yeah,
may have mesothelioma and please call
yeah,
us. At one point, asbestos was considered basically the safest stuff you can put in your house, which is why if you
mhm,
have a house from the 50s, it's probably got asbestos in it somewhere.
mhm,
Um, but some lawyer basically said people are getting cancer from this stuff and started filing lawsuits and lost a bunch of those lawsuits before they started winning.
mhm.
And then only once they started winning does it take off, because people are like, well, if you're at the point where it's like, hey, look, 100 people have filed this and everyone has lost, you're probably not like, well, I'm going to sign up to be 101.
Mhm.
But if the last 100 people have won, you might. But that doesn't mean that like asbestos lawsuits were frivolous just
Sure,
because lots of people win them. Um,
sure.
and Christina Peichels in the chat points out something really relevant here that I was going to get to here. Since 2014. Yeah, I feel
Yeah,
like that's an interesting timeline given the 2016 divorce.
yeah, it is, isn't it?
Like, hey, it's been really picking up since before Johnny Depp had anything to do with this. So they talk about economic abuse and financial resources. Were those at all relevant here? Or are we just saying that Johnny Depp should lose to help other people? That's not how the
Yeah,
law works.
yeah,
This basically comes down to A, he really did it. B, he should lose to help other people.
mhm.
And C, I don't know.
I think you pretty much covered it with 1 and 2. Basically, we insist that he did it, and even if he didn't, you should still lynch him.
Yeah, it's nasty. This will create chilling effects, fosters a climate of second guessing victims. We should second guess everybody, because when somebody's a victim after a trial, like
Yeah.
you can't
You know
like,
what's you know what's at the heart of the scientific method? Is skepticism.
yeah. This is in fact the heart of the whole court process, right? Because
Yeah,
this
because
is why
credibility is always at issue in a courtroom. Always. It doesn't
this
matter
is
what the case is or what it's about. If you end up in court, your credibility is at issue.
yeah, this is why court is a thing, right? So yeah. We've got hey,
Oh,
how's
I'm
the
so
headache?
glad that that Rob is here. I'm unfortunately going to have to tag team out with Rob in like 5 minutes here, but I was feeling really bad about like leaving you all by yourself. So thank you, Rob. You're a bro.
I came for the one-liners. You guys were issuing with so many zingers.
We need to do more of these because you're wonderful, and I'm a big fan of your. There's so many times where I'm like, I have thoughts on this, but before I do my thoughts, I want to watch Andrea's video. And in a few circumstances, I've been like, I have thoughts on this, and I've watched Andrea's video, and I'm going, I'm not gonna anymore because it's covered. Like it's, I can't do it. Like
I will point people in direction of the content I think is well covered. So for the Rust stuff, I was like, go look at Ian's stuff. For some of the Depp stuff, look at Andrea's stuff. Like, if it's covered on YouTube and I don't think I can do better, I'm happy to point people the right direction.
Well, and the other thing I will say, and I've said this before, but lots of lawyers are really good when they've had the chance to really prepare something. And you are in that category. But the rarer category is the lawyers who I think have really prepared something. When I ask a question off the cuff that is just some random question, they're like, well, in this case, back in, the depth of your like knowledge and insight in things is just, I'm always like, sort of lean back. I'm just like, yeah. So
thank you. You guys are making me blush.
Well, I'm a huge fan. I would love to do more of these. So, yeah, I just wanted to say so. So,
well, thank you. I really appreciate it. I, as you know, I have been following this case for years. I was the law tuber who came in having followed the UK trial and knowing all the backstory, and so I had a really good prediction of what y'all were going to see, which is part of why it was just so fun for me to have this group experience with everybody and watch you all take the journey down the rapids that everyone has come to this case goes down. So it's been a blast. There's room for everybody. My style on my channel is much more, I don't stream. Not saying I wouldn't, I just don't do it for analysis. Because I do, like Ian said, kind of like to, prep things, and I, have lots of, post-production stuff that I do. So I'm not like your breaking news channel. I'm not like your quick reaction channel. I do try to be a deep dive channel. And that's what works for me. So if that's what you're looking for, come on by and let me know what you think.
Well, and you mentioned that you were I came at it late because I actually was like, this trial is uninteresting from the start. That was why I wasn't like everybody was covering Depp, and I was like, why? Like, he's got no chance. Like, the legal standard that he had to meet, I'm like, this is so high that it is just absolutely fatal at the outset. And then as I was watching and like popping onto some of the live streams just to really more to hang out with friends than anything else, I was like, holy crap, this is turning into a case. Like, there's actually, he could win this. And then I was like, and then it becomes interesting. Like, it's one thing, nobody wants to go pay to fight, like to watch Mike Tyson fight, Stephen Hawking. You're not going to watch.
No.
That's not a competitive billing. You just kind of feel bad watching that. But when it's, when it's actually, a competitive thing, you're like, ooh, now I'm in. And so I came late to it, and I kind of feel bad for that. But it was like,
don't feel bad. I mean, I remember the moment I was on Legal Bites, and Rick Hogue was on the day that they first played that audio. Tell the world, Johnny, tell them. I just remember it's jaw dropping. That was the moment the case changed for him. He saw at that point. I felt very vindicated.
Well, and then just watching Andrea the entire time, you can tell it's like a kid the day before Christmas. Like, I know that you're about to get here. Like, you are so close. Like, we're about to get to this one thing. And Andrew's like, did you see it yet? Did you see it yet? Did you see it? And we're just like, what just happened?
Yeah, it's like, the parents at Christmas. You're waiting for the, as the kids go, and you're like, are they choosing this present? Oh, I want to see their reactions to this one.
Yeah, it was a blast. I had a great time.
I mean, I don't want to be a Depp channel, but it's a fascinating case. Like, even if I'm not, so that I keep, like, I didn't know if I was going to review these, and then I read them and I was like,
that was the same thing, Ian. Like, I was like, I'm not going to review these. They're amicus briefs. What's the relevance? Why does it matter? And then I read them and I was going, oh my word. Like, are you kidding me?
I was actually going to do coverage of the GWAX lawsuit. And I was like, that's what I really want to do. I kind of put up a poll on the amicus briefs because I kind of thought that the reaction would be, it's been done. Like, Rob's covered it. Emily's covered it. Lots of people covered it. And so I thought they'd be like, we're good. And I got people going, nah. And then the suggestion that I really liked was, you should bring Andrea on. And I was like, so I was like, okay, let's look at the brief. And I'm looking at the brief and I'm going, oh man, I want to talk about this now. It
just keeps on giving. The case keeps on giving. I'm following the insurance litigation as well. That is going to be fun. If they don't settle that, and it doesn't look so far like they're going to settle that, that's where all of the skeletons are going to fall out of the closets, and I am going to be there for it.
I don't think they can settle that one.
Like the stuff.
Yes,
I don't
exactly.
think they can, because if they settle it and it, I mean, she's going to end up losing coverage. That'll be the settlement that they want. And then she's like, her appellate lawyers will be like, their next filing will be, we are no longer counsel on this file.
Yeah, we're out.
if I am her attorney, I'm telling her to go ahead and let the coverage, just let it go. You do not want to proceed. The thing is, we say all of these things. She can't not litigate. She doesn't have it in her. She cannot not litigate. And not only not litigate, she can't go to this level. These amici they're just an extension of her. It's like, I saw this come through and I'm going, these are just amicus briefs. They're going to be largely ignored. And it's not just that they're going to be there. I still think they're going to be largely ignored, but it's just an example of how far she wants to litigate every single point.
Strategically, I think she's got a great way out because of the insurance litigation. Because I bet if she went up to the insurers right now and said, you know what, I will settle this for we all sign NDAs. Nobody ever talks about this. I don't have to pay you back anything, but you don't have to pay anything going forward. I bet the insurers would be like, deal.
Here's a check.
Yeah, for sure.
And I think that, and then she can say, listen, I wanted to litigate the hell out of this. But the insurers cut off my coverage. I don't have the money anymore. I have to walk away. And I'm really sad to all of my fans. This is a heartbreaking moment, but I don't have the money.
I know both of you are heartbroken.
Yeah. I mean, but this is the statement she could make, right? And it lets her walk away and still spin like whatever things, but she can't. And it's the same.
She can't.
It's the same thing we saw in I think the trial, and I've sort of articulated this theory before. I think that basically she was bullying Bredehoft, but because she was pushing Bredehoft around, Rottenborn was given more room to make arguments. And so when you see like Rottenborn coming in with the more legal arguments, like, you gotta let's make the First Amendment argument. I'm like, this is because he's allowed to a little more freedom to do lawyer things. And then Bredehoft stands up and is like, she is the most abused person of all time. And that's because that's Amber talking through Bredehoft. Yeah. That's kind of my take on that. So yeah, it's no,
Amber reminds me, I mean, I've had a lot of clients that are, not dissimilar to Amber in many ways. And one of the patterns with her that I've really noticed is this shotgun, approach to her grievances. And so one of the things you learn as a lawyer, you have to pick your battles. You cannot, you're not guaranteed a perfect trial. You are only guaranteed a fair trial. So it is understood that there are likely to be mistakes along the way, but most of them are going to be meaningless. They aren't going to have any substantial effect on the outcome. And so that's built into the appellate standards and in the review process. So part of being persuasive as an advocate is sorting out the wheat from the chaff. When you have a whole variety of complaints, you need to prioritize and focus on the ones that are most likely to get you the outcome that you're looking for. Amber had a winnable case at trial. I've said this over and over and over again. She had a winnable case at trial, but for the fact that she is Amber Heard and she can't just take the advice to, accept the expertise of the people that you are paying for their expertise. Don't insist on, no, we have to muddy the waters with all of this grievance chum. It's just, it doesn't work. It makes you look petty. It makes the court look side-eye, at your good issues now because you've diluted them with just all of this crap that you've dumped in. It's the same thing that she did at trial. If she had just sat back and shut her mouth and never said anything and rested on an argument that, relationships, they can be ambiguous and there's a lot of gray area and perceptions are what they are. There's, I think, a decent chance that the jury would have thought, that's okay. But she had to get on the stand and show everybody what the problem was.
It was the counterclaim.
It was the counterclaim.
Drop that pile of garbage. Drop that heap of garbage. And almost, I would say about 70% of the legal arguments that she was trying to make on evidence issues would have gone in her favor. Drop that heap of garbage and proceed in defense. And I think you've got a winnable defense.
The other thing,
the counterclaim killed her.
Yeah.
If she'd also just been, I actually thought she might drop the counterclaim at the end. And then I was like, oh, guess not. Like I posted on Twitter, I'm like, you might see the counterclaim go away. And then I was like, well, wrong about that. But I've been wrong about a lot of their strategy predictions because their strategy makes no sense to me in a lot. But like, even just her claims, right? Because she's saying that she's got good, and the last brief we looked at was basically saying she might have good claims about being emotionally sure. Those just tend to go away when you start also making a bunch of BS claims. Like he was dragging me across broken bottle glass and then I was doing ballet the next day because I'm freaking Wolverine. Like, like
exactly. No, it would have been a great argument to take at trial. Another argument that would have been good, potentially to work with at trial. Yeah, I have this borderline personality disorder condition that does tend to affect my perspective. I might have been wrong about these things, but that's what I understood and thought and felt.
And
that's a pathway out of actual malice, but there's no way she would ever lean into that.
Well, the thing is she can't. Like that. That is fatal because at that point, if she says, "Listen, I'm so mentally ill that I just come up with things like this," it's like, great. We can never put you in a room with talent again because, like, Jason Momoa is gonna have a better career than Amber. He's not my favorite actor or even in my top 10, but he does good work, right? And
people want to see him.
People want to see him because his acting is okay, and he's a pretty impressive guy.
You can say it. Like he's literally built like a Greek god. Like, and women will go and see that. Period. End of story. It doesn't matter if he can string together 2 sentences. People will go and see Jason Momoa.
Yeah. So, but so he's worth 2 movies going like forward, millions and millions of dollars. Like, Marvel probably has an insurance policy on Jason Momoa based on we have future contracts. Therefore, we have an insurance policy in case he gets hit by a bus. And please don't. But, if he does, we want to recover the money that we would have.
Good luck to the bus.
Yeah. Yeah, Jason Momoa's pecs. Challenge accepted.
Good luck to the bus.
You can't then say we're going to put that guy who is worth so much money to us into a room with a person who might make up allegations that destroy his career.
Yeah.
You can't put a director in the room. You can't put a producer in the room.
Nope.
You can't even put a grip in the same room as her. And yeah, it's just, Aquaman seems like it's pretty much designed for Jason Momoa because it's guy not wearing a shirt for most of the movie. Like, yeah. So, yeah,
guys, this has been awesome, but I'm gonna have to jet at this point. I've got some hungry dogs. So thank you for the invite, Ian. This has been awesome, and we definitely need to do it again.
And your channel, Andrea Burkhart Law, check it out. She's gonna go through this, and she's got insights. Listen,
there are
I'm gonna
plenty
watch
more briefs to come, so we will have ample opportunities to do this again.
Excellent. Well, till next time.
Thank you, guys. Appreciate it.
Yeah,
take care. Bye.
And we've got a bunch of super chats. I will get to all of them. So all of these super chats I will get to. So I've got all of them saved just so that people know. We've got a whole other brief here.
Yeah, let's get rock and rolling.
Because, this one I actually think they do a better job on their table of contents than the other one. Because Andrea made this point, and she's right. A table of contents is the first thing that they see, and you get to this is an exercise in persuasive writing.
Mm-hmm.
You want your table of contents to be convincing to, and you don't want the person who's reading your table of contents to already be going, really? So the last one really failed at that because their table of contents, the arguments were clearly not legal arguments. So this one starts off with, introduction, talking about various things. Okay, that's good. Abuse can refer to many types of actions. Cool. That's a losing argument, but at least it's not phrased in a way that
it's not phrased and it's phrased appropriately in this setting.
Yeah. Intimate partner violence is a significant problem in Virginia and the US. Perfectly sensible thing to put in, nearly a quarter of female victims of intimate partner violence do not report the violence because they fear reprisal. Okay, now we're getting a little weaker. Verdict in the present case, this one is where we're getting to the weakest.
And I've stopped reading.
Yeah, this is where we're done. Like, this is where it's like, okay, if this is your conclusion, I'm not interested. But they get into stuff about protective opinions, subjective perspective. Like, all of this is worth.
You mean this one actually talks about the cause of action of defamation?
It actually talks about the law. Like, and we are, somebody in the chat notes that we are past 2 hours, so cursory words okay. So I have a comment on the last brief, which is, what the fuck were they thinking? Yeah, all right. Carrying on here. And it's kind of weird that I assume that this is Virginia style, where you put all the court cases at the beginning.
Yeah, you have to cite the first appearance of the case. And it's done alphabetically, then you cite the first appearance, then you have to cite the other authorities.
But this is all done at the start. Different courts have different rules on this, and I kind of like where they put it at the end. Because at this point, you just skip past all of this. You don't really care about what these cases are for until you actually see why they're being cited.
That's to the law clerks. Like, hey, this is what you need to start reading. Pull these cases, read the cases. When you see it, you may have read the case. The law clerk
can pull the tail out of it. So, see Trufflehound saying, hands down, best flight ever, listening along to this. And now there's another brief for my drive home. Jackpot. This has a lot of pages, so we're going to have to go fast because somebody's saying how many pages of what the act 62. We're going to try to go fast. So identity and interest. I thought that this was a little strange, but this is, as mentioned, Virginia rules. So
now, interesting point here. They join to protect their ability to engage in reporting facts and opinions regarding important current events. There was no lawsuit against Washington Post. This is against Amber Heard. The Washington Post was not sued in this. So tell me again how you're afraid that this verdict is going to hurt you, because it's not.
And I mean, to a certain extent, you can do a fair bit with reporting this is something somebody said, So long as you're careful about your phrasing. Like, we're not endorsing this as correct. We are endorsing, like, we're reporting on the report. Is something you can often do. Now, talk to a defamation lawyer if you're thinking about writing anything particularly spicy that someone else said. But, I mean, the other thing is Washington Post has a real easy case on this. Amber Heard told us these things, and we believed her because she was nominally there. Done. You've, ticked over the actual malice standard, or you've, pushed yourself behind that standard.
Good job. Yep, you're good.
Yeah, I mean, that might not be enough if it wasn't Johnny Depp, but was instead, Joe Boggs, who runs the local bakery, because he's not a public figure, and he's going to be a lot more hurt in his ability to respond.
And points 2 and 3, see you later. Get out of here. Please leave the chat. Just join to address significant diminution of reporting.
Not a relevant consideration.
You're wrong. 3, just. The thing is, this was a better written brief, but the basis under which they wrote the brief is dumber.
Fair. Although the last one relies very heavily on a juror said some things as reported by a newspaper article and no affidavit, and the newspaper article doesn't even know who the juror, doesn't even tell us who the juror is.
Yep.
Which, I mean, if you want to introduce new evidence, sometimes you can in a brief, but
no. If you
not
can,
hearsay,
you better dedicate 1/3 of your brief to explaining the authority under which you are trying to introduce something that you had at your disposal at or near the time of trial that did not result in a motion to reconsider being granted. You better have your damn authority lined up.
Oh, absolutely. And I mean, you better basically say, this is new information. It's super relevant. It super changes everything. And it's super reliable. And it was unavailable at the time. And, not so. Yeah. You can't do that with a newspaper article. You just can't.
Nope.
Move for leave to file this brief in the accompanying motion, which they leaked the brief, but not the motion. Interesting.
Yep.
They're gravely concerned that it casts an enormous shadow over First Amendment law, intimate partner. Now, I mean, the First Amendment law aspect this is actually an argument you can make, right? To say, hey, listen, we think that this is putting First Amendment law back, but you can't say the verdict should be thrown out because it sends the wrong message. All of this is arguments that are foreign to law.
I know.
Yeah.
It's okay. You can read it.
All right. So the verdict will have a chilling effect on a wide range of commentators, like the people who weren't sued.
Yep.
Specifically, the verdict has already and will continue to deter women who have been abused by their partners from reporting such abuse, whether it be, among others, mental, psychological, verbal, physical, emotional, or sexual abuse. Well,
what's funny? It feels like there should have been a citation there, like a little footnote to say, hey, this is where I get the authority to make this fucking statement.
This is the introduction, so it's common that they might not, but you do need a thing to say that it actually is. I want to see a citation for this somewhere, and it better be to actual studies, not just somebody's opinion on the studies. But also just the verdict itself, that the verdict itself has bad impacts is not a reason to overturn something. It has to be the legal principle. And I see Robin Runkle speculate, why did they release the brief but not the motion? Because this is for PR.
Yeah.
That's why.
Everyone's kind of reached the same conclusion. It's been kind of funny watching a bunch of the people streaming and reading these amici. Almost every single person has the same exact initial opinion, which is, no date stamp. That means this was leaked. PR.
Yeah. It's just nuts. I see Cassie Jaskula saying totally off topic, but will one of you cover the wrongful death lawsuit that Michelle Dauber was apparently just named in? She's deleted her. Until I see the lawsuit with her name on it.
Yes, I need the pleadings. I have seen the articles. We need the pleadings.
And the articles I've seen haven't actually said Dauber is named.
Correct.
She may not be named, and so I am not sufficiently confident on that, as a true fact to report it as a true fact. I don't know that that's true right now. So she might be, she might not be. I think it'd be weird to name the author of a letter, even if she was the author, and I don't know if she was, because a lot of those letters are form letters, right? So, yeah, I just don't.
I want to see her name in the pleadings, and I want to see the allegations specifically tying her to that event.
Yeah.
Yeah.
So until I see those, not doing it. People have speculated that's why she's deleting her Twitter. It would be a good reason to delete her Twitter, but she's got all sorts of other reasons. I mean, she stated one thing is that she's getting a lot of abuse, and she does because she trolls people a lot. And, when you keep kicking the hornet's nest, you may get stung by hornets. That isn't to condone it. It's just to say it's expected.
This is a tangential discussion that takes us off focus of the brief that we're intending to cover.
Yeah, and Dauber said that she would leave Twitter after the project was done. She's got all sorts of reasons. All right, so not only was this a highly publicized trial, but it became a social media sensation, possibly in a manner that was not wholly organic. You got to cite that because that's an allegation of misconduct. And, if you are alleging misconduct, you can't do that by like innuendo and implication. Yeah. Because, I mean, if they're suggesting that there were out of court statements, and so forth by Depp's team, which is what it seems, this is the kind of place where you open yourself up. Like I said in the last one, I would expect not to see sanctions. I think that this is the kind of suggestion that you want to be really careful about, and I would never mention again.
The next sentence, I think, is what the Court of Appeals is going to be like. Oh, you better give me some info here, because this is. I'm sitting here going,
It's a common tactic for an abuser to sue their victims for defamation, re-traumatizing them and impoverishing them through their legal system. Well, it's also a common tactic for somebody who has been defamed to sue somebody for defamation to recover their damages. Oh, right. Like, you actually don't want to discourage lawsuits that have merit.
Well, and I'm sitting here going, where?
Yeah,
where? I have not seen any. Where are these?
I have never, I have literally been on hundreds of, domestic violence files, and, I've never seen it ever. So this problem is only worsened during the Me Too movement, and this tactic has accelerated due to the verdict in this case. And their citation is to an online magazine. I'm like, you're gonna want to do better. This is something where you cite to an actual, to research, not just to a news article. Lawyers have noticed a substantial increase in defamation cases involving domestic violence and sexual abuse in recent years. Between 2014 and 2020, there were at least 100 defamation cases filed by those accused of sexual misconduct, most of which were filed after the Me Too movement began. And so this is citing to a Mother Jones article, which is not what you want to cite to. But they also do cite to the Journal of Trauma and Disassociation. Okay, cool. This at least is a better citation, but between 2014, so not caused by this case then. And the thing is are these wrongful defamation suits?
That's the point. You're not seeing that. Like, you don't see that. Like, yes, there's been defamation cases. Maybe that's because the Me Too movement had a lot of people going out and publicly talking about their experience, and the statements might have been true. They might have been false. And that results in defamation cases.
I mean, the sad thing, and, this is not a slight on victims, but there are people who want, we have a lot of sympathy as a society for victims, and that is not misplaced, right? You should absolutely have sympathy for actual victims of things. But there are malicious actors always. Like anything, there's always someone malicious. If you put out a sign that says free cupcakes for homeless, like free food for homeless people, you're going to get somebody who's showing up dressed in their their shabby work clothes going, I am homeless, but isn't. There's always scammers. There's always like people who want to ride on for advantage, and they're not the majority. They're like a small minority, but they've sort of realized that this is something that they can do for advantage. So the thing is that the people who actually did the thing aren't really inclined to sue for defamation typically, because that's a really risky strategy. Like, hey, all of this evidence is now public record that the thing actually happened, and now there's a court ruling. Like, yay, you scored on your own goal. Frustrating. The argument of Mr. Depp's counsel to the jury relied upon many assertions that are nowhere within the four corners of the editorial at issue or reasonably derived therefrom.
I think pointing to a specific date, saying this period of time, I basically was subject to this. Face culture's wrath. You're basically saying, no, they can get there. Trust me, they can get there.
I mean, the thing is the defamation by implication doctrine. I think that this might be a much more credible thing, because we don't have the appendix to this. That was left out of the leak. And that appendix lists who all is filing this. But you know what? I'm going to bet that it's not like the New York Times and the Washington Post. Well, Washington Post is a bad example here. But
they're not. They're a good example. They're a good example. They weren't sued.
Yeah. But I mean, we're not going to see news organizations. I'm betting that it's not a bunch of news organizations on this. This, I'm betting, is a bunch of other organizations. So at this point, they don't have an interest in those editorials and other publications. So they say that, basically they say that this should have been anti-slapped, is essentially what they're arguing here.
Incredibly invasive into Ms. Heard's privacy with such a reverent manner as to testimony about alleged incident. I'm sorry, you put that at issue, both in your defense of Johnny Depp's claims. Your article, you put it at issue. You said, I was traumatized by these things. I'm sorry. If you are subject to a lawsuit, you get asked about those things. 2, you filed a counterclaim against him, basically saying his statements were false. I now get to probe whether that is or is not true. I get to get all of that information. You put that at issue. Don't go out and make an article trying to make yourself a celebrity by
Well, here's the other fun thing on this one. Irrelevant matters such as testimony about an alleged incident in the Seattle airport in her past. What was that incident?
Was it an incident of violence where she was the perpetrator of violence against an intimate partner? I don't know.
That indeed it was.
That was observed by an officer? Maybe.
Yeah, it very much seems that they are very much saying, we shouldn't investigate into whether she's abusive because she put that in issue. Like, she said, I'm not that kind of person. So it's an issue. So we got to keep going here because,
Yep.
All right. So publication at issue. So they go on and, this is a lot of backstory. My viewers kind of know the backstory here. So I'm going to skip over this because we got lots of stuff here. But in the op-ed, Ms. Heard explained that because she had spoken out about domestic abuse, she'd been ostracized and lost employment as an actress. And
pointed to a date. Okay.
The problem is it pointed to specifics and basically said this happened. So this is a republication of that allegation. So she reopened her time limits and all of that fun stuff. The op-ed never mentioned Heard's former husband, Johnny Depp, by name or reference, such as former spouse, nor even stated that Heard had been subjected to any particular type of abuse. I'm sorry, once you put a date in there, it refers to a particular person.
And
by implication, and subjected to a particular, again, implication. And when you start
title said sexual violence. The title you did, like, this is false. The statement right here, false.
Well, and the other thing is, when you are pointing to a thing that has already been reported, you kind of bring in the details of that in a lot of ways. So yeah. So she had been exposed to abuse.
Other than the defamatory statements, the op-ed merely explained, which means gave context to those statements, that, yep, okay.
Other than the contested passages. Well, the contested passages are the relevant ones. So, other than the time that I drove over this guy's kid, my driving was perfect. Like, that's not a useful statement to make to a court. So, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And I had the rare advantage of seeing in real time how institutions protect men accused of abuse. Again, that's giving a time frame that narrows it to a specific person.
And everybody, domestic abuse, not abuse in the workplace, not anything else. It's abuse in the home with an intimate partner. That is right there. That is right there. 2 years ago,
everybody in the public knew what she was talking about. In fact, there were reports on the reports that basically were like, Amber says Depp abused me. Like, that's how people interpreted that statement. So the rest of it addressed the repercussions experienced by women who speak up. And was she sued over that? No, she wasn't sued over the rest of it. She was sued over the bits that point to, what was going on there. So other publications reported on other stuff. Okay.
Irrelevant hearsay, bullshit. Like, there's no evidentiary basis to include any of those.
Yeah, Ms. Heard was prohibited from entering these into evidence based on an erroneous hearsay objection ruling by the trial court. Are you contesting that? Or yeah.
Seems like a conclusion that kind of differs from the trial court record, and they don't have to take your assertion at all. Actually, they're going to look back. They're probably going to read that sentence. They're going to look back at the assignments of error and go, you know what? I didn't see where they said that was erroneous.
Yeah, I mean, they kind of want to run their own appeal here, which is not ideal.
No, they want to stay the articles so they can respin the public narrative.
Yeah. All right. So, Depp's unsuccessful British lawsuit against the Sun, and they're going to say that it's that they should have admitted this.
Nope. We've talked about that one at significant length. Oh, all of this.
No, they don't actually seem to be saying that.
They make all those statements before saying excluded. Then they want to go through all of this, and they do say they want to introduce that information.
All right, now they're going to talk about stuff for which we have direct personal experience. To say that the Depp v. Heard trial in Fairfax County or County Circuit Court and its surroundings was a circus is a gross understatement. As the unofficial video record has shown, the outside entrance drop-off gauntlet. Maybe you want to file an affidavit on that, and maybe this is something that there should have been like applications about at the time. You can't relitigate this now, usually. Through which both parties entered the courthouse and through which Depp was championed and Heard was vilified. And the conduct of the courtroom audience and some of the participants created an atmosphere more appropriate for a trivialized wrestling match than a trial court impacting people's lives. There is basically no way that they can give credence to this without throwing Judge Ascarati under the bus. All the way under the bus.
And not just that, like, you and I were there. It was chaotic, but I would say that was probably the most organized chaos, especially once you got in that courtroom or in that courthouse.
In that courtroom, you did not you did not burp in that courtroom, because you touch your cell phone in that room, you're gone. And not just gone, but they cut your wristband off and you're done for the day. And like, if you've been sitting there waiting from like midnight, 10 p.m., whatever it is, to get in there, you're not risking that. I didn't actually see many people thrown out. People were just super
if people got tired, the bailiff would go and touch their shoulder and like say, get up, walk around, like go outside and walk around, then you can come back in. The only other person that got tossed, I think, was because he had a recording device that was masked as like one of those little recording pens.
Oh, that'd get you tossed.
That got him tossed and banned. And then basically, I mean, that bailiff was walking around before we entered the courtroom and was like, your ass will be tossed out of this courtroom if you do A, B, C, D, or E. You will not laugh. You will not smile. You will not clap. You will not stand. You will not breathe unless you are spoken to and instructed to breathe. She was intense.
There were people who, there were moments where people started cheering and the bailiff, like they were just in there like, you will sit right down. You will stop that right now. And people did, because your bailiffs out there are kind of terrifying. I mean, I like them, but they're kind of terrifying.
They're fantastic. I love them.
I wish that the rules would allow me to bring one of them on the channel to talk about it, but they never would.
No, they won't, but I get to see them all the time. I mean, they're all amazing. Every one of them are.
The one black woman who she had the best style. Give her a fist bump for me. She was badass.
She's sarcastic AF.
She's lovely. So, it was pretty well organized on that. Social media lambasted Ms. Heard and viciously attacked anyone who expressed opposition to Depp. And here's where they're citing something interesting. Bot Sentinel. I'm going to tell you that I would not cite shit to Bot Sentinel. Bot Sentinel, they're involved in litigation right now over defamation claims. I feel like that is a bad group to cite. So, I would not cite Bot Sentinel. But I mean, you don't have a right to popularity. And the lack of courtroom decorum, or lack of decorum, was further exacerbated by social media postings which belittled Heard and heralded Depp. Attorneys for Depp were shown making inappropriate gestures and harassing witnesses while they were on the stand, while being praised by the mob. I didn't see anything along those lines. They're citing to a YouTube video. I would bring that up, except I might eat a copyright claim. So we're not going to do that. All of these elements, which are predictable results of defamation suits improperly filed and involving public figures, and also properly filed and involving public figures, right? Any lawsuit involving somebody famous is going to get news coverage. Like, whether or not Trump, is at fault or not, and I'm not making any comments on any particular lawsuit because lots of litigation ongoing, but the media is going to cover lawsuits around that. It happens. Like sometimes stories get stuff. And I see, as I mentioned, I've got all of the super chats that I will get to, but I pull up this one just right now. Can they refer to Amber Heard as the victim and Johnny Depp as the abuser, contrary to the verdict? I mean,
they can say whatever they want. They can refer to them. I can put into it, like when I first name a party in a pleading, I can say Amber Heard and I can say in quotes jackass. And if I refer to her throughout the rest of the pleading as jackass, it's completely appropriate because that's where I gave you the signal that I was going to refer to them in that way.
Jackass would probably be difficult, but
it would. I was making a hypothetical.
That one's probably. But yeah, are they attempting to try the court case over again? Yes.
In the media.
Yeah. And this is like, they know that the court's not going to entertain this crap. This is a media effort. So it's difficult to overstate the amount of historical interest the case attracted and its long-term impact. Let's talk about another historically interesting case. We can talk about a couple. Rittenhouse.
Oh, I think trials of the century, we can talk about a lot. How about the trial of Bruno Hauptmann in the Charles Lindbergh case? You want to talk about the trial, the Scopes Monkey trial? You want to talk about trials that resulted in media frenzy that had people outside the courtroom? Sam Shepard.
Yeah,
Sam Shepard. Yeah, they had Cleveland Press going after him left, right, and center. You want to talk about any number of those trials? They all resulted in a great deal of media coverage. And we have questions about those after the fact, but the media coverage alone, other than the Sam Shepard case, which I think was kind of crazy.
Can you imagine filing an amicus brief saying O.J. Simpson should have been convicted, because of the media attention. Like,
oh,
this sends a message to women that they can get murdered by their like, no, that's not how the court works.
Didn't make that connection, but okay.
Broadcast of YouTube segments amassed a total of 83.9 million hours watched with a 3.5 million peak viewers during the announcement of the verdict. Thank you, everyone who tuned into the channel during that time.
I mean, it's because they didn't trust the people that were in court to tell them the truth. That's the fact of the matter. So
yeah,
I think that's yeah.
Well, I was walking out of court and reading the news stories about what happened in court that day, and I was like,
you're going, what the hell were you listening to?
Were we watching the same thing?
No.
The opening argument of Mr. Depp's counsel, and do you remember, like, we saw one reporter in the courtroom? Well, Chanley.
That's it.
But I talked to lots. I saw lots of reporters. Mm-hmm. They were just like, they'd be there, they'd be reporting on the line, and they'd walk, and usually they'd know that they can't get in. So they wouldn't bother waiting in the line with the rest of us because we're just the peasants, right? Sometimes this was funny. It happened a few times. They'd walk up to the bailiffs and they'd be like, I'm so-and-so with, whoever news. How do I get my press pass? And they're like, back of the line.
Yeah.
And the media's like, you what? And they're like, no, back of the line. That's how there are no passes unless you meet the criteria.
And what's funny is it's because Judge Ascarati had already taken their jobs away from them by allowing cameras in the courtroom. It took they had equal access to the live feed that we did. They could report on it just as easily. They could be on their media, on their mainstream media outlets, sitting there going, breaking news in the Johnny Depp trial. I was just watching the live stream, which occurred again live in court, and this is what I observed.
Yep. People are noting that they watched it on Emily D. Baker's. I mean, there were people watching it on Ricada, Legal Bites. I wasn't live streaming because I was often in the courtroom. But I'd report on it afterwards for, Depp's counsel later argued that what is at stake in this trial is a man's life, the life he lost when he was accused of a heinous crime. Only later did Mr. Depp's counsel correct, you're allowed to use rhetoric in closing.
It's this. He's referring to the same thing. He's referring to the same thing.
You're allowed to use rhetoric. And people are noting that I live streamed during the breaks. Yes, but not like during the actual breaks. And I came on Ricada, I went on Legal Bites, I went on EDB,
split between everybody. Right? It was kind of like we would walk out during breaks and be like, okay, we kind of have to hit everybody. So where are we
everybody's got to hear what happened. So it's, we just kind of, but this is just basically saying that Depp's counsel used rhetoric in the closing. Okay, they're allowed to. Evidence in this case was presented over 23 trial days. Jeez, that's a lot.
I laughed at this. Please remind the court how long the jury had to watch this case. Good job.
Before we just ask that the jury be completely disrespected by tossing this. I noticed I love the tired Runkle streams from Rob's house at the end of the day. Some of those were wild because I just came out and I came out of trial having been up since forever, live stream on with some of the other people, drive to Rob's place, live stream for a little bit, sleep for 2 hours, and then get back to the line. We watched Runkle get 200,000 followers live on EDB while he ate lunch. I got to go back and clip that. I got to clip that because she's like, Runkle, do you know your follower count? And I'm like, it's got to be getting close to 100,000. She's like, Runkle, check. And I'm like, what? She's like, check. And I'm like, what? So it just blew by. I was like, yeah. All right, back to this. I'm getting ADHD distracted by the chat.
Gotcha.
Chat, I love you. We gotta keep going here. They say that they had an immediate impact on his career, but they also, they're leaving out that he also talked about the impact since. and how there was like they talked about how it had a secondary impact. It was like a second bomb going off in his life. So they're going to leave that out because, yeah. Thus, Mr. Depp and his counsel asked the jury to hold Ms. Heard accountable for filing the restraining order in 2016.
Oh, this was the conclusion they made because a lot of the reference was to previous. This is just a this is
throw garbage at the wall.
Yeah.
Post-verdict information. This is something I would not put in writing.
No,
I would not write this. Despite the fact that the identity of the jurors had been sealed, after the trial ended, one juror chose to speak out in response to various comments made by Ms. Heard and her counsel. I wouldn't even write that.
Nope.
Because you can't.
How are you getting that in? Why are you getting that in? Why does that actually have any relevance? It's not. As an evidentiary matter, do they cite to the rules of evidence in Virginia that say that you can't use it? Period.
Guys, I'm going to make a prediction right now. Rob's going to hit 250 before I do. That is a prediction I'm going to make.
No,
right now.
We're fine. We're good. We're happy.
You're going to get to 200K. That's going to happen. Doug Stanhope was a good guy Johnny trusted, and the guy said, that's not Johnny. I've met Doug Stanhope. I will tell you, Doug Stanhope has zero filter. If he thinks you're an asshole, he'll tell you that to your face. In fact, I watched him do it to someone else. He's just, hanging out with people, and he's like, you're an asshole, and he walks away to talk to someone else. Like, literally, the guy's got no filter. He's freaking hilarious. Check him out. Don't watch him with your kids, but he's freaking hilarious. But
so
yeah,
next sentence, I would not have put this into writing at all because this is quite literally saying the jury got it right.
Yeah.
This is the dumbest thing to put into your brief.
Yeah.
You quite literally said they were both abusive to each other, but it didn't rise to what she was claiming, meaning we think she lied. There was not enough or any evidence that would get them to that point.
So, this is basically saying the jury looked at this, applied the standards for defamation, which is to interpret her statement as and we found that she was lying. Like, but they
maybe don't repeat this. Like, maybe don't put this in your brief.
But the other thing is, don't cite this to a news story. From what I understand, Andrea was just on. She noted that she checked the Virginia rules, and they basically say you don't get to introduce juror comments.
Yes, you are 100% right. And I heard her say that. She's 100% right. You do not get to introduce that. You actually have to have a provable misconduct claim in order to even get to the things that they are saying. Not only that, but this is quoted from the article, but this is an article, which is hearsay, quoting a statement, which is also hearsay, being brought up after trial without a basis to bring it up. Like, why? This is for the media. This is not for the Court of Appeals, because the Court of Appeals is tossing this out the window, this paragraph.
Like and misconduct is serious things. Like, I did independent research, or we all thought the guy was innocent, but we decided to convict him because he's an N-word would be provable misconduct.
Yes. Even the I did independent research thing is going to be is a maybe. That's not a big inadmissible or juror conduct that would rise to a level. I saw other jurors getting bags of cash. Like, that's now you've got it. There you go. Put that in a brief, file it, get a motion to reconsider, grant it, no problem. But absent that, you're not getting there.
Or even a juror saying, I took money to rule in the way I did. Other people did too. I feel bad now. I'm willing to sign an affidavit. Like, that would be great. Like, but you also can't get that in. Like, even if you had that, like, you've got the juror who feels bad about taking money for a particular verdict. You can't get that in with a news article that just talks about an unnamed juror. You need an affidavit from the juror, or maybe an affidavit from someone who interviewed the juror at a reach, but not news story reported. Like,
no,
because how do we even know this guy's a juror?
We don't, because they didn't release the information how they vetted him.
Yeah,
or her.
I would not put in writing in a legal filing that this guy was a juror. No. Or, yeah. The juror further stated that Heard's team failed to prove Depp's abuse was physical, thereby demonstrating the juror's misunderstanding of the burden of proof on this claim and the full scope of the term abuse. Oh. This is you demonstrating that you misunderstand defamation law, because there is no specific term of abuse that applies to this. It's what is she implying to the public, which you...
Yep.
Yeah. You know what?
Here comes the liquor.
Scotch is a great drink because you can drink it because you are celebrating, or you can drink it because you're pissed off. And this is a pissed off Scotch. So, and they give a citation here about the trial court entered an order sealing. I'm like, why would you even cite that?
I know why they did it. They did it to basically say the juror was so motivated that even though their name was sealed, they came out and made a statement because they wanted to make a statement. No, it doesn't mean what you think it meant.
I mean, if I was the juror, I probably would have made that same statement for a substantial cash payment.
Well, you want to know why the jury member probably came out and said something? Maybe because Elaine Bredehoff accused the jurors of being an idiot on that, or being idiots on national TV. So, yeah that might bring some of them out of the woodwork.
It might have been a rebuttal to that. I see that there were some gift memberships in the chat there. Thank you very much. Always appreciated. And I don't offer a lot of, like, I got to figure out special perks for or for memberships. I got to work on that. But it's I agree with this comment. Runkle needs an emotional support scythe. Kind of do. You know what I've got as an emotional support thing? Rob, I don't think you've seen this, or maybe you have.
I saw it. I saw it on Twitter, and you texted it to me. Yeah.
I met with somebody from the stallery. Just they wanted to say thank you. So, I've got a little thank you bear. It notes my name is Dr. Patchup, but I think that's just for the model of bear. I think I need to do like a stream where we decide on a proper name for the bear. So, because. Yeah, I'm super, I'm sort of blushing about it. So
I love it. It's awesome. It's the coolest thing in the world.
But abuse can refer to many types of actions. Sure. But let's apply defamation law here. Let's pretend we're doing law. Because sure, abuse can mean many things, but like we had the example last night of the cheese pizza. If I write an article saying that somebody is, a particular person is a fan of cheese pizza, if everyone understands that as pizza, like the physical food, no problem. Like, I'm not going to get sued over defamation because A, everybody likes pizza with cheese, and B, like, unless you got like a lactose issue or an allergy or whatever, but B, like, it's not defamatory, even if you're wrong. Right. But if people understand that as meaning bad pictures, then the fact that you used a code word isn't going to help you. And, if I say that, let's say I say Joe owns a bunch of guns. Okay, well, owning guns is still legal in Canada. I mean, it's hanging on by a thread here, but it's still legal. But if everyone, like, if I've been putting that in the context of talking specifically about illegal guns, then Joe might have a claim against me, if I say that, right? Because people would understand that even though I just said Joe has a bunch of guns, because there's been this, contextual thing that everyone understands that as illegal guns, and now I'm accusing him of a crime, and now I'm in defamation land. So, all of this is basically just, we don't know the law and we hope you don't either, which is a bold statement to the appellate court. So more than half a century ago, they recognized that it can take... now, it's really interesting that they're citing the same crap in both briefs. Angry words, coarse and abusive language, humiliating insults, and annoyances in all the forms that malice can suggest. Now, we're talking about this in the divorce context because these are the grounds for divorce.
Yep.
So, I know here in Canada, and I want to ask if it's the same thing. We had a period of time where it was hard to get a divorce because you had to show either some wrongdoing in the relationship or you had to be away from people for a time. And so the court started basically finding that things were really like that all sorts of things were meeting that test for what was okay to end a relationship. Did they have the same thing in Virginia?
So Virginia used to be that you had to have grounds, and then they adopted no fault grounds because you were having a lot of those cases where people were getting to the end of the divorce litigation and they would say, we can't grant you the divorce because you haven't proven cruelty. And then all of a sudden you're going, but now by not giving them the divorce, have you just left them in the marital state? Like now they return after this litigation. What's the end goal, or what's the end? Are we going to keep people in these marriages? So that's why we adopted the no fault grounds. But the thing is, the case they cite here, Soley versus Soley, they didn't go on like that. We have so much more case law after that fact where, for example, there's the Williams case. Doesn't permit the court to sever marital bonds and break up households merely because husband and wife, through unruly tempers, lack of patience, uncongenial natures, live unhappily together. There's another one that says that you've got to basically put up with any number of coarse and abusive language, humiliating insults, etc. They do not grant grounds for a divorce in and of themselves. Marriages and families are very interesting dynamics. They're just trying to overly expand abuse so that that's what this entire brief is. This brief is let's overly expand what abuse means so that everyone can go out and accuse everyone else of being abused.
Well, and also the jury was wrong to come to their own conclusions about what was intended by that statement, which is basically the jury was wrong by being a jury. So they're going to talk about intimate partner violence is a significant problem in Virginia and the US. Now, violence versus abuse, right? We're seeing a switch up in terms because you know what? As much as it's bad if people are using coarse language with each other in a relationship, I don't think that's a role for the government. Like, you know, if you guys call each other mean names in a relationship, I don't think that's the government needing to step in, but like,
what's funny is people keep asking, like, we talk about definition of abuse and what is abuse. We have in Virginia, we have a body of case law going back to the 1700s trying to define what abuse is.
And it's like, tough and it's contextual.
Because it is contextual. It is every single case is different. There is no defined definition of A, B, C, D, E, D, F, G that all constitute abuse. That is not what this is, because abuse requires context. I have told people in the past, I can take every single person's cell phone, everyone in the chat, all 2,000 of you guys that are here. Give me your cell phone and you give me free and unfettered access to the text messages. I can prove with those text messages taken out of context that abuse occurred. Period.
Oh,
people say things that are insulting to each other. We do all the time.
One of my closest friends, him and his partner, they're not married, but they're basically married. Their communication with each other is coarse.
Oh yeah.
And they both enjoy it that way. Like it's you know, he'll call her the C word and she'll laugh and say, I'm going to bury you in the backyard one of these days. And the thing is they have one of the best relationships you could find because they just don't give a damn, right? They really enjoy being that kind of like, none of them have hurt feelings.
You remember Isaac Baruch? Like one of my favorite lines from the entire trial was when they were examining him and Elaine Bredehoff was saying, has he ever called you a C word? And he's probably like, he probably called me that last week. Like he literally said that. And I'm going, yeah, okay. Yeah.
I mean, I've got friends who, when I'm around them, I'm very careful about my language. And, you know, some people I don't swear around at all. And there's some people where I would very much, you know, not call them by any sort of rough and tumble terms. But I've got friends where I hang out and we just like, we just kind of have fun teasing each other. It's different relationships, right? And, I had one of my friends, and this is a guy I really like, said, I watched one of your YouTube videos. I couldn't tell if it was a YouTube video or an OnlyFans, because was that your ass on screen all day? And I was just like, that's freaking funny, right? It was just, and he had a much better delivery than I do, because repeating a joke kills it. But I was just like, yeah, good. And I mean, this is a guy who, literally, he's one of if I was in custody and I needed bail money, this is a guy I could call and I know he'd be out there, right? And that's even if it was hey, I need 20 grand in bail money, he'd be like, let me sell some things and I'll be right down. So, this is a guy who'd sell his car to put up the bail money, right? So, but yeah, they're saying within intimate partner abuse is psychological aggression, which includes
do you see that? You see that whole within? Yes. Yeah. These can all be elements of abuse. Every single one of them can.
But literally nobody read her thing and thought that meant name calling.
Yeah, no.
So
sexual violence is a very different thing.
Yeah. And they also say, similarly, as the CDC explained in the thing, sexual violence includes non-contact abuse, such as non-contact, unwanted sexual experiences of verbally sexually harassing the victim, making a victim look at or participate in sexual photos or movies, and sexual coercion, e.g., threatening to spread rumors and sexual pressure due to someone using their influence or authority. Nobody thinks that I was the victim of sexual violence means, hey, come watch a porno with me.
Yeah, no.
No.
You read their text message back and forth and you're like, no fucking way. That's the thing. Context matters. Read how she talked to him. Read how he talked to her. Yeah, they said a lot of really stuff that I would never text Ian or anybody else that I know. But
I mean,
context matters.
Back and forth like the narrator and Carla in Fight Club. But I mean, that's just how some people talk, right?
And another one, good thing, cite the CDC.
CDC is at least a decent citation.
It is, except for the fact that CDC has a habit of changing certain definitions every now and then, not to say around a certain topic. And I think that some Virginia judges have gotten burned on that particular topic. So yeah, let's go ahead and cite them.
Yep. So, while psychological aggression by an intimate partner was experienced by 47.1% of women, physical violence by an intimate partner was experienced by almost a third of women. Okay. But if it includes, if this includes calling somebody names, I'm surprised it's not higher.
Why are we talking about this? Why are you blowing this up to this scale? Why are you going through statistics and saying that statistically speaking across this is not about the world at large. This is about two people, the context and the actual dynamics of their relationship, and whether what one person said about that, given that context, was defamatory. I
mean, it's fair enough to say this is a serious issue and whatever else, but yeah. So this doesn't get us to this might get us to a legal rule should be interpreted in one way or another. It doesn't get us to the specific facts of this case. Nearly a quarter do not report the violence because they fear reprisal. I can tell you that when they fear reprisal, those fears
it's not
of reprisal
a defamation case.
Is not a lawsuit. Those fears of reprisal are, he gonna punch me, or I'll get thrown out of the house and I've got, I've got no whatever, no support.
I have no money. He's going to cut off all of the funds. I have nothing. He's going to take everything away. He's going to take my kids away. I had a previous drinking problem. He's going to take my kids. I'm going to come home. The locks are changed. He is going to find a way to do something in my sleep. She is going to find a way to do something to me in my sleep. Switch the roles, switch the narrative. that is the reprisal we're talking about. We're not talking about a defamation lawsuit.
I see Duke Chronic saying this is too long. A judge will be pissed having to read this. Yeah, I mean, I'm pissed having to read this, and I'm grifting off it. So, although it's less grift and more just like I want to rant, anger. And if I rant if you do too much ranting, like without the camera on and an audience, my wife starts to think I've gone a little off, and she's right, but not for this. Rob's like, dibs out. So over a 10-year period, almost half of non-fatal domestic violence victimizations were not reported to police. Were those swearing? Because now you've muddied the water that I don't know. You know what? I actually think that they probably mean actual serious victimization, but this has nothing to do with with what they're saying here. See, what's good, Ruckle people? First live being able to make since Turkey Day, ready to get back at it. Yeah, I'm gonna cover all of the super chats are starred, folks. Just so you know, I will get to all of them if I have to stay up until tomorrow, because we all know that I don't sleep. So the light of disclosure reduces abuse. There's a large amount of intimate partner abuse hidden by the shadow of non-disclosure, and much of that is based on the fear of retaliation. But that fear of retaliation does not apply to reporting to police. Like, at least not the litigation.
Yeah,
like I might get killed. That applies.
And you know what's funny? You know what's funny about the 10-year period? The non-fatal were not reported to police. You know why they're not reporting to police? Maybe because you're scaring them with this particular case, and you're giving them one more reason not to report it to police. Well, maybe because the overarching message of this is, the
other thing is that a lot of domestic violence people are very unhappy with the results when they report to police. Because what often happens is you get two people in a fight, and they're in a fight, and one of them just loses their temper and slaps the other. And it might be either partner. This happens all the time. And the other person calls the cops to say, I need somebody here to help talk this crap down, right? And the cops show up, and they have one solution on this, which is one of you's getting arrested, and you're getting, released on terms that say that you can't get, have any contact. You guys are out of the house. And this might not actually be what the person wants, right? They might not actually want to have their life blown up in that way. They might have just wanted the fight to stop. And so a lot of those people, like I hear a lot of complainants in this say, I don't want to call the police again because they don't listen to me. It happens. That said, if you need the police, call the police.
The cops have one job, and it's to make an arrest.
Yeah,
in that moment.
But keep in mind what they're going to do, right? It's that they are going to make an arrest.
They're going to make the arrest.
If you want a result that's short of somebody's going out of here in cuffs, there are shelters. And you know what? A lot of those shelters understand things. And for instance, if you're like, I got to stay here for tonight and I'm going back tomorrow, shelters take people on that basis. There are resources. So I am not the best source for resources because you live in wherever town and I live in, my town. But Google can find those. And if you are concerned about your Google searches, you can.
The police will give them to you too. If you call the non-emergency line and you say, I'm having issues, they will give that information to you.
Yeah. And I do note that there's not many shelters for men. I think in Canada, the current number is 0. So that is unfortunate. So this verdict means that juries may ignore abuse unless it is extreme physical violence witnessed by third parties. That is not what it is.
This is not a domestic violence case. This is defamation. This is not, these are not the drones you were looking for. Like, no, stop. This is about 2 people. Stop.
Yeah. In several recent cases, even admissions by an abuser have been insufficient for a finding of abuse in defamation cases, causing doubt in the minds of many women that the legal system can provide them with justice, citing a case dismissing defamation claim filed by accused abuser. Yeah. Apparently there is a men's shelter in BC, and somebody's saying there's one in Toronto, so that's good. I don't think there's one in my province, so I'll have to look, because these things change, right? People, they open stuff, they close stuff. The verdict in the present case communicates that retaliation in the form of a defamation action, is a powerful action against women who report abuse. They're missing a word here.
I'm about to get real pissed.
This is 100% accurate if you add one word to it.
Mm-hmm.
Falsely. And, well, actually, no, you need to add a few words. Falsely to the media.
Yeah.
Because, how often in defamation claims or in abuse ish, because you do family law, you see a lot of that too.
Mm-hmm.
How often is their first call to the newspaper?
Never.
Not
the second call, or the third call, or the fourth call, or the fifth call.
How many of them have a PR firm?
None.
Have they ever called TMZ?
Nope.
I'm kind of feeling like this is an unusual case that doesn't apply to your average woman.
Nope. Or man, or anybody. It doesn't apply to your average it doesn't apply to anybody. It applies to the top 0.0001% of people.
This verdict punishes Ms. Heard for being brave enough to write about the abuse of women that didn't happen. The message is clear. No woman who voices her opinion about abuse falsely is safe from retaliation. Like, if we just add the words here, it makes sense. This verdict will likely decrease the false reporting of intimate partner abuse. See, if we add false in here,
you know what? There's Ben Chu's response. Here, I rewrote this for you.
Yeah, we just add false in.
And just I rewrote this for you. And like, that would be the ultimate troll move. Here, I rewrote this, and then just put in italics, like bold, false. Just file it.
With even less reporting of false intimate partner abuse, a heinous problem for Virginia in the United States, such false abuse... Well, no, that one doesn't work. Like, this is the thing, is that if you are actually falsely abused, falsely reported, a defamation case is a good thing. Like, we actually, in the same way that if somebody actually keys your car, it's good that you can sue them for keying your car.
Yeah.
So
I'm glad you chose keying tonight instead of the other one that we were talking about.
I did too much fire the other day. I had to move on from fire. So because this case received such widespread attention, both in traditional and social media, some women have already received the message from you guys that they should hide the intimate partner abuse in their life. Yeah. It's from you.
Let me write the response to this one, please. Just
this is, this is a guy saying, like, oh, listen, people are worried because there might be a murderer in the house. And the guy's like wearing a ski mask and is holding a bloody butcher knife. Like, and
he gives a description of himself. He might be 6 feet tall, Caucasian male. It just keeps on going.
Like, they're really concerned about this murder, and people are like, and he's like, no, we're not going to be doing that, because people are real concerned. So, so angry. Dr. Jessica Taylor, a psychologist, forensic psychology PhD, and the author of 2 books on misogyny and abuse. Guys, you don't tip your hand that hard. You don't want to tip your hand that hard. Says she has already been contacted by hundreds of survivors since the Depp verdict, wishing to retract public statements they have made in the press or pulling out of court cases against their abusers.
Like,
she says the verdict opens the floodgates to future defamation cases.
She's being contacted by hundreds of survivors, caveat, who made public statements in the press. I don't even know I don't know dozens of survivors who have made public comments in the press. How many people have actually survived intimate partner violence, get out of that, and then say, I would like to go to the press and talk about this right now?
I don't think I've read 100 statements in the media in my life. So the footnote, of course, is to an article from the Rolling Stone. Here's how you get evidence like this in, with an affidavit.
Also, pro tip, in a defamation case, maybe, just hypothetically speaking, in a defamation case, maybe you avoid citing to an article by a publication that has been sued and lost / settled out for defamation against certain people. No, Rolling Stone lost the Virginia case, didn't they? Yeah, they did. They lost that rather famously. So Rolling Stone.
Yeah, not the best citation. But like, seriously, you want to get this under oath, right? If you want to make this statement, because what if she's full of shit? Like, what if she's lying to promote her next book on misogyny and abuse? Like, I don't know, but that's why we get statements under oath and not just somebody reported something to, to a news organization, right? And when you file this as an affidavit rather than as a citation to a freaking news article, you'd also be citing her as an expert, and you'd also have to put in her credentials, and that would be debatable. Yeah.
Rolling Stone got sued. People are asking, Rolling Stone got sued by Virginia members of a fraternity because they published an article saying that they were doing certain conduct that ended up being completely false, and they got sued and lost that lawsuit.
Oh, that was another one that I called online as being fake at the time and got a world of crap for it. And here's the funny thing. I said, this one didn't happen. I'm calling it now, didn't happen. And people were like, why do you say that? And I'm like, because this was the one with the report where she was smashed through a glass table.
Mm-hmm.
And I was like, the injuries that would result in are catastrophic. We would have, she indicates that she didn't go to the hospital. Didn't happen.
Yep.
And, glass is something you don't mess around with. But similarly in the Heard, Depp and Heard trial, I was like, oh, right. Glass seems to be this thing that seems to be tipping off, or it's a tip off in a lot of these cases. A lot of the false reports are ones that are sort of too lurid to be true. Because when you look at actual SA allegations, almost all of them are I went out on a date with a guy. We started fooling around. I was not losing interest. I said stop, and didn't. But that's not exciting. That's not lurid.
Someone in the chat just also pointed my attention to the fact that the article was published June 1st at 6:10 p.m. This is 3 or 4 hours after the verdict.
Oh, after. Yeah. So that if it was after the verdict, 3 or 4 hours, you can be pretty certain that this was written by a PR firm. Yeah. For these women, this appeal is an opportunity to erase the message of the verdict that reporters of abuse will be punished. This is the kind of statement that if I was on the appeals court would be like, and trash.
Trash. No, I was done a solid 10 pages ago.
Yeah, but this is literally we are asking you to do not law things that are specifically forbidden by the law. In fact, if we look at this case, Rottenborn made a similar statement in his closing.
Yep.
And it was objected to late. Benchu screwed up here a little bit.
It was the one thing that he did in his closing that I thought I really didn't like. I thought his closing, just from a standpoint of presentation, was good, but that one statement kind of pissed me off.
Well,
just kind of really pissed me off.
Benchu properly appealed to it late and pointed out that such statements are wildly improper in a close. And ultimately, the judge basically said, well, you got your verdict, so we're not.
It's jury nullification.
Yeah. But yeah, this is what they're asking for, is jury nullification by the court.
Yep.
And you know who doesn't do jury nullification? The
Courts of Appeals.
Reversal in this case will communicate that retaliation against women who report abuse is not acceptable in Virginia. You know who you take this to? You take this to government. You take this to politicians, and you say, we don't think it should be acceptable to file a defamation claim, against. And I mean, they could put that into statute. Like, they could do that.
Mm-hmm.
They won't, because, like, why? But I mean, that's who would be able to do that. Summary of argument.
Wait a minute. What? What page are we on?
We're on page 33, which is listed as 23 because there's a bunch of, like, they don't count the pages like in this of like.
So that was all background?
I guess. They keep summarizing. Eventually, they're going to make an actual point. We're not there yet, but eventually. So the op-ed was an opinion piece with no direct connection or citation to Mr. Depp, other than providing a direct connection via the time frame. It reflected Ms. Heard's opinion that society in general, and Hollywood in particular, failed to support what. You know who contradicted this? You know who says this is bullshit? Do you remember the trial?
The jury.
Oh, not just the jury. Someone else, someone real important. Amber Heard.
Amber Heard said that?
Amber Heard on the stand said, yeah, this was written about Depp.
Mm-hmm.
So these people are calling Heard a liar. Whoops. Like, you know, if you don't believe Amber Heard on that, then why is the jury supposed to believe her on anything? Mr. Depp has alleged that statements by Ms. Heard using the terms abuse and domestic abuse implied a defamatory statement about Mr. Depp, and the jury found so too. Based upon the uncontroverted evidence at trial, those statements cannot be the basis for a finding of actual malice by any reasonable jury.
There's that word again, uncontroverted. You keep using that word. I don't think it means what you think it means.
Because they were subjectively true from the perspective of Ms. Heard. The jury determined that they weren't subjectively true from the perspective of Ms. Heard. They found she was lying and knew she was lying. That's what their finding means. Moreover, there was sufficient uncontroverted evidence at trial of actions that satisfied most reasonable definitions of abuse to be considered. The jury doesn't have to accept most reasonable definitions. They can interpret that to be, what does Ms. Heard mean in these statements? And they can find that she means a different definition than the one you're using. Mr. Depp contends that they included implicit innuendo, readily apparent to any reader, implying Mr. Depp engaged in physical and sexual violence against Ms. Heard to restrict the known meaning of her choice of words on abuse to his viewpoint, not hers. And the jury's entitled to say, you know what, we find that she meant loud shouting. Did she say she meant loud shouting in the trial? Yeah. Like, she said that what she meant was, he put a bottle up me. He dragged me across broken glass. He smashed my head against, a hard floor. Yeah. Yeah, I've mentioned this one. They mentioned Segal and V. Carrera was dismissed in favor of defendant victim. How could that be helpful here? They're just picking out a quote that they think is helpful. They're quote cherry picking. Amici are concerned about this application of the doctrine of defamation by implication, which is long-standing. The freedom to truthfully speak about abuse in general statements will be restricted if the op-ed's use of the term abuse is held to imply actions that allegedly occurred and were reported more than 2 years. Like, again, this is defeated entirely by the cheese pizza argument.
This is so stupid. We are now in the dumbest argument.
Like, the number of times that people are defamed by implication is tremendous. Yep. And if you don't allow defamation by implication to be then you get all sorts of things. Like,
Yep. For example, the leading case in Virginia, Pendleton case. I've made this comment before. The Pendleton case. This case in Virginia was about a school board that was talking about parents who forgot to, who the school board implied had impermissibly or had implied that these two parents forgot to include a what's the allergy pen?
EpiPen.
The EpiPen.
Yep.
That the parents forgot to include the EpiPen or instruct the school on how to use the EpiPen. and that the parents, by failing to do that, they were the cause of their child's own death when the school actually had the EpiPen. So when we're talking about the freedom to speak and defamation by implication and why defamation by implication is important in Virginia, that case is the case that they're arguing against. So if you are opposing counsel, you can just write one word and the Court of Appeals will know exactly what you're talking about. You just write Pendleton.
But there also have been defamation cases for like businesses based on things like, if you have like, there are 2 burger joints in town and you do an advertisement that shows you cleaning the burger, like all of the equipment. And you say, we really care about cleanliness of our burger, fry grills, unlike some of our competitors. If there's only one other burger joint in town, you're going to eat a defamation lawsuit, and properly so, because you're not going to be able to say, oh, well, we meant like, this other burger joint like 6 years ago, or like, in another town, like 3 hours drive away. Everybody's going to interpret that as we mean the other burger joint across the street is, a dirty place that you will get food poisoning from. Defamation law is full of this because lots of people, when they are speaking horrible lies about people, hedge with stuff. So I see this is an accurate statement. Rob is losing brain cells and IQ points just for having read this.
I am.
We'll get them back. It's just that this like temporary contagion of stupid. You don't want to read too much stupid, people, because eventually it just like, yeah. Somebody says, you can tell Runkle spends a lot of time in front of juries explaining things so that even a toddler can understand. I mostly do like judge alone stuff.
Which you also have to, like, you kind of have to.
You got to explain it. I mean, I don't want to insult
judges.
But
it's not insulting them. They're expected to know every aspect of the law, period. Sometimes you have to break it down.
And the thing is if you can't explain your argument to somebody who's never heard of the law, you don't understand it well enough.
Can I just read one quote from the Pendleton case and tell me if this sounds at all familiar?
Oh, absolutely.
Pendleton case. This was one of the articles that was published by the school afterwards, after the child died. Earlier this week, a first grade student at Hopkins Elementary School died. Chesterfield County Public Schools is deeply saddened by the loss of the child and has reached out to her family. It is a parent's responsibility to provide the school with accurate, timely information, a health emergency plan, and the medicine necessary to execute the plan. If any one of these items is missing, the doctor's orders cannot be carried out. The school relies on parents to follow through. If you're a mom and so
yeah,
imagine that case and then saying, we know what you meant, school. And then you look at this article, you go, we know what you meant, Amber.
Every statement of that is true in a literal sense, but what it communicates is false, right? What it tells the public is real ugly. So, that case makes me want to like find a time machine and punch those people. Yeah. Just because, can you imagine the parents of, a child who's died who are now facing this publication saying it was your own fault because you're just too freaking
yeah, so that's the case that they have to argue against.
But you can see why these rules exist.
Yes,
Pendleton becomes an excellent.
It's a good case. It's a good case. I feel like why that case is there.
Yeah, I feel like their arguments about the social good are going to fall in the face of that one. It is also alarming that the verdict was allowed to stand given the utter lack of causation evidence showing that this one op-ed was the source of Depp's financial troubles. Well, the jury is allowed to determine if it contributed to them and if so, to what extent. The jury is allowed to make that call. No evidence was presented by Mr. Depp that any reader of the op-ed who would have employed him, but chose not to, had read the article, much less made a connection between the general statements in the op-ed and Depp. They did present evidence that it impacted his hireability. They had a bunch of experts on to talk about that specifically. So this is just BS. yeah. It is next to impossible to say that any alleged harm was to Mr. Depp was due to alleged innuendo in the op-ed, except they had witnesses who specifically said that it was, and that, that it did have a renewed impact, and that, those experts were cross-examined. So, yeah. So they're talking about protecting the press and commentators. I'm going to bet right now that there's not a single press publication in this.
Ian, do you see that chat I just dropped, the Pendleton one?
Oh, the Pendleton case. Yes.
See if you go ahead and pin that, just so that people can hit, because people are asking about it and people are debating on who was who, yada yada. If they want to look it up.
Yep, that is pinned.
Okay.
So somebody says they were about to pay $5 to say what Rob is saying. So all good. I'm just like, don't tell me you're about to pay me. That's no good. So, lastly, the amici are concerned that a claimant has been permitted to litigate the exact factual issues in two different fora and obtain different and contradictory findings. Well, except that they're not different and contradictory. Like the UK proceeding found that Mr. Depp was not defamed by the Sun in a different choice of law, like different legal tests, and against a different defendant. And yeah, even though the UK proceeding was against a different defendant, the exact same facts regarding the abuse in question supported the English court's determination that it was substantially true.
Not the same defendant.
Just as a question of like legal principles, can you have a precedent for a finding of fact?
This is different defendant and exact same. No.
Well, and you also can't have a precedent for a finding of fact. There is no precedential value to a finding of fact. So, if one fact finds that a car was red, you can still call evidence to say, no, car actually blue, like a picture of the car. And like, that's perfectly fine. There's a reason why
she donated everything. She had no financial incentive. She donated everything.
Yeah, I mean, when we look at why the UK court made the decision, we know several of the things that they relied on were actually false. And so, like, this other court got lied to and believed some bullshit. There's not a reason to deal with this. The message of this Virginia verdict to abusers is that relitigating defamation strikeback suits in different courts until a favorable verdict can be obtained is profitable, without regard to whether an adverse outcome is obtained in the first case.
You can move on. This is as stupid as it sounds. Keep going.
Trial verdict is inconsistent with the First Amendment. This is actually an argument that an amicus could make.
Like, oh my gosh, we are 30. How many pages in?
We are 26 pages in, and they're finally getting to we are an amicus.
Oh, my brain.
So they are concerned that the threat of frivolous and expensive lawsuits by claimants is significant and increasing, especially in Virginia. Okay. And they cite to the Devin Nunes case, Devin Nunes's cow. That's a whole thing we could do a whole case on. Yeah. It's ridiculous. So people, especially those who have been the victims of abuse, are afraid of speaking out against those who have more power and money. Again, how often does this actually happen? And you know what they cite to here? Marilyn Manson.
I love that they don't use his legal name.
Yeah, I mean,
like
in
it's
a legal
case,
finding,
it's a legal case, it's a legal document, it's a case filing. You're not using his real name. You're using his stage name. Interesting.
And you know what? It would have been perfectly appropriate to say Brian Warner, better known as Marilyn Manson. That would have been perfectly appropriate.
That would have been appropriate. This right there is just misleading.
Yep.
Wonder why.
I don't know a Marilyn Manson. Marilyn Manson, never heard of her. Like, at least in a legal courtroom. I've actually listen to a whole bunch of Manson stuff.
Mhm.
It's still on my Spotify playlist. So,
Mhm.
but the other thing is this is ongoing litigation. Manson hasn't been determined. Manson
Nope.
might be in the right. I
Correct.
haven't been following the Manson case, but maybe in the right. You know, hey, look, this guy who ran me over should lose his case because there's an increase in personal injury lawsuits. Look, this famous guy just sued over being run over by a car. And that's still before the courts. This is the equivalent argument.
Yeah.
And this is something I was just going to mention, but somebody else got in the chat got to it first, so I feel it's appropriate to sort of give them recognition for that. Absolutely no reason to include Lily Rose's name. Yeah, this is one of those places where I just kind of want to.
Smack
I want to.
people?
Well,
In
I
the back
want
of
to
the
pull
head,
up,
like in the back
I
of
wanna-
the head, like just do the whack.
I want to pull up the Chris Rock bit of "Get her name out your mouth." Like, I feel like that's appropriate here. And House Hippo is noting Andrea Burkhart covers the Marilyn Manson case. If anyone wants more info, she does, and she is incredibly detailed. She does incredible diligence. In fact, part of why I didn't cover the Manson case is that every time I look into it, I watch an Andrea Burkhart video and I go, I can't do this much research. I'm just going to do a pale shadow of this. So I just leave it to her. She does careful stuff. Even before the verdict in this case, First Amendment advocates expressed concern that slap actions might,
read the first part of that sentence because that is so dumb.
These suits, frivolous or not,
which means these suits, even when justified, take their toll on defendants. So yes, when they're justified, they take their toll on defendants. They're supposed to, even if they ultimately win. Yes, that's what they're supposed to do. They're supposed to take a financial toll on the defendant because they were not frivolous.
Yeah. It's so maddening. Like we should actually be encouraging more defamation cases in situations where where the statements are false. Like this is basically saying some people should be defamed and should have no remedy to that because it might silence people who like
defame people.
Yeah. Oh God, no. Yeah. Like this is basically saying the rule of law should be thrown out in favor of the popularity of the decision.
No, the rule of law should work for the quote unquote good people, not for the quote unquote bad people. We apply the rule of law to achieve a means, rather an end that we think is good because people good, bad people bad.
So a New York decision accurately assessed the problem when it dismissed a defamation claim by an accused abuser, holding that the lower court's decision allowing the claim to proceed has the effect of emboldening sexual assaulters who seek to weaponize the legal system in order to silence their victims. Maybe I want to look at this case sometime. As it noted, sexual assaults remain vastly underreported, primarily due to victims' fear of retaliation. It does not escape us that defamation suits like the instant one may constitute a form of retaliation against those with the courage to speak out. Most victims cannot afford years of litigation, nor do they wish to have their personal information disclosed through invasive discovery or to relive their personal trauma through litigation, including depositions, filings, and testimony in court. They do not wish to endure continued unwanted interaction with the person alleged to have assaulted them through the litigation process. I'm going to bet that they made findings about the case itself being without merit and without sort of grounding for it. I'm going to bet that was also in there.
Here's the other part. You don't have to write an op-ed. Like if you are a victim of abuse and your partner is that much of a problem in your life, you don't have to write an op-ed.
You really don't. I've written very few op-eds in my life.
Right.
So they believe that this court should hold as a matter of law that the opinion editorial drafted by Ms. Heard was opinion written to address the problem of retaliation in Hollywood about men who abuse their power to harass and assault women. How is this matter a matter of law when it's clearly a matter of fact as to what it was written, like what it was?
Here's an opinion. Parents should inform schools that their children have certain medical needs. That's an opinion.
Yeah.
But saying that in the context in which it's said makes a factual assertion.
Yeah. So she wrote about having suffered abuse at an early age, including me. And you know what? Had she left out the specific reference to Depp, I think she probably would have skated. Like if she'd left out the 2 years ago, I don't think anybody would have sued her over that op-ed. Like if she just said, by the time I was of college age, I was harassed and sexually assaulted, and sexual assault bad, I think she'd have been just fine. But she had to make the specific references that everybody knew referred to Depp. Generally, a statement of opinion relating to matters of public concern, which does not contain a provably false factual connotation. Oh, we're done here. We are done here. Will receive full constitutional protection and not be considered defamatory. The jury found that it was provably false. And not only that, they found actual malice. Like that she knew it was false, not just anything else. So, yeah, pure expressions of opinion not amounting to fighting words cannot form the basis of an action for defamation. Oh, unless you also have factual implications, which they did. So all of this just, I don't see how they determined this as a matter of law. This was clearly a matter of fact. Although every fair inference must be drawn in favor of Depp in determining whether the words and statements complained of in this case are reasonably capable of the meaning ascribed to them by the alleged innuendo, the meaning of the allegatory defamatory language cannot by innuendo be extended beyond its ordinary and common acceptation.
Are you sure we didn't need to do that?
Yeah, we don't. The province of the innuendo is to show how the words used are defamatory and how they relate to plaintiff, but cannot introduce new matter, nor extend the meaning of the words used, or to make that certain which is in fact uncertain. Except like when we look at our cheese pizza example, you can still interpret cheese pizza as bad pictures, right?
Yep.
You can't hide behind, oh, I didn't. This is like the thing where
this is your Bailey and what's the castle one? What would you call it?
Mott and Bailey.
The Mott and Bailey, yeah. There's that argument.
And this is also like, you see kids doing this where they like put their hand in their face and they're like, I'm not touching you. I'm not touching you. I'm not touching you.
Mm-hmm.
It's like, if somebody does that, you probably can actually, respond. Now, I'm not saying call a lawyer before you do anything, but just saying you can't normally do the, I'm not touching you, especially in courts, right? Like courts deal with this all the time. Like I wasn't selling meth. I was selling rocks that just happened to come with a bag of meth. Is a great way to go to jail for selling meth. Like, you buy this rock for $40 and you get free meth with it. Everybody knows you're selling meth, right?
The funny thing is they cite Pendleton for something that Pendleton doesn't say.
Any matter that can be considered in evaluating the statement must be within the publication itself,
that is
or within the public's knowledge in the immediate past. Oh,
that is not what Pendleton says. They didn't set that as a bar.
Yeah, it's not intended as a bar at all. And I see, have they lowered the standards for the bar exam recently? This is Daryl Brooks level incompetent. This is not incompetent.
It's not incompetent. This is actually very. It's good. It's not incompetent. It's just making a very bad point.
Well, it's not incompetent. It's written for an entirely different purpose. It's not written to win the case, and I'm gonna make an argument that it's written for the opposite of that when we get to the bottom of this, because Ms. Heard's opinion editorial focused on the treatment that women who spoke out regarding abuse received from the public, but it also mentioned, it
was also, and someone else made the point, it was edited multiple times to the edits and how the edits were done by the ACLU. People in the chat are very correct and very astute. The ACLU basically drafted it. There were edits to basically narrow it down to make it very clear that it wasn't just referring to her past, it was referring to something that was more recent to the article's publishing. Yeah. So
And because they didn't contain a provably false factual connotation, Amber Heard testified that that this was referring to Depp. Done. Like, yeah, like, were it to be held otherwise, this precedent would have profound effects on the amici and their ability to opine on the prominent issues of the day.
I really want to see who these freaking amici are. I'm sorry.
Yeah, I'm wondering if any of them. I'm wondering if one of them's the Rolling Stone.
Oh, please be the Rolling Stone and cite
Please
yourself.
be the Rolling Stone and cite
Please
themselves.
be the Rolling. Please do that.
You know, if it's the Rolling Stone, I know what I do if I'm Ben Chu. I cite the F out of the case where the Rolling Stone lost.
I just drag them.
Yeah, drag them all the way under the bus. Yeah, that's just, yeah.
The bus that Jason Momoa body checked down a ramp to go straight towards them.
I kind of want to see that in a video or in a movie now. Jason Momoa needs to like pound a bus. So, to affirm the verdict in this case is to chill the First Amendment right to express one's opinion and encourage frivolous defamation cases. Now, I mean, I think that this is bullshit, but at least it's actually within the confines of what an amicus should be opining on. Like, this at least says this will have First Amendment implications that might affect somebody outside the parties. Like, the other amicus brief is just purely verdict bad, we angry. This one actually, like, so, yeah. I see Pikel says, Ian has a crush on Aquaman. No.
No.
As I said, he's not even in my top 10 actors. Johnny Depp is higher, but also not in my top 5. Sorry, fans. I just, yeah. Abuse in the op-ed was a subjective perspective. Okay. Yes, it's a reference to abuse and domestic abuse are subjective opinions of her perspective, not a verifiable fact that could be defamatory. I mean, at this point, you're basically saying she was making stuff up and believed it.
We are so far down the rabbit hole.
They basically want to redo the, like, this is an argument that could have been made at trial.
Trying to go back and redo the trial.
This could have been a winning argument at trial. She's so far up her own butt that she thinks this is, real because she's got a mental illness. Her mental illness causes her to reframe everything in the context of she thinks like she is the victim of everything. She imagines abuse where none is, but she believed it and therefore not actual malice. Boom. I mean, that's a winning argument. I think they could have sold to that jury that she was, offer. And I mean, I don't want to insult all the people with BPD out there, but I mean, I feel like she's an extreme case. I feel like she's an extreme case who's not managing it and who is causing, causing harm to other people because she's failing to manage it. But yeah, I think it could have been a winning argument to say she's got issues. It was in her head, but nope. The statements represented her viewpoint regarding her experiences, except her argument was that these were actual facts that actually happened. So you can't make this argument at this stage.
You can't get up on the stand and say things occurred and then have those proven false.
Yeah.
That's not how that works.
I mean, the thing is that they could have actually put her up on the stand to say, hey, listen, all of this stuff actually happened. And then you just call an expert to say she's gonzo, right? Like, she doesn't know where she is from, she doesn't know what's happening. She makes stuff up that didn't happen. She's confused, right? And then you can have her testify to all sorts of things. And
imagine Amber Heard signing off on that.
Oh, I mean, it would have been freaking hilarious. But, I mean, it would have been a winning argument. Like, you would have won the defamation case on that. Because she gets up and tells like wild stories about I was dancing across broken glass. People would be like, yeah, no, she's imagining things. She believes it, but she's imagining things. You could have sold that. So yeah. she would never have gone for it. And the thing is,
it was a toilet.
It ends her career is the other point, right? Because I mean, they just can't. It's like, I remember that the ACLU's rep testified in court that they wanted it clear it was about JD.
They did.
Yep. So, why are they making this argument when it's very clear that it's the opposite? The term abuse as used by Ms. Hurd is subjective. It is an opinion in the eye of the person who has been subjected. And the thing is that the jury could have found that she meant insults. That was open to the jury, but they didn't. So, Oh, this is killing my will to live. I need to put my pocket knives away because this is just like, will to live diminishing. During the trial, there was uncontroverted evidence regarding actions by Mr. Depp that constituted abuse from the perspective of any woman. Well, again, you start this brief with the quote from what you say is a juror that says that they understood that it was meant to imply more than that. Cool. For example, a commentator speaking generally about racial violence perpetrated in the past by white supremacists could be sued by a white nationalist group that had only engaged in verbal, not physically, racially violent attacks.
Go to that footnote. Where is it up there?
I want to
37.
Where is it?
The speaker. So this goes back up. So it's the top of the page. So go to the previous page.
So to affirm the verdict in this case is to chill the First Amendment right to express one's opinion and engage frivolous defamation claims based upon what a claimant can imply from what is spoken, rather than the actual words of the speaker.
And then the footnote, for example, no. Let me change this. Let me change this to make this example appropriate. On such and such date, following an event that every single person knows who was there, I was subjected to racial violence and subjected to racial violence and I became outspoken against racism. The thing is, if I'm referencing an event that took place where there was one other person, and I say I was subjected to racial violence, that's where that actually makes sense. But even then, this is not a commentator. This is a participant. This is someone who was the victim of this. Like, this hypothetical is the dumbest version of a hypothetical.
This is like insulting. If I was on the appellate court, I would be looking at this and I'd be going, counsel, how stupid do you think we are?
Well, and that's the thing. The last thing you do is feed the appellate court bad hypotheticals, because the appellate court, I don't know if you guys have watched any appellate litigation. They ask you questions in hypothetical format. They are masters at creating hypotheticals because they want to get to the root of the law, the root of the issue. Yeah. This is the dumbest thing to do to an appeals court.
You're just feeding them a bad scenario for them to just dunk on you with. In fact, when you do this, you might end up spending your entire appeal time, if they get appeal time, arguing this stupid point and getting dunked on, and then they just ignore everything. And I see Bees on Mars, who I assume is black, saying, FFS, leave black people out of your mess, Amber.
Yes.
We want no parts of this. Oh my God, I'm heated. Yeah. The whole thing about Amber borrowing other people's trauma to make up a BS story to go after people, I'm like, up yours. But also now she's going after the black community. She's like, whatever she can do. It's just
it's the black people have to side with me now too. That's what it is. Like,
yeah,
if you're black and you've been subjected to any racial violence of any sort, you have to side with me because you could be next. No, that is exactly what she just did. That is what that hypothetical was intended to do. Yeah. No, the black people in the chat have respectfully requested you keep their names out of your mouth.
So they have like, picking up her phone and slamming it down, ending the taping, assaulting kitchen cabinets with kicking and slamming. I mean, the thing is, the jury didn't believe that that was what was intended to be communicated, right? So punched a bathroom sconce during an argument with Ms. Heard in the Hicksville trailer. Again, they didn't believe that, that they were referring to insults or, or smacking around objects, right?
Go back up to the effing C word one. Like I reread texts where she literally said, "I love you, you effing C." Like
Oh. Mr. Depp sent Ms. Heard messages, her text lambasting her while she was at a coffee meeting, stating that the meeting is for horrors. Part of her, again, like I
love
read
that they say that every person could read this as being obvious abuse, and they have to put a parenthetical in there to explain why it could be viewed as abusive language.
And the thing is that I read this as like a caution of like, hey, you're going to get a shit reputation in the field you want to excel in, and you need to not be there. Like, it's like the same thing as if you want to be a screen actress, but you also want to do porn. You're going to have to pick one because doing the porn is going to prevent you from doing the screen acting, right? It's just, this is the culture that exists there. And there's nothing wrong with people who do sex work and porn and all of that. I'm, typically supportive of that as a, like people can choose what to do with their bodies, but you got to realize that there are, you also got to know that there's potentially consequences to this in the real world. Like, because the real world sucks. I don't see anything wrong with a, somebody who works at an office doing OnlyFans on the side. Their call. But you got to realize that some offices will fire you over that. I don't think they should, but it happens. So, he wrote incoherent sexually harassing messages attacking Ms. Heard on mirrors, walls, and lampshades while causing $70,000 worth of property damage.
I don't think that was uncontested. I think that was subject to dispute, and I don't see how writing that stuff on walls and mirrors.
What also was the context to that?
They're not going to give it to you.
Was like a body part cut off?
Maybe.
Like, I feel like that's a relevant context, right? And I mean, this is kind of like writing a thing saying, this person shot me and therefore should have, should be liable for all this damage. It's like, but did you shoot them first? Because if you did, you're not winning on that claim, right? And I see it was 50,000 in the other Amicus brief. I mean, the amount's going to keep going up. Yeah, during the tape, an audio tape was played for Mr. Depp. I headbutted you in your... I couldn't believe you did that forehead. That doesn't break a nose. I mean, there was context. Mr. Depp was asked about this interaction, and
it was not an intentional headbutt.
And he said it wasn't an intentional headbutt. Nobody thinks unintentional things are abusive. Like, although Mr. Depp claims that he did not intentionally headbutt Ms. Heard, under Virginia law, Mr. Depp's testimony was an admission by Mr. Depp that he abused Ms. Heard. I think
headbutt requires context because I say headbutt and it could be I bump my head. Oh my gosh,
his statement about at trial that the headbutt was not intentional. The definition of family abuse under the Virginia Juvenile and Domestic Relations statutes does not require intent or willingness. I haven't looked this up.
Here's the thing. We're going to cite 16.1228. 16.1 is the chapter that is applicable to JNDR district courts, not circuit courts. It's not applicable to this particular court proceeding. It has no binding effect on anything in the circuit court proceeding. It is exclusively for the dominion of juvenile courts in ruling on protective orders involving cases of family abuse. And the definition is exceedingly broad and includes damn near freaking anything, because the courts need to be able to understand the context of the situation to make an appropriate ruling. Sorry.
Now I'm just looking here about, you know.
And it's not 228. Where is it? What is it? It's not. I think it's 220. It's 270. Look at 278.1.
Okay, I'm looking at 228, which does have some relevant stuff to it, but
family abuse as defined. No, family abuse as defined in the code. If you look at 278, that I think is the protective order statute, but the definition section in 16.1, yay, code 16.1.
I mean, this does have abused or neglected child.
Yeah, it is 228. So family abuse as defined. So if you go down to family abuse, F, family abuse means any act involving violence, force, or threat that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury, and that is committed by a person against such person's family or household member. Such act includes, but is not limited to, any forceful detention, stalking, criminal sexual assault in violation of 18.2, 61. So basically criminal code section 4, sexual assault, or any criminal offense that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury. See what I mean when I said that it's so broad that it allows for a lot of context to be read in, because everything is really important.
I also don't think that they would take, like, I read that they talk about violence, right? Most people wouldn't understand unintentional things as violence.
Well, when they say violence, force, or threat, all of those are intentional acts. Intentionality, by reference to 18.2, by reference to the criminal code, includes an element of intentionality. I have never in my life seen a judge basically say protective order for something that was entirely unintentional.
Well, as an example, I sustained a serious injury as a kid. My ribs are, still messed up. My back is messed up. And the reason why is because bad ankles run in my family, and my dad blew out his ankle and fell on me. Like, I sustained a serious injury. But you're not going to base a family law, like Child Protective Services isn't going to come in to be like, this guy blew out his ankle and fell on his kids. So, like, the notion that you can apply this to unintentional stuff is like neglect. Sure. Like child neglect, but it's hard to neglect an adult. Oh, this is maddeningly, like, I do moot court judging sometimes, and moot court judging involves like junior students who are doing fake court stuff. And if I got this from a junior student and it included these kinds of misleading statements, I would spend their entire time dunking on them for this. And, afterwards, my commentary would basically be, you need to not say stupid things in your brief, or else you will have a bad time. This is bad. Analogous situation is to the issue in Fairfax versus CBS Broad Incorporated.
It was the lieutenant governor pursued,
based on its interviews with women who alleged that he had AR'd them many years before they announced their allegations. He also complained about sympathetic comments by the co-hosts of CBS's morning show after the interviews were aired.
Look who the defendant is. Scroll up.
That's CBS?
CBS. Different fucking case. You're not suing the actual person who made the statement.
Federal court granted a motion to dismiss the defamation claims in that case, explaining that the relied upon commentary, when read in context, does not ascribe to any particular view of the underlying events, but rather on how persons who believe they are victims of sexual abuse are affected. Yeah, but you're also suing the news reporters who are just reporting the allegations, right?
Yeah, that's not the same.
Oh, very different. Oh. See, if accidental headbutt is a crime, my dog needs to go to jail.
And toddlers.
Well, I have like this dent in the drywall, and that's because Potter had a derp moment. Potter's a big dog. He's not a small dog. He fell off the bed without any help. He just fell off the bed and put a hole in it. Like, yeah. So these exact same words could be said of the op-ed published by Ms. Heard.
No, it can't.
No.
It cannot do that thing. Oh, no. Because one is CBS and the other one is the actual person. Oh.
Yeah.
Oh, your hypothetical is so dumb.
All right, I'm moving past this hypothetical because it is.
Stop making sense.
Yeah, it's. See, alleged abuse defamation was not based on facts that were verifiable, except that they totally were. She came in and explained what they meant. A recent decision from the Western District of Kentucky regarding another highly publicized incident is instructive. That's the Sandman decision. That one is politically contentious. Whoops, and I somehow jumped there. In that case, a student wearing a MAGA hat, Sandman, stood in front of an older Native American man, Phillips, while the latter attempted to go to the Lincoln Memorial to engage in a tribal ritual. After the incident, Phillips was quoted by a newspaper stating that Sandman just blocked my way and wouldn't allow me to retreat. The plaintiff initially filed cases against several news organizations on several grounds, but the court dismissed all other claims, narrowing the issues to whether the newspaper's publication of this discrete...
this is so stupid. This, again, is the wrong hypothetical. Oh.
The thing is this is the right hypothetical for their purposes because they really want... they want to cite to as many high-profile cases as they can.
But it's media. You're not suing the person who said the thing. Oh.
Hand Banana Nose says, if you skip over the stupid parts, you won't have anything left to stream. Yeah, I could just hit end and we'd skip over the stupid parts. But I feel like at this point, we covered that last stupid and we can move on to new and fresh stupid.
There's so much stupid.
Trufflehound has a great quote. I'm reminded of an old Australian saying, you cannot polish a herd, but you can roll it in glitter.
Jesus.
The Aussies have some great sayings, and that's just fantastic.
That's pretty good.
So Philip's statement that Sandman blocked him and wouldn't allow him to retreat were objectively unverifiable and thus unactionable opinions. Instead, a reasonable reader would understand that Phillips was simply conveying his view of the situation. The court further explained that generally blocking is an imprecise term capable of different meanings that lacks a plausible... Yeah, unless there's context in a larger world. Because this was a very discrete event, right? Like, Sandman and Phillips never met each other before this. They had no history. They didn't... But the implication involves the other sort of... So basically they're saying it's an imprecise term capable of different meanings that lacks a plausible method of verification unless you've got somebody who gets up on the stand to testify to exactly what they meant. Oh, right. That happened.
Mm-hmm.
So in the present case, Depp's counsel focused on just a few words and then merged those comments out of context with statements and acts that occurred more than 2 years before, which provide the necessary context. Statements in the op-ed cannot be the basis for a finding of actual malice. You know what can be? Her testimony.
Mm-hmm.
Like, she testified.
Mm-hmm. Mm-hmm.
And, I see this is a very... Amber is no longer a person anymore to these groups. She's a hill to die on, the corporation to stand up for. To them, she is the same as CBS. It's actually kind of ironic because Amber wrote this big thing about there's so many people on the ship who are committed to this, version. And that's how she's running this. Yeah. I mean, at least the notion of we need to expand the notion of protected speech is at least something that an amici can speak on. So at least this is written as an amicus brief in some parts. So basically they're once again going with the amicus, or with the this broad notion that abuse includes everything, and they're basically saying that abuse can never be the basis of a defamation claim.
Yes,
what this argument
that is their whole point. There's their whole point.
And
Abuse
so,
can never be defamation.
Well, they abused me. Like, would they actually want this implication? Like, because if you accept this, then like, somebody who comes forward to say that these lawyers, somebody who came forward and said these lawyers sexually abused me, their implication would have to be that they have no claim, because that's a meaningless term that could be interpreted as anything. And it's like, no court should ever accept that. That would be an unreasonable position. And just for the chat, this is a hypothetical, not a, not an actual scenario there. Yeah. I see this stream has been going on so long that I had to refill my massive Stanley tumbler that EDB influenced me to buy. Had a rum and eggnog there. I feel like I need a tumbler.
I can send you a link. They're very effective.
I got Scotch glasses, so yeah. I see Pickles has a good comment there. I will straight accuse all of them of abuse. They've abused my brain. Yes. Mm-hmm. This is definitely not lawful law. Mm-mm. Yeah. Grounds. Mm-hmm. No defamatory facts could reasonably implied in the op-ed written by Ms. Heard. Again, the jury had to decide what was implied. So they're trying to say that the jury was unreasonable here. Good freaking luck. Where the statements of fact are literally true, but by an implication arising from them are alleged to be false, the alleged implication must be reasonably drawn from the words actually used. Okay, like this is our cheese pizza example, right? In context, people understand what cheese pizza means. And, like you can say, hey, we've seen this person use cheese pizza before to refer to this. His audience would know that. Like, that is
what that means.
Yep. In the present case, the statements made by Ms. Heard were on their face true.
Oh, this is the hill you want to die on. Oh,
This is basically find the jury is dumb.
Mm-hmm.
And interpret this as literally as possible.
Mm-hmm.
Also, I feel like I can never order a plain pizza again in my life.
No, you ruined it for everybody.
I was using bad pictures. So, because I've used that before in videos. Like I've been saying, like I've said,
no, you were suggesting bad pictures. You were not using bad pictures. You were using cheese pizza to refer to bad pictures.
But I mean, in prior videos I've done on some case law, I've been like, this is a bad pictures case. Now,
yes.
Bad pictures,
yeah,
people know what that means, right? And so if I said something like, random person from the chat likes bad pictures, people in my chat would know what that means, and it would be defamatory if it wasn't like something that I knew. So yeah, this is basically just saying we have to read everything in its specific literal context, like literal thing, and you can't, which again is completely contradicted by, what was the case you just reciting?
Pendleton.
Starts with P. Pendleton.
So it says Pendleton, under Pendleton you lose, also Pendleton doesn't work. That's what it says.
Yeah, throw out Pendleton because,
Mm-hmm.
Mr. Depp stretches the meaning of the words used by Ms. Heard beyond their normal meaning and reasonable construction. Statement that Mobil Oil president set up his son in business could not be extended to interpret that president had set up his entire business relationship to benefit son. The thing is like, that makes sense because those are very different statements.
Yes.
But the thing is, as crazy as this is, I find myself thinking, if you had the worst appeals court, could they latch on to this?
I don't know.
I don't know either.
I can't. Having argued in front of the Court of Appeals, I can't see them.
Here for years says there's nothing wrong with having pineapple on pizza. I don't like pineapple on pizza. So long as I don't have to eat it, you can put whatever you want on your pizza, including, like, lint and drywall shavings. But yeah, do not put pineapple on a pizza that I'm going to be expected to eat. Republication of the headline written by a Washington Post staffer cannot be the basis for liability unless she approved it or, say, republished it somehow. Did she ever, like, republish using
maybe
some sort of
quote tweet, maybe adding to it or providing context? It says, today I did this. Gee, I don't remember. That might have been a part of the trial.
Yeah.
Bathroom break.
Under the single republication rule, a statement on a website is not republished unless the statement itself is substantively altered or added to, or the website is directed to a new audience. Like, say, your Twitter feed as a new audience, or added to by adding things with a quote tweet. A mere hyperlink without more cannot constitute republication. Gee, well, it's a good thing that they added more, isn't it? Like with that quote tweet. Mother. Yeah, all of this is ignoring the actual argument on this point. And had it been just a retweet without a quote tweet, I think that they could have gotten that statement tossed. I think as Karate might have said, you know what, I'm not going on that. This is just... So it's uncontested that a Washington Post staffer wrote the headline, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change, or that Ms. Heard did not participate in the creation of that headline. Yeah, it's just that she retweeted it. It's uncontroverted that Ms. Heard sent out a message on the social platform, forwarding an online copy of her article to her followers on that platform without adopting or addressing the heading. She did quote tweet it, though. You are leaving out that she added to it. So you are leaving that out, and that's that's open to the court. So they say the facts are not sufficient to establish that Ms. Heard's lone tweet was a republication, which again is a question for the jury. They found otherwise. They're basically saying no reasonable jury could have come to this conclusion. I think that's too far of a bridge.
No, this is dumb.
No causal connection. This is just denying that the world exists. Like, this is just saying, like, I don't have a Scotch glass in my hand, because he provided tons of evidence. Like, there was a whole bunch. Mm-hmm. It was a boring day.
It really was.
They had, like, the day where they had all the experts was super boring.
Sucked.
And it sucked. But it existed. I know it existed because it felt like 3 freaking days. And it was just so, like, they definitely did call evidence on all of this stuff. So given that Mr. Depp was awarded $10 million in compensatory damage, due process requires some basis for such an award. I mean, at Depp's level, that's like 1 or 2 movies. Like, literally, it's just, does the jury find that he's lost 1 or 2 movies? And I can see you got your head on your hand because of the headache and because of the
it's a combination.
And so your webcam doesn't know whether to focus on you or your curtains.
It's like I'm fading in and out.
And I'm just like, this is the perfect communication of your mental state. It's just like
it's like fading in and out.
It's like fading in and out and just my head. if large claims for defamation can be awarded in the absence of evidence of causation of harm, like they literally only had to think that he lost a movie or a few movies. Like that's it. It's real easy. I mean, even just merchandising rights. If he's, I see, not even Runkle. He got 50 million for The Last Pirates. So if he lost a fraction of a movie, Mr. Depp's counsel presented a distorted view of whether the op-ed actually caused harm to Mr. Depp. There's no evidence that any Hollywood or other movie executive relied upon Ms. Heard's vague references to her being ostracized. I mean,
let me bring up a point here. So someone in the chat was making a comment about how the standard of review, etc., how it would take it back to before the trial had happened. The errors and the assignments of errors that the amici have attached themselves to are that the jury got it wrong, not that the demur should have been granted. The demur being granted, that was an assignment of error, but the amici have not latched onto those. The amici actually haven't specifically delineated any of Amber Heard's assignments of error. Right now, they're just making general assertions. That's why the frustrated face. They're challenging the jury verdict. They are not going back to any of the earlier pleadings. So no, this is all post-verdict, attacking the verdict itself.
And Lori, Lenny, hold the green peppers on that one, but otherwise I'm on my way. Talking pizza now. Because, on the contrary, there are numerous prior publications demonstrating the risks and danger of employing Mr. Depp. And there was expert evidence to say this article tanked him.
Isn't it great that there's conflicting testimony and conflicting testimony gets provided to a jury to parse through the conflicting testimony? The jury makes a decision based on what their interpretation of the conflicting testimony is. Isn't that the cause of jury trials? I'm sorry, my brain is just like in.
And isn't it great that the competing or that the appellate standard is basically if conflicting evidence, then go away. Like that is the standard, right? If you have, I gave the example, I think it was before you were on, you might've been in the chat. If you have a house party and 5 people say Bob shot Frank and one guy says Frank was shot by accident because a dog stepped on the gun, that guy could be a known perjurer and could be, could have been drunk at the time. And, other people, like the 5 other people say he wasn't even in the room. He was out back having a pee. The jury's still entitled to believe that dude.
Yes, and the jury's allowed
to
believe anything they...
And they're not going to get overturned on appeal. Like, it's going to be, we had 5 witnesses who are better witnesses. And it's like, no, better witnesses is the jury's question. Jury decides better witnesses.
The thing is, the guy could have been like, yeah, I was hammered, but even when I'm hammered, I remember what happened. Like, and it could have been completely believable. You guys all probably have that one drunk friend who's like, yeah, he was hammered, but I trust him. If he said he saw it, he saw it.
Yep. And I mean, friend of mine often is not accurate in his recollections intentionally. And you tolerate him for other reasons, but he also has a super bad tell that unfortunately I can never get him to play poker. I keep trying to lure him into poker, but
Ian, did you really say my dog stepped on a gun?
I guess I did.
Like my dog stepped on a bee.
I guess I did. I didn't even think of that aspect. Oh God. You shouldn't have a gun out where dogs can step on it. Lock it away with your bees. So, yeah. So Disney's corporate designee testified that Disney had found no copies of the op-ed or emails discussing the op-ed in its files.
They don't need it. They don't fucking need it. Why are you arguing this?
And here's the thing. The jury can can decide upon watching him that he was lying and that in fact he did have all of the, that he did have copies and that they did rely on it. The jury would be entitled to make that conclusion based on him denying it. Like a denial of something by a liar can be taken as an affirmation of it in fact. Like, yeah.
This is so dumb.
Matthew Madu.
Yeah.
Really?
This brief is dumber than that argument or that statement.
Yeah.
This brief is dumber than these jokes.
Oh.
Right at this point, it is. It's just getting it.
It is also alarming that the verdict was allowed to stand, given the utter lack of causation evidence showing that this one op-ed was the source of Depp's financial troubles, especially given Depp's previous unsuccessful defamation suit regarding statements for the English newspaper The Sun in another court. Like, you can be defamed more than once, right?
And it can reach different audiences and have different effects.
Yeah, I mean, it could be that the Sun's publication prevented him from getting any work in the UK and diminished, it might have cut in half his value as an actor. But that still leaves half, right?
Oh my gosh, people are doing BB gun emojis in the chat. I'm sorry, I'm finding the chat far more entertaining than this stupidity on the screen. That's my apology.
Stupid. I wish I was the appellate court, because it would be so entertaining to have these people in to defend their motion. Just be like, let's talk. And normally these motions are limited to 20 minutes. We're going to grant an extension of time to 6 hours because we just got some things to say. Like, we're granting this extension unilaterally because we're gonna have thoughts.
And I have circulated a pen and paper for all of my colleagues on the Court of Appeals to ask the funniest questions, and I will read them out, and we're going to have you answer them.
Yeah. It's understandable that the jury was misled into believing that there was such a connection.
Oh, good. Jury dumb. There you go. Good argument. Let's hang our head on that.
I mean, the thing is if the jury was misled, then those are the facts. Like, that's it. Like, you don't get to do that. This is not an argument you get to make. Should have dismissed this action based upon comedy, which basically means we are respecting this other verdict.
This one's going to get tossed real quick.
Yeah. There is no way that a U.S. court is going to find that they have to surrender deciding on issues to a UK court.
Yep. And I can tell you the Court of Appeals is not going to die on the sword. Like, they will not do this, period.
Yeah.
I will give it a 92%. And Ian knows me. I don't hedge bets like that. Like 92% is Court of Appeals going to just say, nope.
So, so the UK court further found the abuse to have sexual dimensions and prodigious amounts of property damage. I mean, one of the reasons why the Fairfax trial court held that the libel laws of Virginia are starkly different than those of England. The Declaration of Independence and the First Amendment to the United States Constitution represent major departures from the English common law with respect to freedom of speech and freedom of the press. And they say this is illogical given that First Amendment protections would have protected Heard's speech, not Depp's interest.
No. What it actually means is that the U.S. has an entire body of law. The U.S. has an entire body of law focused on those first two principles.
Yeah.
Which means that while English courts in common law have a path where they have adjudicated rights and responsibilities under their version of the law, we have a dissimilar interpretation based on our First Amendment principles, and that's been adjudicated for 200 years until we've gotten here.
And so the other really entertaining aspect of this is, like, there's a countersuit, folks. So the court's going to hear both, and they're not going to dismiss half of it based on, like, sorry, how the Declaration of Independence affects the party's legal interest regarding defamation in this matter is a mystery to Amicus. Well, figure it out before you file a document.
The Declaration of Independence would respectfully like to be removed from this conversation.
This is the kind of snark at the lower court judge that you need to have receipts on before you start trying to dunk on a judge like that, especially before you start trying to dunk on Ascarati's which judge again?
Chief Judge of Fairfax Circuit.
Chief Judge. So not just like, hey, this is rando judge, or like judge who was just appointed 15 minutes ago or just elected 15 minutes ago if it's the States. This is the chief judge. You don't get to snark the chief judge like this without bringing the receipts first. Like, this is a dick move.
It's a bold strategy, Cotton. Let's see how it plays out for him.
This is the kind of dick move that gets the appeals court to go, we have some opinions that we would like to express about, the case of shut the F up. So, yeah. Oh. And, I mean, the thing is that I suspect that another reason why the court, wanted to hear this one was that there were allegations that that the facts relied on by the UK court were in fact false and established credibility issues. And this trial showed us that those were false, right? The UK court relied very heavily on she donated the money.
Yeah.
We know that's not true. And one of the ways you break comedy issues and break is they relied on facts, or they relied on things we know to be false. In the current age, when a fact is published in one form, it is often picked up and republished in various other media. Claimant should not be able to sue one publisher in one jurisdiction and lose, and then sue another publisher regarding the exact same facts in another jurisdiction, hoping to get a better result. I mean, this is actually basically a statement that the U.S. does not get to have its own law.
Yep.
Because they're saying here that if you get, the U.S. can have different legal standards than other places, right? And so you can, hey,
if you say stuff in different jurisdictions, you're subjected to the laws of the jurisdictions where you say the things.
Well, as a really sort of strong or really sort of potent example of this, bad pictures that are drawn are legal in the U.S., but not in Canada, because we have a different tradition on First Amendment, like freedom of speech. In the U.S., it's the First Amendment. In Canada, it's 2A charter rights. At least 2A or 2D. I keep forgetting. Anyway, freedom of expression in Canada. I'm not good with the remembering the numeral or the numbering. But so Canada has a different tradition on that and bans depictions. So let's say somebody is in the States and they get charged for possessing a particular bad picture. And they win that trial because at that trial, it's determined that that bad picture was actually a photorealistic drawing rather than a photograph. Okay, they've won that. Then they get on a plane and fly to Canada with that same picture. There is not a snowball's chance in hell that the Canadian court is going to say, well, this was already litigated and you're good. They're going to go, yeah, this was already litigated and we're going to litigate it again, and you go into jail because and if you published a news article with that picture in it and then you republish that in Canada, yeah, there were this is such a ridiculous thing. And then they go, while there may be exceptions to this rule, such as jurisdictions in which the rule of law is not given the same respect as that of our Commonwealth, here Mr. Depp got a second bite at the apple on the very same facts upon which he had already lost in a case in the United Kingdom, except those facts didn't include this new publication and different law. The second bite at the apple is language that is used in appeals courts. And it's typically used where you're trying to pull a fast one. So, for example, let's say that they try Rittenhouse for all this stuff, and Rittenhouse is acquitted. And then they decide that they're going to try to use some procedural screwery to reopen the file. A court might say, no, you're just trying to get a second bite at the apple. You don't get to do that. Second bite at the apple is typically, sort of forbidden. But this isn't a second bite at the apple because this is a new apple. It's an apple that didn't exist at the time. See, didn't we leave England's rule for a reason, or 10 plus more? Why would we follow their court ruling here? Yeah. That might be why the Declaration of Independence was cited by a Marine. So, what is more galling is that Mr. Depp was the one who filed the UK action, and he was the one who chose to litigate that case first because it was in the UK, relying on the more favorable standard of review. When he lost in the UK, that decision should have shut down any further actions based upon the same facts. It did. I mean, he wouldn't have been able to sue the Sun in... I don't think he would have been able to sue the Sun in Virginia.
Or here? No.
But he can sue a different person for making a new statement. Like, this is such a... I don't like this argument. So, conclusion. The trial in this case was not about any defamatory statements made by Ms. Heard within her op-ed, but was rather a vendetta for all of the publicity surrounding the allegations of abuse by Mr. Depp from the date that Ms. Heard sought and obtained a restraining order in May 2016 up to December. I mean, a vendetta for the publicity surrounding the allegations of abuse is exactly what you are expected to have for a defamation case if those allegations are false. Like, that is, in fact, the purpose of defamation law, is to recover for damages caused to you by negative publicity. So, defamation lawsuit based upon this op-ed was not the legitimate vehicle for remedying Mr. Depp's dissatisfaction. That was, I mean, it is the legitimate vehicle for dealing with the statements she made in the op-ed. Yeah. He cannot seek retribution for the allegations that were made in the California courts regarding his alleged physical abuse of Ms. Heard, their divorce, and subsequent publicity from various venues, including the Sun. He's not. Like, and the court was very clear that it had to be confined to a particular window. Like, that was super clear in its communication to the jury. Oh. This one right. The damage that will be done if the verdict is upheld to First Amendment jurisprudence, which this case, I think, they haven't said that it doesn't follow First Amendment jurisprudence at all. The ability of Virginians to express their opinions. Again, we can slide in false opinions. Mm-hmm. And it's not even an opinion. It's a statement of fact. It's a fault, like, and the ability of women to report domestic violence for fear of retribution. Report to the police, report to the courts. Most people aren't reporting to the press. An expensive lawsuit would be no less than catastrophic. Like, at least this one isn't saying like the verdict itself sends a bad message. They are making some claims about, listen, we have to, the principles espoused are bad. At least this one is an amicus brief. It's a bad amicus brief, but at least it sort of gets to some of the issues some of the time. Would have been better if it was all of the time. But yeah, and I see here, if you aren't making bad faith claims, you don't have any fear, do you? Like, this literally says, to get to this finding, the jury had to be very clear that she was lying. Intentionally lying. Like, not I made a mistake, not I got things wrong. I was lying and I knew I was lying, right? I knew this was false, or I was reckless. But you can't get to reckless on this, right? Reckless is like, I was relying on a bad source that I should have known I shouldn't have relied on, right? Like, a homeless person told me the thing and I relied on that. But the person also told me that the Illuminati were, controlling the weather, and therefore maybe I shouldn't have listened to that person, right? That's reckless. But you can't really be reckless about things you claim to have personal knowledge of. They're either true or they're not. Absent, like, sometimes I see things. Oh my God. Comment for Rob here. Nice hair, don't hide it. People like the Rob hair. All right, I got super chats to get through because...
And I hate that I'm doing this to you, but I actually have to jump off. Like, it's 1:30.
I was going to say, dude, I was actually going to tell you to jump off because it's late. I might have kicked you out if you didn't, because it's late and you're doing the like, I can't, Yeah.
Yeah.
And I imagine you probably have an early morning tomorrow. So, yeah.
Just regular stuff. But thanks for having me on. And I'm really glad that you were covering this one.
Well, I wasn't sure because it's amicus briefs, and I was just like.
But then you read them, and you're like, I can't not say something.
Before you go, I want to share a theory with you, and I want to see what your thoughts are. My thought is that the end game of this is not to win. My thought on this is the end game is to lose, and potentially to lose badly, in order to then be able to once again spin the PR and say, the court is against women because they didn't even listen to the amicus briefs.
It's possible. It really is. There was no, the assignment of error. There was no statement of the standard of how the court was supposed to view this. This was messy from start to finish. It was messy. It was filled with conclusory statements, a lot of vague assertions. It just not effective legal writing.
Yeah, well, especially the first one, which is basically just, we don't like the verdict because, the verdict sends a bad message, which is ridiculous. And, and jury too stupid to make decisions is really what the first one comes down to. So the second one, at least, is written, I could see them. I think it's more likely that they throw out the first than the second. I could see them not accepting either, and I can see them not rejecting either. All of those are within the realm of possibility. Personally,
I think they're going to accept them. I just don't think they're going to read them.
Yeah, I suspect that they say, fine, you can file them, and then make no reference to them. Mm-hmm. I would be upset if I found one of these amicus briefs in my bed.
Mm-hmm.
So...
Yep.
All right. I'm going to get to super chats. You should get to sleep, and see you soon.
All right. See you, chat. Thank you.
Yep. All right. So Debbie Campbell, thank you for the membership. And Hitachi Singh, briefs are filled with inaccuracies. Yeah. Why is Amber Heard risking this and sending it to the judges is beyond my understanding. Technically speaking, Amber Heard should be saying that this is not mine at all. That she's not risking anything because she didn't decide to send it. I don't think that's accurate, but that is what she would claim if you asked. Mary Malarkey, look forward to a discussion with the best of the legal minds and a dash of snark. We might have had a little bit more than a dash. It's one of those, there might have been a few pinches of snark here, but Nicole Fugue, thank you very much for the super sticker. Truffle Hound, I'll be honest, first time reading this, I legit thought the Onion was on a roll. Some of this stuff in here is straight out of Ankh-Morpork, which, if you don't know, is a reference to Terry Pratchett's Discworld series. And if you don't know, pick up Discworld. I think it's a fantastic thing. I have read every Discworld book because they are amazing. It is my favorite series. So just BKZ, it's a shame that they didn't call any witnesses who could clarify the concept. Oh, wait. Yeah. I mean, they did call witnesses extensively to try to argue what that meant. And, some of those witnesses were not great. Red Beats, thank you very much for the super chat. And follow-up super chat. I'm thinking that there might have been an error in terms of getting the message out the first time, but thank you. Has Amber Heard's brief come out? When will you cover it? It hasn't come out yet, and I will cover it when it comes out. Thank you both. Let the throwdown begin. Oh, yeah, we had fun. Law and Lumber, this should have been properly styled in amicus. Torcular, I covered this one before. Friend of the press brief. Oh, where did my legal argument go? Where could she be? Let's hear that singing voice. Yeah. Charlene McKinney, thank you very much. Linda D. Beat, thank you very much for the super sticker. Much appreciated. Also, Linda DB is one of the most generous people I know. I can't give the details, but super awesome. Gun Kit Canada, what is the difference between a chickpea and a potato? You didn't pay $20 for potato on your face. Yeah. It's a good thing we're more than 2 hours in. I saw that super chat come in, and I was like, that one's going to have to wait till the end. Truffle Hound, if we're singing, I'm going Streisand. Try to understand me. Your Honor, don't you know I had no choice? Can you hear me praying anything I'm saying, even though my head is filled with voices? I don't know the song that one is, but please, VA Appellate Court, could you live stream the court yelling at the amicus brief authors and lawyers? Oh, that would make me so happy. So happy. Yeah. Yeah. Heard's legal team was such a train wreck that by the end of week 1, team 1, Amber had she's a C word and Amica cream in the court record over a dozen times. They wrecked her. Yeah, there were places where I was just like, why are they doing this? See, that joke's better when it's a chickpea or a garbanzo bean, since they're the same thing. Fair enough. Ian and Andrea, thank you. Ian, I owe you this for your stream yesterday. Well, thank you very much. Hopefully you were able to sleep. I did get some sleep. I slept in until the early afternoon, but yeah. Were you really expecting something of merit from any of this? Really? I wouldn't sign my name to either of these. And I filed some long shot briefs, but I wouldn't sign my name to either of these. I would be much happier signing my name to the second one than the first one. The first one I wouldn't like. No. Second one, debatable. It's a reach, but I don't like it. Leaving on a jet plane, Depp v. Heard trial takes me off again. Departure Lounge ballads by Truffle Hound. Thank you very much. Truffle Hound again. You never close your eyes anymore since I split your lip. There's no tenderness in what's left of your fingertip. What Love and Feeling by Amber Heard. Yikes, that got a little dark. It did get a little dark. Truffle Hound, a little bit of darkness in there. I knew Amber Heard and her followers were bug mad, but until this brief, I didn't realize just how unhinged this verdict made them. A man won and they're melting down. Yeah, it's interesting. The safest assumption is that all men are guilty if accused to make this work. I'm dumbfounded at the total abandonment of due process. Yes, in theory, the most unpopular, miserable, wretched person should be able to come before the court and have their issues heard. That's the whole point of the court system. That's why we have one. And if that's not the point, then it's not worth anything. So, yeah. The law made interesting. Thanks. Thank you. That's sort of what I try to aim for here. The law is difficult. And I mean, people sort of say, oh, Runkle, your analogy. Analogies are how we understand things. I think it's important for explaining things. I think, and typically if you can't explain something in a really simple way that if you can't explain this to a guy with an 8th grade education, then you don't know it. That's my philosophy. Fleur de Mal, and I'm not saying that the previous super chatter has an 8th grade education. I'm giving that as a hypothetical, just to be clear. Fleur de Mal, love the nickname. Hey, Runkle, between you, Emily, and Rob, do you discuss who does what live stream when it comes to Depp v. Heard? You guys rock, and it's hard to choose. We don't really coordinate. Basically, we just kind of assume that if there's something interesting, we're all going to cover it. Yeah. Sometimes I've done live streams with, when Emily is on, and, people are like, hey, love your stuff, but I'm going to watch Emily. And I'm like, cool. I love Emily's stuff too. So yeah, I get it. And sometimes people are like, hey, caught you in the replay crew. Awesome. Please advise the lovely folks in chat how many times you've seen the denial of a motion to strike a jury verdict overturned on appeal. Not common. Lumbert, the amici are clearly geniuses, clearly. I think that they're actually pretty smart. I think that they're just writing intentionally badly, or trying to write on a weak point. Chromatics, when the facts are on your side, pound on the facts. When the law is on your side, pound on the law. When neither are, pound on the table. There's a lot of table pounding in this. And a lot of, please pretend the facts are different than they are, and then we win. Well, that's great. If, it's like going in and saying to, the clerk, please pretend that the numbers on this lottery ticket are actually the winning numbers, and, issue me some money. Doesn't work that way. Accurate title. I suffered non-physical abuse in my marriage, but I gave way more than I got. Yup. This is all amazing. Y'all are right on point. Thank you. And Viking Wolf by Blood, I like the username. That is badass. Potion Master Danya, JD has been in movies for 40 years. No nudity scene whatsoever. I can understand his standards for choosing movies. Also, Amber Heard wearing very revealing dresses was Johnny Depp being controlling. Yeah, I mean, you gotta have sort of notions there. You gotta like there's videos I don't do because it would affect things, right? Like, I'm not gonna do an OnlyFans because it would affect this, right? So I get all sorts of people who say, Runkle, will you do what is it? Will you take a sponsorship from us? And I will tell you, most of the time the answer is no, because I don't want to, people will get upset. Like, you don't want to be sitting here listening to, you should play Wraith's Shadow Legends. It will drain your bank account and make you feel like crap. Yeah, no. Vibe AI, thank you very much. Hey peeps, just stopping in before the next family stop. Hope everyone has a safe holiday weekend. To all it applies, and have fun either way. Thank you. I am getting hungry now. I've been talking too much about pizza, and I've been on for too long here. Nicholas Stero, Labor Law Santa. Bad legal arguments when you can just change the name and it applies better as the points of escalating abuse. Yeah, they could have just filed this for Depp, and a lot of their stuff about abuse would have made a whole lot of sense there. Marie Arajo, are there any police reports filed by Amber Heard against Johnny Depp? Any criminal charges? I mean, they did call the police, and the police came and investigated and said nothing going on. That was part of the trial. Haiti, thank you very much. Here they talk a lot about verbal abuse from Johnny Depp, but we've listened to a lot of verbal abuse from Amber Heard in these audios. They're just avoiding that, huh? Yeah, I mean, they're presenting a pretty one-sided version of the facts. Dr. Lillian Corridor, thanks, Ian and Andrea. Feeling much better with your clarifying statements. A lot of inaccuracies in Amicus. Yes. Sometimes it's just like, are we watching the same trial here? So jury instruction 1, the jury is to reach a just verdict, regardless of the consequences. That's exactly it. This is part of the point of jury, issues. So yeah, I mean, it's basically if a verdict is the proper verdict, but would cause the world to burn to the ground, then the world's going to burn. That's how the court should work. Okay. Thank you very much for the super sticker, Jess J. Ex Petite Surge, thank you very much. Much appreciated. M169, Andrea, how are colleges permitted to handle SA cases, not appropriate courts? These are, Andrea's not here anymore, so we've got to, we've got to talk a little bit about sort of why they handle them and sort of how they handle them. These are disciplinary decisions. Like, it's not like you're going to go to jail. It's, do you stay in the university? So that's why they handle those. I think personally they should go to the courts usually. And I mean, if you go to jail for SA, you're probably not at the university anymore. So, yep. Silver Gypsy Lady, see, Amber is cute, so she should win. Rolling eye emojis. Yep. It seems to be a lot of the people out there. My first time watching was literally mid Tell the World. Wasn't that such a horrifying tape? Yeah. I see somebody saying, you're still live? It's been 5 hours. I don't make good life decisions. I stay up to weird hours. My sleep schedule is messed up, and it hasn't been right for a long time. And I'm probably not going to get to sleep for another 2 hours at least. Probably well up into 4 a.m. That's just, yeah. Viking Wolf by Blood. I'm with Andrea. I can't wait for the insurance part to come out. I want to see it all. That is the insurance lady in me. I think that was probably in me. I kind of agree. I want to see all sorts of aspects of, I want to get into because they're going to potentially put discussions with counsel at risk. And so if we got to start prying into what discussions happened between Amber Heard and Elaine Bredehoft, yeah, that's, That's going to be tasty. Totally off topic, but will one of you cover the wrongful death lawsuit? We covered this before. I will if it actually turns out Dauber is involved. That's sort of it. I don't feel comfortable making that allegation at this stage. Becky G, did they leak this to see opinions so they can change some of this prior to filing it? Might be a dumb question. I'm not a lawyer. They leaked this at the filing deadline. So I don't think that works, but it's not a dumb question. You got to ask stuff, right? Trufflehound, thank you very much. Hello, Justice. Be my friend. I want to make my case again. I promise I'm not crazy creeping. I'm pretty sure the jury was sleeping, but the visions that are planted in my brain still remain. Speak of my innocence. You are good at this. That's really good at this. Lori Lenny here. For our fathers, brothers, sons, friends, please help us shine a light on male victims of abuse in any way you can. For all victims of violence and abuse, please try to get help. We believe you. Thanks, Ian, for yesterday. There are so many, when they talk about legal abuse, male victims face so much legal abuse because there's so many times where somebody, like a guy, gets the crap beat out of him, and then she realizes that she needs to get on the phone and call the police first. And Victoria Thoms, thank you for the 499. The Cut, one of the sources, wrote an article the day after the op-ed tying it to Depp. Seems pretty clear the implication of her claims. Yeah. I don't think we got evidence on that, though. Am I one of the only one who had zero clue who Amber Heard was before the trial? I had heard that she was married to Depp. I didn't really know her anything else. Like, I didn't. But, I mean, I haven't watched, like, all of Depp's movies. I've watched some of them, but, yeah. If Amber Heard is accepted, how will judges know the lies? The judges are going to have access to the complete trial transcript and record. So, yeah. We need to get Rob to 200K subscribers. I agree with this 150%, and he will. Runkle needs an emotional support scythe. I can't argue with that. But okay, but if we name the fluffy, cute teddy bear Kukri, I might have to do a grift stream of, like, let's name the teddy bear. That might have to happen. I don't know. I have to decide. Maybe I'll put that as like a poll for members. Maybe I'll throw that out as a members option. Heather Mills and McCartney, Louise Baker and Charlie Chaplin, Gonzo litigation, Depp v. Heard. Yep, past precedent. You know, Ian, don't appreciate being your ex. Yeah, that is not a thing, but it's funny. So, Ellie QOD, I read some of the documents that were released, and I didn't see anything wrong with almost any of it. Yeah. What is it? Yeah, I should note, I don't talk about my exes on this because talking about your exes, like, it's not a fair forum for that, even if I was going to say true things. So I don't want to do that. Family IT dude, be careful about asking the internet to name something. I would put limits on it. It would not be a strict poll because we're not naming the bear Barry McBareface. She played herself on Zombieland. Watch the movie to see why that's so funny. It is highly entertaining. She played herself in The Stand too. Very convincing. I haven't seen The Stand. Maybe I should. All right. See anime archetype Hia Kasudere for this kind of relationship. Anime has so many archetypes, and I don't watch anime. Different flavors exhibited by Horo, Spice and Wolf, Takagi-san, Nagatoro-san. I watch a very little bit of anime. I like Cowboy Bebop. I like a few other things. Planets, but I haven't seen anything. Chat. Yeah. Runkle and Lumber, thanks for covering. We needed some logical, friendly, productive discussion after the holidays. You guys are the best. Thank you. One of the things I really like about having gotten into doing the YouTube thing is that I get to do these live streams with people I like. And, yeah. I see House Hippo lol, but very on point for Ian. I missed the chat that was about. The name ought to be a bit more kid-friendly with it being the children's hospital and all. Yes, I feel like that is seeing things like Teddy Bundy Bear. Maybe I will name the bear. That is probably the the better way to go. All right, moving on here. Carla Nault, friends fought. He went outside to calm down. RCMP showed up, said if they came back, someone would be arrested, and it'd be him. Ian Strathcona has men's shelter. Okay, that's good to know. Also, I'm PR and never known media to run a PR article. I have known media to run PR articles. I have spoken to journalists who have told me, in one case, I called a journalist to go, hey, what the heck? And the journalist told me that the article hadn't been written by them. So it does happen. Dragon Star, thank you very much. Most BPD are, and Karauri, most BPD are people who are hurt on a traumatic emotional level as kids. It's to protect themselves that they morph to everyone around them. Her behavior is way more histrionic personality disorder. I'm not going to diagnose her, but yeah, the others, I mean, she's got diagnoses. So Ma Esther Toledo, where can I start with Discworld? I started with the first book, largely by accident. I just found it at a library and it happened that it was the first book. I think that if you Google online, there is like a recommended reading order. So yeah. Where is Douglas? Douglas is asleep, both of them. So yeah. Objection. Amber Heard is not Gonzo. JD is more closely affiliated with Gonzo, a la Hunter S. Thompson. She is stratospheric. Fair point. Truffle Hound, thank you very much. I'm reminded on an old Australian saying, you cannot polish a herd, but you can roll it in glitter. I love that saying. 'Twas just a regular tweet even. Thank you, 4C Process. Beats Kill Bean. Didn't she adopt the headline when she tweeted it out and added, today I published this? I mean, that is what it was open for the jury to conclude, and clearly they seem to have. So the stupid gave Rob a retroactive headache. Nice. We see Canadian Center for Men and Families has many resources. Maybe things are changing. I know a while back it was pretty bad. Whole flow chart for Discworld. I started with The Last Continent. Yeah. One of these days I want to find a good set of Discworld books that I'm capable of rebinding and try to make an entire Discworld set of leather-bound books. If I can do that, then that would make me so happy. If you just search for Discworld reading order, you'll find visual guides on it even. Awesome. Yeah, one of my grand hopes would be to make that. Rob needs a unicorn in a bee's costume. Somebody's going to make that and send it to Rob. English common law works kind of similar to American law. If you tell the effing truth, weirdly, you didn't tell the truth to the UK judge who relied on your lies for their judgment. You utter pinecone. Pinecone is a great insult there. Are you okay? Color of Magic is where to start. It's just where I happen to start, and I happen to start because I literally picked it up at a tiny library. Like a tiny out-of-the-wall little library, and it just happened to be there, and I read it, and I went, I need more of this. Please tell me he wrote more. And he wrote more, so that was good. Does Virginia video appellate courts? I don't know. I don't think so, but I don't know. Boppet, snacks for the pups. I will make sure they get some snacks, but they're sleeping right now. Galadris, off topic, what is needed to apply for D&D group? If you mean with Prototopics, join his Discord. I think you can find the link on his Twitter, and he can hook you up. He's doing some stuff that is like D&D one-shots with random people. If you mean what is needed to get into D&D in general, I've got a video on this on my second channel, Roll of Law. So check that out, because it's my second channel. I'm trying to get it up to monetization, which is going to take a while, but yeah. Mary Davis, thanks for being an awesome and helpful leather nerd Logoless elf. I appreciate the advice on Cardinal Bird. Oh, Twitter. That's what that is. That's the bird image. Well, thank you. I'm yeah, if you're trying to get into leatherwork, I'm always happy to offer some advice on that because yeah, it's yeah, I see somebody saying Discworld consists of many multiple storylines set in the same world. You can start with any of them. Unless you're a big fantasy nerd, don't start with Color of Magic. The other books are much better. Color of Magic is basically from when Pratchett thought he was going to be writing fantasy stories, right? And fantasy stories, he wrote a good fantasy story. It's a perfectly serviceable fantasy story. But he also does a lot of funny footnotes in it. And later the funny became his goal and the story was kind of the secondary thing, but he writes really good stories that are hilarious. I don't really know how to describe it other than just amazing. See, what without rule of law, isn't that a prepperism? No, my new channel is just roll, ROLL, of law. And it's geekery. I don't have a prepper channel. Bear, Feagle the Friendly Bear, roll for charisma. That's not a bad idea, but also, Rob, go to sleep. Sleep. Yeah. Oh, and I think last one, lol X, meaning example. Tonight, I'm a joke. Okay, fair enough. He doesn't want to be the example in that I was using his name. So, because I was using Joe as my example a lot of the time. I've got a few names that I kind of throw out every once in a while. Trufflehound says, I vote for Mort the Bear. I can't use Mort the Bear because Mort is already the skull. The skull is Mort. So I need a new name because they can't all be Mort. I can't just name everything Mort. Maybe I could, but yeah. Galadriss, Rob, go to sleep. I don't want to stun you. Yeah. And it's Roll of Law, subscribe. Thank you very much. Yes, Roll of Law is the second channel. And Mary Jane, Ian telling Rob to sleep. He's 2 hours ahead of me. It's way later for him. I'm awake at the reasonable hour of midnight. And he's, and he's probably going to wake up at a sensible time, whereas I'm going to wake up at, at dumb times. So I see, I just got here. What are we naming the bear? I'll probably do like a bear naming stream or a bear thing. Ishkate, Ian didn't get my chat. Oh, well. Let me see if I can search for it. Hey, it's showing up as highlighted. That's interesting. I'm only seeing one match. I'm sorry. I missed it. My bad. Sorry about that. Yeah. And I see oh, if it was a member chat, it won't. Do they really hide member chats on StreamYard? I will. Oh, that makes me unhappy. Oh, so unhappy. Trying to scroll back up on the YouTubes, and it's too far. It is too far for me to find. I'm sorry, Ishkade. I will try to find that. Oh, it was a member chat about it being Ishkade's birthday. Happy birthday, Ishkade. I am sorry. That's a crappy birthday present for me to miss that chat. I am sorry. Happy birthday. I still got some scotch in my glass here. To many more birthdays, because we all get a number. We don't know how many we get, and hopefully they're all... hopefully each one is better than the last. By and large, with some hiccups, my birthdays have been getting better. So I've got one coming up, but I hope your birthday is better than the last one. And I hope that the one after that continues to be better. To many more birthdays. And yeah, so happy birthday. All right, so I see Ollie from the Stollery as a suggestion there. But I missed your member. I'm looking in StreamYard, so I'm not seeing the member chats. I have got to yell at StreamYard. Or I've got to figure out a way to catch the member chats, because I am really sorry I'm not seeing them. StreamYard is bad. Malort would be it's a good bear. This is a good friendly bear. We're not naming the bear Malort or Surströmming because those are mean things. And yeah. All right, I'm going to wrap this up because it is just ticked over to midnight. I'm going to, sorry to the folks in the chat who sent in member chats. StreamYard seems to filter those out. I'm going to try to find a solution to make sure I see those because those are important. Yeah. All right. Yeah, I see they don't show them to me. StreamYard needs to... I got to find like a way to send StreamYard a message and go, what the hell? Because, yeah. I see name the bear Charity because it was... Charity sounds like the bear is a stripper. Maybe if I get the bear like a pole, I feel like the Stollery would be upset if I got the bear a pole. I'll think about it. Anyway, good night, everyone. What a thing to end on.